and for supporting this initiative on creating a guidebook on the Evidence Act, which I think is a great contribution to the Maldives. Secondly, to the Prosecutor General's Office for hosting me and giving me the opportunity, which I've spent the last week, to work with so many prosecutors in our city. We had many great discussions. I learned an awful lot, not just about the Maldives Evidence Act from those discussions, but also about my own evidence law. It's an advantage of this kind of conversation that you learn much more about the differences and nuances of your own law when you compare it to another law. And as well, I'm incredibly honoured to receive an honorary appointment to the Academy and to be involved in this first event for the Academy, and particularly grateful to Director for everything he has organised about this. So thank you very much. And finally, I'm also grateful for you, to all of you, for coming here today. As I understand, it's the last day before a long weekend, and the temptation might be to find other things to do in the coming days. So thank you very much. And I'm also excited to be here in Mali, including for the National Day. I will now start, and just again to outline what I hope to cover today. I will not be covering all of the Evidence Act. That would take many days to cover in that detail, but I hope to cover some of its main features. In the morning, I will be looking at part of the origins of the Maldivian Evidence Act in Australia. So I'll start with a little bit of history and then be looking at the structure of the Act. And when I've been speaking to people about the Act, many of the main questions I've got from practitioners and magistrates have been about the new provisions on examination of witnesses. So I'll also be covering that in the morning session. In the afternoon, I will be looking at the main exclusionary rules, as we call them in Australia. They're rules of evidence in the Maldivian Evidence Act, the hearsay opinion, tendency, coincidence and credibility rules, many of which have similarities, although some contrast with Australia. And in that afternoon session, I will be running through those provisions, but also exploring a scenario. I'm a big fan of not just talking about evidence law in the abstract. Sometimes it can make a lot of sense in the abstract, but the moment you try to apply it to a real situation, it suddenly stops making sense. So I want to explore that. So I will use a scenario from Australia, but I understand it's one that has got international attention. It's a recent murder prosecution that concluded just 2 weeks ago of a person in Australia who was accused of poisoning the guests at a lunch party with death cap mushrooms. So that's the scenario I will discuss, amongst other examples, in the afternoon. All right, and I should also say I know that everyone has lots of questions about how the Maldives Evidence Act works, so I'm very happy to receive those questions, and my intention is to stop at times and open for questions. That doesn't mean you're obliged to ask, but please feel free to do so at that point, and I'll do my best. All right, so I do have a number of slides to show you that I've prepared. I don't usually use slides when I teach my students. I'm a bit of an outsider on that particular issue, but the purpose of these slides is not to contain everything I'm going to say. I will be speaking about many things, but to serve two purposes. One is to remind me so I don't forget of some of the things I want to say, and secondly, so you have something to look at rather than just looking at me the whole time. So that is the purpose of the slides. The initial slides are going to have maps in them because I'm doing a short history lesson and then some quotes, but I should warn you that, and this may either disappoint you or delight you, that the majority of the slides are going to be excerpts from the Maldivian Evidence Act and some comparisons with Australian evidence law. We will be spending a lot of time looking at statutory provisions. All right, I've tried to include some pictures in the afternoon session to break that up a bit. All right, so the first thing I wanted to discuss in the first session, I guess, for this morning, is to look at the Australian origins of part of the Maldives Evidence Act. There's more to the Maldives Evidence Act than just the Australian origins, but that is what I wanted to focus on here. So it's a little bit of a history lesson about the spread of Australia's uniform evidence law. All right, so this is where we get to maps, and I've managed to get Google to draw me a map which includes Australia, but also just in the corner the Maldives is there, although I couldn't convince Google to put the name Maldives on the screen, but you all know where it is. But actually where I want to start the story is where this arrow is pointing. I don't know if you can see my cursor there, but anyway, there's an arrow, a blue arrow, and it's pointing to a little bit of Australia. Australia is a large country. It's either, and I'm going to talk about islands a lot. Let me say in passing that a few years ago I wrote a book chapter called The Uniform Evidence Law in the Islands, which made the argument that islands are important to Australia's uniform evidence law. Australia is either, depending on who you ask, the world's biggest island or the world's smallest continent, and it's a complex place in that it's a federation. So there are 6 states and a number of territories, and the arrow is pointing to a little territory in Australia. It's the Australian Capital Territory, which contains the capital city, Canberra. So it's the equivalent of, say, the District of Columbia in the United States. And by coincidence, Director Ahmed Nafo and I are both graduates of the Australian National University, which is based in Canberra. We both studied law there. But this story actually starts many decades ago in the 1970s, when the little territory of the Australian Capital Territory didn't have a government of its own. It was being run by bureaucrats in the Australian government. And this is a slight similarity to the Maldives. At the time, it didn't have an evidence law of its own. It just had, as the Maldives did until 2022, a small number of provisions that were local, plus the courts having a practice of referring to neighbouring jurisdictions or other jurisdictions to fill out the rest of evidence law. And in the 1970s, some bureaucrat in Canberra decided that that wasn't appropriate and that the ACT, the Australian Capital Territory, known as the ACT, needed its own evidence law. And so they just wrote it down. No one knows where it came from. I'm sure someone does, but I don't know where it came from, but chances are it was one person writing down a bunch of sections. And they simply announced that would be the new evidence law for the Australian Capital Territory. It's not like the Maldives Evidence Act or the Australian Uniform Evidence Law. It did not purport to be a comprehensive law. Rather, it's like the Evidence Acts of most of the world, which aren't comprehensive, detailed schemes for dealing with evidence, but rather just a hodgepodge, a collection of provisions that have been taken and written down just to put them all in one place. That was the idea. And if that had proceeded as expected, I wouldn't be here today and the Maldives Evidence Act would look quite different, because something unusual happened in the 1970s, which is that the members of the Australian Parliament objected to this law being written by a bureaucrat in a government department, and their objection is an interesting one. The government department had said evidence law is just technical machinery provisions, just boring rules that you have to write down somewhere but aren't all that interesting or important, and it's just useful to have them in one spot. And members of the Australian Parliament objected and said that's not true. Maybe some of them were lawyers, I'm not sure. They said evidence law is actually one of the most important areas of law, and this is something I also believe, that it goes to fundamental issues of fairness, about the ability of the legal system to get correct answers, about the impact of the legal system on countless people, parties, witnesses, victims of crime, civil plaintiffs and defendants. They are all deeply affected by the law of evidence, and it's important to get it right. And it is not an appropriate thing to simply be written down by a bureaucrat somewhere and imposed on the population of the Australian Capital Territory, which at the time had 150,000 people and now is close to 500,000 people. Not all that far from the population of the present Maldives. So that objection, which was new in Australia and had not been raised before, and it was not common around the world either, caused a bit of a panic, I guess, or passes for a panic in this particular little area. And the Australian government decided that rather than objecting and just passing the law anyway, they would find a way to answer this objection. And their answer was to go to the Australian Law Reform Commission a body of lawyers and judges and ex-judges and researchers, which was just at the time finding its feet as a major driver of the development of laws in Australia. And so it took a while, but in the 1980s, the Australian Law Reform Commission was asked to develop an evidence law, initially just for the Australian Capital Territory, but the Law Reform Commission had ambitions. It wanted to be a more important body. It decided maybe they would create an evidence law for all of Australia and maybe a model for elsewhere. And so that's the origin of the Australian Uniform Evidence Law. The Law Reform Commission worked for years, and they set themselves a very difficult task. It's not easy to write down a comprehensive new scheme of evidence law rather than just copying existing provisions. Of course, they did a bit of copying. They had one option at the time. At the time, there was a competing, as you would all be well aware, comprehensive evidence law scheme that had been in place for 100 years from India, from the Indian Evidence Act. And in fact, I was surprised to discover a few years ago that the Indian Evidence Act actually applied briefly in a very small part of Australia, and it was applying at the time of this discussion. On the left side of the screen, I've got a couple of arrows pointing to tiny dots, little islands in the Indian Ocean, the Cocos and Christmas Islands. Christmas Islands is somewhat well known in Australia, but as a place to house potential immigrants. But they've got a very tiny, a population of about 2,500 people now. And they had formerly been run by Singapore until just after the end of World War II. And although they were handed over to Australia or became Australian responsibility in 1950, they kept their existing laws that they had from the Singapore time, and that included the Singapore Evidence Act, which is based on the Indian Evidence Act. So Australia once, a little portion of it had the Indian Evidence Act. I'm a little sorry to say, though, that the Australian Law Reform Commission wasn't interested in the Indian Evidence Act for whatever reason. I could speculate, but I don't know. And instead of looking to the Indian Ocean, they looked east to the Pacific Ocean and across the Pacific Ocean to the United States. And in the 1970s, the United States had started a process of formalising various rules of evidence. They're again a complex country with many different jurisdictions, but there was, since 1975, the Federal Rules of Evidence, a collaboration between the United States Supreme Court, the United States Congress, and an awful lot of evidence law academics had been in place in the United States. And that is the main place that the Australian Law Reform Commission drew its inspiration from. And you can see a lot of links, if you look at the Federal Rules of Evidence, between the Australian Uniform Evidence Law and the Federal Rules of Evidence and some of the provisions of Maldivian Evidence Law that have now been picked up, and the Federal Rules of Evidence. That being said, Australia did not copy the Federal Rules of Evidence, but nevertheless used that as a starting point. And the Law Reform Commission saw its role as bringing together modern ideas of psychology, philosophy, and process and fairness, even some modern terminology, to create an Australian evidence law. And in 1987, they published a draft evidence law statute for Australia. All right, my next slide is going to turn in an unusual direction because the story doesn't continue on this slide. Australia, as you would know, is between the Pacific Ocean to the east, the Southern Ocean to the south, and the Indian Ocean to the west, as well as Indonesia to the north. But the story continues in the Atlantic Ocean. All right, so here is the Caribbean, the islands of the Caribbean, which is just off the coast of Mexico and the United States and Venezuela. And it's a chain of islands, but although there was at times the idea that they would amalgamate into a single nation of the West Indies, and they did for a couple of years, it remains a series of independent nations. And in 1994, Barbados became the first country in the world to adopt Australia's Uniform Evidence Law. They adopted it before Australia did. This was not well known in Australia. I only learnt about it when someone wrote to me from Barbados asking for a copy of my Australian evidence law textbook, and I wrote back saying, "Why do you want it?" And they said, "Because we have your law." So I've never met anyone else in Australia who was aware of this until I started talking about it then. And I went to Barbados a few years ago because I was very curious about how Barbados came to adopt Australia's evidence law, and I'm sorry just to say I never found the answer. The parliamentary discussion in Barbados only briefly mentioned a connection to Australia and claimed in all manner of other connections, including what appears to be an incorrect claim that the law they adopted had been drafted by the Commonwealth of Nations. I think they were confused with different provisions when they talked about that. So I don't know why it was adopted in Barbados. If I had to guess, it's a collaboration a little bit like the one I'm involved in here, that someone from Australia went over to Barbados, or someone from Barbados went to Australia, and there was some sort of connection. And when Barbados was looking to have its own evidence law, because they were in the same predicament that the Australian Capital Territory was in and that the Maldives was in a few years ago, they decided it would be good to copy the draft of the Australian Law Reform Commission. So Barbados enacted that draft law, and it spread a little bit in the Caribbean. So 8 years after Barbados adopted Australia's Uniform Evidence Law, St Lucia also adopted Australia's Uniform Evidence Law. I looked at their parliamentary records, and the St Lucia parliamentary records insisted that this was a locally developed law in St Lucia. They didn't even mention that there was a copy of Barbados, let alone of Australia, although that is, of course, a well-known fact in St Lucia now. So they have Australia's Uniform Evidence Law. And then in subsequent years, it spread to two further parts of the Antilles, I think that's how you pronounce it, part of the Caribbean. So in 2006, the British Virgin Islands adopted Australia's Uniform Evidence Law, and the British Virgin Islands aren't a nation. They're an external territory of Britain. So the Australian Uniform Evidence Law has been partly adopted in Britain, in a country that uses the US currency as its currency. And then finally, the last of these moves was in St Kitts and Nevis in 2010. So that's 4 nations on the other side of the world in the Atlantic Ocean which adopted Australia's Uniform Evidence Law. So now let's go back to this side of the world. But I will return to the Barbados experience in a bit, because that means a lot of nations have gone through what the Maldives is, well, what this niche segment of the professional part of the Maldives is going through in adopting a new Evidence Act. So the story continues back in, of course, Australia and its region. In 1995, two Australian jurisdictions adopted the Australian Law Reform Commission's draft, but with modifications. And so although Barbados adopted the draft in its totality, the actual version in Australia is a little bit different in some respects. The two jurisdictions are firstly the Federal Courts of Australia, so that covers the whole of the continent, but importantly the Federal Courts mostly don't hear criminal cases, so it wasn't such a significant development because of it, as you would all be aware. Although evidence law is important in civil cases, it is much more important in criminal cases. But the other adoption in 1995 was the largest population state in Australia, New South Wales in the southeast corner, and so that was a major development and signalled a rosy future for the law. It took a while. In 2001, Tasmania, the island at the bottom of Australia, itself a state, adopted the law. And then in 2008, my own home state of Victoria, which includes the city of Melbourne, where I live, joined the scheme, and that meant that for the first time the majority of Australia's population, but not its area, was part of the scheme. And then, I should mention, in 2004, a small external territory in the Pacific, Norfolk Island, adopted the law. They now no longer have a government of their own, they did at the time, but they still have Australia's evidence law, even though they are otherwise run by a jurisdiction that has not adopted it, Queensland. In 2011, both internal territories, including the Northern Territory, a very large territory in area, but small but important in population, adopted the law. And that's where it all stopped in Australia for a while. But there were two further developments, and on the map I have shown New Zealand in the bottom right corner and the Solomon Islands in the top right corner. So New Zealand, a neighbouring country to Australia and with many similarities, decided, having looked at what Australia did, that it would also adopt its own Evidence Act. But being an independent nation, like the Maldives, it didn't just copy Australia's Evidence Act, it looked to it for some inspiration, but devised its own law. And in fact, in developing its law, it was a hybrid law, and it's a term I'll use a few times today. It's a combination of the Australian provisions and draft Canadian provisions, which were never adopted in Canada, but were nevertheless a popular model. So New Zealand is a hybrid of Australia and Canada, and that was adopted in 2006. In 2009, the Solomon Islands, a very different country, and one with at least one important similarity to the Maldives that I'll get to, decided to have the same process. It drafted its own law, and I don't know the origins of that, but when you look at the law, it is a combination of Australia and New Zealand, again, a hybrid model. All right, and then, as you of course all know, in 2022, starting in 2023, the Maldives decided to have the same process and initially drafted a model based on the Indian Evidence Act, but what the Maldives has now is in part a hybrid between the Indian Evidence Act and the Australian Uniform Evidence Law. I'll just finish the story by briefly mentioning those two little islands in the Indian Ocean that briefly had the Indian Evidence Act themselves, the Cocos and Christmas Islands. In 1992, they stopped having the Indian Evidence Act. They didn't acquire the Australian Uniform Evidence Law, though, because they were governed by Western Australian law. That's the biggest state in Australia on the left side of the continent. And so they followed the old common law approach. And they still do right now, but there's one final development to mention. In the coming months, Western Australia will be the latest jurisdiction to join the Australian Uniform Evidence Law. It will be the 15th, on my count, jurisdiction to adopt all or some of the Australian provisions, with Maldives being the 14th. All right, so that's my history lesson, but could I note a couple of things that unite all these countries, although there are many divisions as well. One, it's worth mentioning that all of these jurisdictions and countries are members of the Commonwealth of Nations, although I understand with the Maldives that isn't consistently the case, but is currently the case. So I've got the latest good. So there's one commonality. On the other hand, notice that this is very much a global law. The law has been adopted in an island in the Southern Ocean, Tasmania, islands in the Pacific Ocean, Norfolk Island, the Solomon Islands, New Zealand, I guess, perhaps Australia. Islands in the Indian Ocean now, and the Maldives was the first, although the Western Australia is also bordering the Indian Ocean. And the Atlantic Ocean. It's the only evidence law scheme, as far as I'm aware, to be in all four oceans of the world. I think it's probably the second most successful modern statutory evidence law scheme after the Indian Evidence Act. Which has, of course, been around for much longer and governs a much greater number of people. Although there are 15 nations that now apply some or all of Australia's Uniform Evidence Law, the population total is not particularly big by world standards. All right, but nevertheless, that's the scheme that has been adopted. Could I mention as well a couple of smaller groupings? So, as I said, the Maldives is one of the three countries which have a hybrid law, combining the Australian law with other nations. I think there is another important link or grouping, which is between the Maldives and the Solomon Islands, very different countries in many respects. But the important feature they have, which I will talk about quite a bit today, is they are the only two of all the adopting jurisdictions which don't have juries. And the Australian evidence law was very much developed, as is most parts of Australian law, with procedural law, with juries in mind. Australia has a jury system. It's 12 in Australia, and in many other countries in the Caribbean, it's juries of 7 or 9. And they are very much the focus of discussions of evidence law, even though the vast majority of trials everywhere in those jurisdictions are not held by juries, but rather by judges. Nearly all civil cases, the vast majority of criminal cases are decided without a jury by judges, either because they are minor or because, for various reasons, including the pandemic, judges were used instead of juries at times. So, although the paradigm, these laws are designed to apply in both settings. And in the Solomon Islands and the Maldives, the intention is that they work in a non-jury system. All right, so that's the history lesson. But history aside, what is important about this particular background is that there are many different jurisdictions that have gone through the process that the Maldives is currently going through. It's a process of going from not having much of an evidence law to suddenly having 200 or something sections of evidence law that you suddenly have to get on top of and apply. It is quite an experience. I've personally been through it twice. When I studied law at the Australian National University in the 80s and 90s, there was no Australian Uniform Evidence Law, and my teacher at the time never mentioned it, even though it had been much, it was progressing through the Parliament at that point. But when I started teaching for the first time in Sydney in Australia in 2000, the Uniform Evidence Law had been in place for 5 years at the time. And so I suddenly had to learn a new area of law, but at the time the real problem we had was there were very few cases. So we were looking at a statute, we were debating the meaning of the statute, but there were only a handful of cases on the new statute. It had been in place and been applied for 5 years, but as you would all be well aware, evidence law issues are often more a fact of life in practice, in day-to-day experience, than they are the subject matter of lots of decided cases. And so we were all desperate for cases. And I remember sitting around with colleagues where we were talking, I think, to some Canadians who had had a similar experience with their Charter of Human Rights, and we said, you know what, we are envious of you. You have so many cases to talk about. And they said, you have no idea what's coming. What seemed like a trickle at first would eventually become a flood. And we would be overwhelmed with decisions, is what he predicted, and we couldn't believe it. But the truth is he was right. And now, 30 years after the start of the Act, we have thousands of decisions and hundreds I would regard as key and important decisions in Australia that we all have to be on top of, as well as being on top of those provisions. Based on that experience, and I realise, of course, that isn't necessarily a transferable experience, perhaps something similar will happen in the Maldives. That is, at the present moment, where there are hardly any cases, that is something you'll look back on with as a distant memory sometime in the next couple of decades, where a seminar like this could not be done without detailed reference to cases. All right, so that's the first experience I wanted to mention, is just that change. The second experience, and sorry, I should also say that I then moved to Melbourne. And so I moved back away from an Australian Uniform Evidence Law jurisdiction, instead to a jurisdiction which, again, used the old system. And so for a few years in Victoria, I taught the older system, but then it was announced that Victoria would join the scheme. And at that point, I knew more about the scheme, and so I sat with groups of people in Victoria as we debated what was going to happen. I sat with judges and with prosecutors and with defence lawyers, and we talked about it, and many of those lawyers said, we don't like this idea of having a written down law. We are used to doing things the way we do it. We learn it by practice. You pick it up on the job. You get used to it. And the problem with writing it all down is suddenly you now have to keep referring to written rules, and they may not be good rules. At the time, I told them, you know what, you're going to get away with ignoring the Act for quite a while, because everyone is used to the old scheme and everyone's instinct is to keep following the old law. They know about the new laws. That was my experience in Australia, but that doesn't mean they always apply them. They don't always look them up. No one in the room raises them. And even when the laws are looked at, everyone reads them with historical glasses in mind. They treat the new rules, they assume the new rules are just like the old experience they had. And so that was the initial experience that I'd experienced in New South Wales, and again it happens in Victoria. So again, based on that prediction, I would suggest that it's going to take a while for your reference point, your first reference point, to be the new Act, because everyone around you will be more familiar with the older law and will make assumptions about it. It's an understandable impulse, but it eventually becomes a dangerous impulse because new statutes are never the same and are not intended to be the same as the old law. Let me show you, I have an example to present of this experience where you can see it in writing. And the example is actually from Barbados, which of course also introduced Australia's evidence law now over 3 decades ago. They introduced it in 1994. Here's a quote from 2002, 8 years after the adoption of a new Evidence Act in Barbados, from the Chief Justice of Barbados, not just some disgruntled lawyer or rogue judge. And in fact, this Chief Justice was previously the Attorney General of Barbados at the time the Uniform Evidence Law was adopted. And he made it clear in 2002 that he hated the new Act. He said, "The Evidence Act is in some parts a very difficult piece of legislation to comprehend. In other parts there are errors. In still other parts, it seems as though some unusual burdens are now put upon trial judges that the legislation has become a virtual minefield. It cries out for urgent amendment." And I must say, although I'm a fan of the Maldivian Evidence Act, I think the same thing could be said about the Maldivian Evidence Act. And I suspect many of you, or the judges that you deal with, or others, are going to say similar things about the Maldivian Evidence Act. It's an easy thing to hate a new evidence statute. It happened in Barbados, and it absolutely happened in Australia as well. There was a time, and it was even more than 8 years, more like 15 years after Australia got the Uniform Evidence Law, that judges in the top court of Australia, which is confusingly called the High Court of Australia, but it's the equivalent of a Supreme Court elsewhere, would routinely criticise the Uniform Evidence Law. That included Australia's then most prominent evidence law scholar, Justice Dyson Hayden, who is the author of the Australian version of Cross on Evidence. He routinely condemned the Australian Uniform Evidence Law as poorly thought out, poorly drafted and so on, and causing more trouble than it was worth. He was a fan of the Indian Evidence Act, and he routinely complained that Australia reinvented the wheel rather than using an established century-old statute. Whether he was just saying that as a way to be antagonistic is another question. He's a difficult man. So there, again, based on this prediction, again, it's just a prediction, it might not follow in the Maldives, there are going to be complaints about the Maldivian Evidence Act, and not just in the next couple of months or year, but in the next couple of decades. All right? In the textbook I co-author on Australia's Uniform Evidence Law, in the early editions, in the early years, in fact, until the most recent edition, I would routinely point out that there were all these criticisms, but I would also point out that the thing about all these critics is they are all people who trained under the previous system. And my prediction in the earlier editions of that textbook was that maybe this will change when a new generation reaches the bench. All right, so I'll talk about that a little more. Let me talk also about, so at least Australia, when they adopted the Uniform Evidence Law, they adopted their own law, drafted by their own people. Barbados, on the other hand, adopted a foreign law, which in part the Maldives has done as well. And the Barbados courts weren't happy with that either. As I said, Barbados, although Australians were completely unaware that Barbados had adopted the new Australian law, Barbados was aware that they had adopted Australian law, and they were the lawyers there realised, and trying to find cases which were otherwise lacking in Barbados, which is a small jurisdiction, again, I think roughly the population of the Maldives again, they looked to Australia. And the Barbados courts were unhappy with Barbados lawyers looking to Australia. So in 2003, 9 years after the adoption of the Uniform Evidence Law in Barbados, the Court of Appeal said, decisions of the High Court of Australia do not bind this court. They are merely persuasive, and although we pay them the greatest respect, we are free to choose whatever common law precedents will produce fairness and justice in consonance with our circumstances. Apologies for the typos here. Now, of course, this is completely correct, and it is also true, obviously, in the Maldives. Decisions in Australia do not bind the courts of the Maldives. They are merely persuasive. Whether they needed to be paid the greatest respect, I don't know. But the Maldives courts are going to chart, and rightly should be charting their own course. So I'm not surprised, and in fact agree with this sentiment. But an interesting thing happened in Barbados. We fast forward, and we are nearing the end of my history lesson, to the Caribbean Court of Justice. Now this is not a Barbados court, it's a supranational court. It hears appeals from a number of Caribbean jurisdictions. Was a court created as an alternative to the Privy Council, which was otherwise hearing appeals from those jurisdictions. Sadly, one of the reasons for this is the Privy Council was too opposed to the death penalty, and the Caribbean countries wanted a more death penalty-friendly court, so the Caribbean Court of Justice was it. But here is the thing. The Caribbean Court of Justice disagreed with the Barbados courts. They liked the Barbados Evidence Act. In 2015, in an appeal from a Barbados death penalty case, they said the Act was passed, this is the Barbados Act, in order to reform the law relating to evidence in proceedings in courts. To this end, in several respects, the Act applies standards that are more stringent than the common law, the previous law, compels the judiciary to be guided by fresh approaches, and requires the executive to make available to the police new technologies. And a particular issue in Barbados was a requirement for recording police interviews. The Act lays down rules of evidence to meet modern social standards and the citizenry sense of what is fair. And that is a bit of a rebuttal to Barbados, which said it's the judges who decide what is fair. The Caribbean Court of Justice said no, it's the Act that decides what is fair, and it might have a sense of fairness which differs from the judges, and in that situation, the court must follow the Act. And again, I think that is a correct statement and also applies in the Maldives. Judges in the Maldives are no longer as free to do what they think is just if it conflicts with what the Maldivian Evidence Act says, and that was the statement, a similar statement in the Caribbean Court of Justice. And the Caribbean Court of Justice also disagreed somewhat with Barbados on whether or not Australian precedents could be, how they would be dealt with in Barbados. They said, of course, the courts of Barbados are not obliged to follow the common law of Australia, and of course that is correct. But they said the nexus is that the Act that was passed in Barbados modelled itself upon the draft evidence bill introduced in Australia. In expressing our position, we are not so much adopting the views of any judge of Australia as we are complying with the specific provisions of current statute law of Barbados. And the argument of the Caribbean Court of Justice is if Barbados has decided to pick up some or all provisions from Australia, then they are also picking up some of the way that those laws are interpreted in Australia. It's a difficult position, and I'm not sure it's true in the case of Barbados because they adopted it in 1994 before there were any Australian provisions on the new law. But it is perhaps more of an argument in the Maldives, which is coming later to the process and is adopting provisions that have, a number of provisions, that have already been the subject of Australian decisions. And at least in an Australian context, that would be a reason to say that maybe the Parliament intended not only to adopt the words of Australia's parliaments, but also the rulings of Australia's courts. It is absolutely not a compulsory approach, but it is a stronger approach than merely regarding the Australian authorities as merely persuasive. It might be a little more than that, but of course everyone in this room would know that all of that is subject to relevant differences of all sorts between the provisions, the systems and so on. So I'm not here for a second to say that Australian decisions have a massive import in Australia. For what it's worth though, the Caribbean Court of Justice firmly ruled the Barbados courts had to follow a particular precedent in Australia that the Barbados courts had rejected because Barbados had adopted Australian evidence law. It's a complex ruling, I'm not sure I entirely agree with all of it, but that was the ruling. So this is 2015, 21 years after the adoption, and somewhat reluctantly, the Caribbeans are coming around to the idea that they must move on from their old approaches because of the decision of the Barbados Parliament. So again, if I had to use this to make a prediction, it might be, noting a lot of potential differences, that perhaps in 2 decades, the Maldives will also start looking primarily to its new statute, regarding it as the source of justice when it comes to evidence law in the Maldives, and looking a little more, not necessarily hugely, to the other 14 jurisdictions that have partly adopted Australia or wholly adopted Australia's Uniform Evidence Law as guidance on how to apply some of those common provisions. All right, so that's my history lesson. I think that gets us to a slight end of the first session, but I'm now going to be moving on to looking at the specifics of the law. But I just wanted to reflect that this is going to be a difficult experience for everyone to move from the old system with, I think, Nafal, you told me it was a one-page or two-page Evidence Act, albeit with a lot of other provisions in place, to this much longer statute. It is not something, despite the efforts of I think the guidebook is a fantastic idea and the training is also fantastic, but the reality is it's going to take not just years, but maybe decades before the Maldivian Evidence Act becomes the starting point and the central part of this aspect of justice in the Maldives. Maybe I'll be wrong and it will happen quicker, but that would be my prediction based on effectively the other 13 jurisdictions. And I should add, this is still happening in Australia. So Western Australia next month will adopt the new the Australian evidence law, and that means millions of people, but in particular thousands of lawyers in Western Australia will go through the same process that the Maldives is also facing. All right. Just check where we are timing-wise. So yeah, I think we're now at the end of the first session. I'm not sure this is something where you'd have questions necessarily, but if anyone does have a question on this history lesson, I'm happy to take it, but otherwise I will move on to the details of the Maldivian Evidence Act and its comparison with Australia. Yes?
Yeah, thank you. I would just like to know, to what extent have you followed the Australian law?
So this is a good question, and it's a little complex. I think when Nafal first contacted me, he said the Maldives has adopted Australia's evidence law, and I thought, oh, maybe it's adopted it to a big extent, but looking at it's a little more complex. So I think I should say first is that none of these statutes, the 15 statutes, are uniform. They are all different from each other in some respects. And so although it's called the Uniform Evidence Law, it's a uniform origin. And even within Australia, there are small and in some cases big differences between the various statutes. So it is common enough that there are differences between statutes, but I think the Maldives, the difference is bigger. And that's because the Maldives is one of those three hybrid jurisdictions which did not adopt the Australian law, but rather used it as a source amongst other things to create a law. And so on my reading, the Maldives law is a mixture of perhaps, 4 sources. One is the Australian Uniform Evidence Law, and I'll get to the details of how many provisions there are that are adopted. 2, the Indian Evidence Act scheme, or perhaps the Malaysian schemes and others that followed it. 3, Sharia. And 4, local drafting and development, local innovation. And so that means that the Maldives law is only partly the product of Australia. And on my initial count, I actually counted 8 provisions that were extremely similar to Australia's and which were obviously taken from Australia. And that's a very small number of the total. That being said, the more I spend time with the Act, the more I can see that there are a number of other provisions, maybe a dozen more, maybe 20 more, that are partly inspired by Australia and are similar enough that they are a common reference point. But by no means is this a situation when you can just pick up an Australian evidence law textbook and walk into a Maldivian courtroom and use that. It wouldn't work. So it is only a partial adoption. And I intend to cover in today's seminar most of the main provisions that are identical and some of those which are inspired. But I will also be pointing out, and every one of my slides will do this, I think, the differences. And so it's a complex thing. You have to be, to do this, is to be aware that it's from Australia, but also aware that there are differences from Australia. So it's a partial adoption. And the same also applies to the Indian Evidence Act provisions. There's a number that are similar to the Indian Evidence Act, but we have been looking at them with the prosecutors, and there are differences as well. So again, you would not be able to even pick up Indian evidence law and apply it even in those areas where there are inspired provisions. You would need to keep constantly checking for differences as well. That's a lot of work, and it would be understandable if your approach was to ignore the world outside the Maldives and stick to the statute. But that, at the same time, that means you would get the burden of having to interpret it all on your own without the benefit of developments and case law and the like that might cast light from elsewhere. So that's the balance that needs to be struck. Eventually, the Maldives will have so many cases of its own that there's less need to look overseas, and that has happened as well in places like New Zealand, Solomon Islands, parts of Australia, but that process is a decade or two away. All right. Are there any further questions? That was an excellent question. That's also a good question. The answer is not at all. Not at all, which is unfortunate, I think. It shows the parochialism of Australia and the way Australia tends to look to developed world countries, England and the United States and Canada, much more than it looks to the rest of the world. So I think that reveals more about Australia than it does about anything else. But the Australian Law Reform Commission, barely without even stating why, simply said it wasn't going to follow the Indian Evidence Act model and doesn't follow that model. I mean, in fairness perhaps, and I think this is fair to point out, there are criticisms of the Indian Evidence Act model. It's a very different scheme. It involves a different approach of classification and a different kind of concept of how to do proof. And I think it is fair to say that in a common law country like Australia, it is a little bit unusual. Of course, India has its links to the common law, but they diverged a while ago. So I can see why an Australian jurisdiction would find the Indian Evidence Act too difficult a change to make. On the other hand, the federal rules of evidence in the United States were based on the United States common law, and so there's more familiarity to that. The Maldives, of course, isn't in any of those positions. It is the practitioners here are well familiar with the Indian Evidence Act and the other versions of it across the Indian Ocean. So it's a different choice to be made here. And so Maldives could have just adopted the Indian Evidence Act, and then I wouldn't be here, and you would be learning everything you need to learn from the many hundreds of thousands of practitioners across countries who use the Indian Evidence Act. But perhaps because there are those criticisms of the Indian Evidence Act scheme, that isn't the approach the Maldives took. I think I've heard, and I can't speak to this from personal knowledge, that the original proposal for a Maldives Evidence Act was much closer to the Indian Evidence Act, but through the parliamentary and committee process, it eventually became a hybrid model. I should say that there is a downside to hybrids. The one problem of hybrid models is sometimes the fit is a little awkward. And so in particularly the Solomon Islands and here, and to an extent in some of the jurisdictions in Barbados, which diverged a little from the scheme and adopted some English provisions as well, sometimes you look at the two provisions and you can't see how they were meant to work together. And that will also undoubtedly be true here in the Maldives. And that is on top of a further matter, which I'll only talk about briefly today, which is that all of these statutes, all 15, have a provision that says this act applies unless another act provides for a rule of evidence. And so in every jurisdiction in Australia and elsewhere, you can't just look to your Evidence Act, you have to look to a lot of other statutes to fully understand the process. And that's because none of them are intended to be a code, but rather a starting point, comprehensive spot to look at the law, but allowing for lots of differences in particular areas. So the Maldives has specific rules for sexual offences, it has rules in its Police Act, it has rules in the Criminal Procedure Code and Civil Procedure Code, and the Maldives Evidence Act has to be read in light of those. The same thing is true of all the other jurisdictions, including the Australian ones. Any further questions? Yeah. Thank you for your tolerance. Yeah.
You mentioned that the Australian Uniform Evidence Law was partially inspired by the US federal rules of evidence. How helpful is the FRE?
That's a really good question. So as an evidence law scholar, I perhaps naively thought when the Australian Uniform Evidence Law was adopted that it would move Australia from a system which is the common law system where we always look to Britain for our evidence law precedents, and we would start to look more broadly to places like America, to Canada, and others who had been inspired by modern movements, but particularly ones that have followed parts or all of the federal rules of evidence in the United States. I'm sad to say that this has not happened. The Australian lawyers simply were not used to. They find America a very difficult system to understand. They weren't familiar with it, and they have not used it much. I can give an example of why this can sometimes be difficult, a difficult process. The United States Federal Rules of Evidence were adopted in 1975. Australia's Uniform Evidence Law was planned in the 1980s and adopted in 1995. And a very major decision from the United States, the most important Federal Rules of Evidence decision, was the Daubert decision in 1993, which was about expert evidence, and for the first time the United States Supreme Court said judges shouldn't just assess the qualifications of experts, but also the scientific principles they are applying. I teach a subject on expert evidence law with an American, and we spend a lot of time talking about this. American judges were given a major role of judging science. So that if a forensic witness, for example, turned up and said, I can compare bite marks and work out if it's the same, if this bite mark that fits the teeth of the suspect, the American judge, in Australia, it would just be a question of, are you qualified in bite mark analysis? That would be the only question to be asked, and have you applied it? But in America, they would ask, is bite mark analysis good science or junk science? And in fact, many of you would be aware that there's every reason to think that bite mark analysis is very, very, very poor science. It's led to miscarriages of justice. So that's a long story to say that in 1993, the American Supreme Court, using its federal rules of evidence, gave the judges a new role. And that has not been adopted in Australia despite being considered there. Why? In part because there are slight differences between the language on expert evidence used in Australia and those in America. The American one refers to science, the Australian one does not. That's one difference. But the real difference, it was not clear that the Australian parliaments, when they drafted in the 1980s and adopted in 1995, meant to pick up this dramatic change in the law. And so the judges were simply unwilling to defer, as the Barbados courts had been to Australia, to these major developments overseas. So I think the federal rules of evidence are well worth looking at, but like everything else, you have to look at both the similarities and the contrasts. But for example, the lay opinion exception to the opinion rule in the Maldives almost exactly follows the Australian language, but is also even closer to the American equivalent language. And so one thing that I will get to when we talk about the opinion rule is that it may well be that American precedents, in part, are more useful on that rule than Australian precedents are, simply because of one extra word, one word that is missing in the Australian version but is common in the Maldives and the United States. I think America is a fascinating jurisdiction. They are huge. They have many, many cases. They are an interesting place despite their present troubles. And I would personally like it if more Australians and more everyone looked at the American decisions, albeit with caution. But that has not been what has happened in Australia by and large, and it's very rare for there to be an American citation or even an American adoption in Australia. Maybe the Maldives will be different in that respect. Those are such good questions. Any others? All right, I'll just take a quick sip of water and then we'll move to the next session where I'll be talking about the law, not history. So a lot of my slides from now on are going to look like this, albeit later on in the afternoon with some pictures, where I put the Maldives language, the Maldives, I have to qualify that term language in a second, against the Australian text. All right, so what I've put on the screen are just the major headings in each jurisdiction. So Australia's Uniform Evidence Law is divided into 5 chapters. The Maldives is divided into what in the English translation is described as 5 parts. And I don't think it's a coincidence that there are 5 in each of them. In fact, when you look at the 2 you see a lot of similarities between these. This is a situation when you can look to these and think, I can see the connection. This is nothing, I think, like the way an Indian evidence law would be divided. So at this point, I now have to give you a whole lot of caveats about what I'm going to be talking about today. So the first caveat, I don't know which order to talk about these in, is my reliance on translation. Unlike everyone else in this room, I am stuck with the unofficial English version of the Maldives Evidence Act that has been generously posted on the Prosecutor General's website. And all the rest of you can look to the proper text. So I want to apologise that I can't look to the proper text. I know from discussions with the prosecutors, many discussions with the prosecutors, that there is room to differ on the translations, and the translations are not official, of course, but are also imperfect. So I am stuck with these translations, but I'm very happy and will mention the times where my understanding is that the translation is a problem. So, do you want to take a break? Is that what you... Oh, okay. Everyone. So I just want to explain, and everyone in the prosecutor's office will be used to this. I can talk and talk and talk and talk, but if everyone wants to take a break, please feel free. So how about we take a break for how long? 5-minute break. We'll take a 5-minute break and then I'll start on this. All right, so you had me partway through some apologies, and the first was about translation, just pointing out that I'm reliant on the translation and that the translation may not be accurate. In fact, when you look to the screen, I see a lot of similarity between the titles in the Maldives Evidence Act and the titles in the Australian Uniform Evidence Law. To me, it looks like they're a copy. But that being said, there are differences as well. And this difference might be due to double translation. You take from the English, you change it into Delhi, you put it back into English, and you get different words. So of course that is, I'm sure, part of what's going on here. But I want to say that an advantage of this, and I hope it is in the official version of the Act too, is avoiding jargon. So although the Australian Uniform Evidence Law was designed to be a modern statute, free of Latin and old terminology like res geste and so on, it still used too much jargon in my view. So for example, Chapter 2 of Australia's Uniform Evidence Law in most jurisdictions is called adducing evidence. That's probably a term you've all heard, but I would make a bet no one has ever used the term adducing outside of a courtroom. And adducing just means asking a witness a question or handing the court something, like a document or a thing. So it's a very fancy, difficult term for a very straightforward action. And I like that the unofficial translation of the Maldives Evidence Act instead uses the word submitting, which to my mind is a better term, and in fact one of the versions of the Australian Uniform Evidence Law in Australia uses presenting or giving evidence. And these are better. I think avoiding the jargon is good whenever you can. And I say that particularly because of the term admissibility of evidence, which appears as a chapter title in Australia's Uniform Evidence Law and of course throughout the Act, and does appear in many parts of the Maldives Evidence Act, of course. It's a very familiar term to evidence lawyers, but I like that the unofficial translation uses the term assessing evidence. When I teach my students evidence law in Australia, I tell them to go through Australia's Uniform Evidence Act and replace every time the word admissibility appears, I say replace it with use. And every time you talk about admissible evidence, you talk about usable evidence, because that's all admissibility means. It means can it be used in the courtroom by the court. And admissible, a very popular term, is a very technical way of saying allowed to be used. And it's important, of course, to remember that that's all we are talking about. Not a physical process, but a mental process. So I like the fact that assessing evidence appears in Part 3 of the unofficial translation of the Maldives Evidence Act. So that's the first of my apologies, is just to note that I, unlike the rest of you, are burdened with the translation. Secondly, my second apology is that I'm going to be talking through a lot of potential rules of evidence and scenarios and the like, and the hazard when you apply any large statute is that you sit there working your way through the rules and saying this is how it works, but then there's this exception and there's this other rule, and then you confidently say your answer at the end, having done an awful lot of very clever analysis, and you've forgotten another section which changes everything. So that still happens to me and others in Australia, even though we have decades of experience of our law and know all of the sections off by heart. We still forget, courts still forget and get wrong decisions because they miss a section. This will happen and must be happening to all of you right now as you get used to the Evidence Act, and I'm sure it will continue to happen to you for many years. And it will definitely happen to me today. I'm going to miss a section, I'm going to say something wrong, because although I did great analysis, I hope, it's wrong because there's a section I forgot about, didn't know about, or whatever. So apologies for that. Please feel free to correct me and at least put that caveat on my analysis in case I've made an error like that, because everyone does it. And I'm going to talk about that as one of the problems of having large statutes like this, is it's easy to make mistakes like that. The third caveat I want to make is that, and I should also say that's also a particular problem when there may be other statutes, not the Evidence Act, but other laws, that actually change the results. And there were many times in discussions with the prosecutors where I would talk about the Evidence Act, and then they would point out that there's another statute that resolves or sometimes doesn't resolve that problem, worsens that problem. And so, of course, you need to know about those other statutes as well. And I will only talk about those in passing and incompletely. The third, and I think this is the last of my caveats, is that my understanding is that the Attorney General has indicated that there are going to be amendments to the Maldivian Evidence Act, and perhaps fairly soon. That's likely to be a very good thing. Amendments are generally, though not always, a positive step. And I should say that in Australia, a problem in Australia with the Uniform Evidence Law is amendments are not a fast or easy step, because the preference in Australia, with now 8 jurisdictions following the Australian Uniform Evidence Law, is that we all make amendments that are similar and at the same time. And that requires agreement from 8 different governments. And the reality is that stops most amendments. So Australia is particularly burdened. That's why our Act in some ways is now feeling old. Countries like New Zealand, Solomon Islands and Maldives, and for that matter the Caribbean islands, are not so burdened. And so I think that's a good thing. That being said, even without the constraints of federalism, there will be some pushback against amendments on the basis that you've already spent all this time and training and guidebooks and court decisions getting used to a complex new scheme, and amendments throw you out. And you have to relearn and start to learn again how the scheme works. So although amendments can sometimes be straightforward and easy to apply, not always. And so I suspect, and this has been the experience elsewhere, there will still be, despite this early rush, some reluctance to do big amendments, or even at times small amendments to the Evidence Act, because of the flow-on effect of those amendments in terms of everyone's understanding. So there is a hazard in adopting a comprehensive scheme, which is eventually there's a pushback, just let's not make changes. And I should mention that in Australia, after 1 decade of the Australian Uniform Evidence Law, the Australian Law Reform Commission and several others reviewed the Act, and people like me and many other academics said, there are all these changes you should make because there are problems, we've been teaching it, we know where the problems are, here are some solutions, I propose many. And by and large, the Law Reform Commission decided not to make many changes for 2 reasons. One, they felt that those changes would be a learning curve for everyone, but secondly, they would say things like, you know the problems you're pointing to, you talk about it a lot, but the courts seem to cope with it. And you all know that experience. You might have a bad provision somewhere, and there are some in the Maldivian Evidence Act, that you know a court will deal with. They will either ignore it, or they'll interpret it a little broadly or a little unusually to avoid a problem. And what then happens is there's a reluctance to change the text because it seems to be working. So that will happen as well. All right, so those are my 3 caveats. Now I just want to talk about this scheme And what I think is important to notice about this scheme is it's a clever scheme. It's a clever way of describing evidence law. And that is true both in Australia and the Maldives. But let me talk particularly about Australia right away. Putting aside the preliminary chapter, chapter 1, and the miscellaneous chapter, chapter 5, and I'm not sure why either of those necessarily, well, the last one exists. The central 3 chapters set up and describe how evidence law works, because they describe 3 processes which evidence law regulates. So the first process is how information goes from a lawyer to the judge. And that might be literally handing a document or a thing to the judge, or it might be the more complex process that I'll get to later this morning of bringing in a witness and asking the witness questions, and the witness speaks to the judge and gives their answers. So Chapter 2 of Australia's Evidence Law, Adducing Evidence, Part 2 of the Maldives Law, Submitting Evidence, is about the process of information going from a lawyer to the judge. Now, turning more closely to Australia, for a reason you'll see in a moment, what's that middle chapter, admissibility of evidence, or in Maldives, assessing evidence? Well, in Australia, it's a further physical process. It's information going from the judge to the jury. So does the judge let the jury use, hear, and understand evidence? The lawyer gives the evidence to the judge looks at the evidence and decides whether it will go to the jury, because the jury is the tribunal of fact in jury trials. All right, and of course you'd all be aware that that process is not going to work the same way in the Maldives, and nor does it work the same way in the vast majority of Australian trials, which are not heard by juries but by a judge. But let me just wrap up this triangle. We have Chapter 2, evidence goes from the lawyer to the judge. Chapter 3, evidence goes from the judge to the jury, the tribunal of fact. And Chapter 4, proof, the tribunal of fact then uses the evidence to reach its verdict and gives it back to, I guess, the public, or the lawyers or the parties. So it's a triangle. Information goes from the parties to the judge. Information goes from the judge to the tribunal of fact, caveat in Maldives, and the verdict goes, the evidence is used by the tribunal of fact to go back to the parties. That's the triangle of information in evidence law. In Australian jury trials, it is a genuine triangle, and you can analyse each stage in that way. All right, and in Australian evidence law, that second bit of the triangle, going from the judge to the jury, is often the focus of discussions. But let's talk about the Maldives. There is no triangle. The judge is the tribunal of fact, and so that middle bit of the triangle is happening inside the judge's mind. It's the judge looking at the information from the lawyer, having received it, and saying, am I going to use this or not? Am I allowed to use this or not? And then if they decide they are allowed to use it, then they use it to deliver a verdict back to the parties. It's still a sort of triangle, but maybe it's a very funny shaped triangle, a rectangle of sorts, where that middle process happens entirely inside the judge's head. That is also true, of course, in the majority of Australian trials, which are not jury trials. So that is the scheme the Australian scheme, that's how the Australian scheme works and was designed to work. And I think it is also what has been adopted, albeit with some caveats, in the Maldives. A 3-stage process where each stage looks at a different part of the information flow in the courtroom. That being said, when I look through some of the provisions of the Maldives Evidence Act, I don't think that the scheme has been perfectly followed. There are provisions in Part 2, for instance, which seem to be more about assessments of evidence or about proof. So although there's this overall scheme, you cannot depend on it. Understandably, there's a little bit of blurriness between bits of the schemes. You could argue that one provision has a dual purpose, and so sometimes it ends up in a different part of the Act. But nevertheless, that's the overall approach. Okay, and so, the heading in Chapter 3, Classification of Evidence, was meant to be for this slide, not the previous slide. Apologies for that. So let's now start looking at the Maldives Evidence Act at Chapter 3. Chapter 3 is inside Part 2, which is the submitting evidence part, and is about information going from the lawyer to the judge, or the parties to the judge. I'm not sure Chapter 3, though, is a good fit for this idea because it's a pretty complex idea, this classification approach. So Chapter 3 has a concept of classification or categorisation, and I'm sure there's a better term in the original Act that is more familiar to you. And this is, I think, following the Indian Evidence Act approach, which is also very much about classifications of different types of evidence. And so we have 3 provisions here which purport to be about classification. Section 37, classification of evidence based on the medium. Based on the medium through which the evidence is submitted, that's the link, the court shall admit oral evidence, documentary evidence and physical evidence. And I think this is appropriately in Part 2 of the Act. It is the rules about oral evidence, documentary evidence and physical evidence are mostly about when a lawyer can bring information to the judge and how they go about bringing information to the judge. Sometimes they have to bring in a witness and go through a process, oaths and questions. Sometimes they are able to present documents and there's a process for doing that, which often also involves a witness, but not always. And sometimes they want to present physical evidence. Again, sometimes with a witness, but not always. All right, so that makes sense in Part 2 of the Act. When I first looked at this scheme, I thought there would be a strict division. Evidence is either oral evidence, or it is documentary evidence, or it is physical evidence. But having looked closer at the scheme, I'm not now convinced that's how the scheme works. There is an overlap between each of these concepts. I haven't put it on the screen, these are not comprehensive slides, otherwise there'd be hundreds of them. But there are definitions of oral evidence, which in part refer to material that could be the subject of documentary evidence. There's a definition of documentary evidence, which of course refers to documents. And there's a definition of physical evidence, which is quite complex and inclusive and includes a number of documents, things like video and audio, which will only be available to the court in documentary form. Forensic evidence as well will often have a documentary aspect. At first I thought, well, maybe the scheme of the Act is that documentary evidence is only about written documents, text, and physical evidence is about things like watching a video or listening to a tape, and that kind of made sense to me, but on looking closely at the way the Evidence Act has been devised, I don't think that is the intent. I think the intent is that there are some items that are both, that fall within 2 categories. So video and audio, I think, falls within the concept of documentary evidence, and so is in part subject to the rules on documentary evidence, but I have to put a caveat at that in a moment, but is also in part physical evidence and is subject to the rules on physical evidence. In effect, it has to obey both sets of rules. The further caveat when we talk about Section 37 is that there are also provisions on electronic evidence, and effectively they are intended to be, I'm not sure they totally succeed, much more helpful, much more facilitative of electronic evidence than other forms of evidence. And so many, if not most documents these days are electronic. And so when you look at this classification, maybe there should be a further classification for electronic evidence, which, while a form of documentary evidence, isn't dealt with by the rules on documents. And a form of physical evidence, because audio and visible video these days are almost always electronic, is nevertheless not dealt with by the rules entirely on physical evidence. All right, so that's that first classification. The second one is categorising evidence based on class, and this is very much following the Indian Evidence Act approach, and evidence admissible by the courts that are assessed based on their class are divided into the following 2 types: primary evidence and secondary evidence. And those are the terms admissible and assessed, not submit, which is Part 2's domain. And my view is Section 38 is really not about submitting evidence. It's not even about assessing evidence, it's about proof. Because the purpose of the primary and secondary evidence division is to guide the court on that third step of the triangle. Once you're allowed to consider the evidence, what verdict will you reach from it? As I understand it, the Indian Evidence Act scheme, primary evidence is of course treated as primary, secondary evidence is only used with caveats. Perhaps the general rule is it cannot be used on its own to convict someone or to make a verdict. You need primary evidence as well, though I'm sure it's a more complicated rule in practice. There is a definition, again I haven't put this on the screen, of both primary evidence and secondary evidence, and generally it reflects the distinction that many of us will be familiar with between direct and circumstantial evidence. Primary evidence is direct, secondary evidence requires further inference before it can be used to draw a conclusion of fact. That being said, the definitions don't entirely follow that approach. They include some things as primary evidence that could be better thought of as indirect. For example, out-of-court identifications are treated as primary evidence. And the definition of secondary evidence includes some things which perhaps are in a blurry line between primary and secondary evidence. So that distinction is there. There is a question in the Maldivian Evidence Act, and the Indian Evidence Act is not my expertise, of to what extent it has picked up the approach of the Indian Evidence Act of, at the proof stage, being very reluctant to make findings purely on the basis of secondary evidence. The Act, to my eyes, lacks the kind of clear language that picks up that approach. It divides constantly between primary and secondary evidence, but it does not expressly state what the significance of that division is. I'm sure the courts will be dealing with that particular issue down the track. This is the part that is most clearly taken from the Indian Evidence Act scheme. All right, so I would put 37 in part 2. I would put 38 probably in part 4 on proof, although in the Maldives that is only about standard and burden of proof. In Australia it is all concepts of proof. And then there's section 41, which I'll now spend a little more time on, classes of evidence based on relevance. Evidence admitted by the courts that are assessed based on the principles of assessing evidence, and again I'm sure this is suffering in translation, are divided into the following two classes: physical relevance and legal relevance. It's a little bit unusual to describe it in this way, but what I will say generally about section 41 is it is clearly about the middle chapter of the Maldives scheme, and in fact the Australian scheme, the admissibility or assessments phase, when a judge decides, okay, I've heard this information, am I allowed to use it? Am I going to use it as part of my next process of reaching a verdict or making a finding? All right. And although it says divided into two classes, what it really imposes are two conditions before, amongst others, before evidence can get through that middle phase. Physical relevance, again that terminology might have suffered in translation, and legal relevance. Yes? Yes, physical relevance is a very unusual term to me. So material relevance does make sense, or perhaps logical relevance, that sort of thing, probability relevance. The clear distinction here is between legal and non-legal. So as you would all be well aware, relevance is primarily a non-legal concept. It's about logic and common sense. I teach a subject at Melbourne Law School called Evidence and Proof, and that is because half of the subject is devoted to logical reasoning. We have our students analyse real evidence and draw charts showing the mental steps that you have to get from evidence in the courtroom to a particular conclusion that has legal significance. I think it's a crucially important process, very hard to teach. All of us learn about it, but it's hard to talk about and pin down all of its processes. So yeah, I think that's the distinction. I agree, physical relevance seems like a very odd word. But again, this is the translation issue, and particularly the burden I have that I can't speak to the original text. So we have physical and legal relevance, but let's talk about the details of that distinction, which is where I want to go next. So physical relevance, logical relevance, material relevance. So here are two provisions, one for the Maldives and one from Australia. The Maldives, evidence when admitted that is corroborative in directly proving an existence of a fact, or evidence that assists in proving the existence of a fact, shall be considered as evidence with physical relevance. All right, and so to my eyes, and again this may suffer in the translation, corroborative is a slightly difficult term here. This makes it clear that relevance can be both direct and indirect. Directly proving a fact in the usual way we're used to with direct evidence, or assists. which picks up in part circumstantial evidence. I haven't put on the screen a further provision which makes it clear that this assistance can be in many different ways. You can assist by addressing the credibility of a witness. You can assist by addressing a fact that is only relevant to the further question of whether the court will make use of the evidence, an admissibility question. You can assess by reference to facts like whether the significance of the party's decisions on whether or not to call evidence or ask questions. All of those are within this concept of logical relevance. They are things a judge can logically take into account, and if there was no rules of evidence at all, they would take them into account. All right? They are a requirement. Although this part, as I said, that provision, which I haven't put on the screen, is a direct copy of Australia's Uniform Evidence Law, the one that says that these 3 extra things count as relevant. The Maldives Evidence Act does not directly adopt Australia's definition of relevant evidence, which says the evidence that is relevant in a proceeding is evidence that, if it were accepted, could rationally affect, directly or indirectly, the assessment of the probability of the existence of a fact in issue in the proceeding. That's a very carefully worked out Australian definition. In that half of my course where I teach students proof, we work through each of those steps. We talk about what it is to be rational, hardly a straightforward concept. We talk about affecting how your mind isn't always convinced by certain facts, but is affected a little way by certain pieces of evidence. We talk about assessments of probability, which is really what proof is about, and we talk about the connection to a fact in issue, a legally significant fact in a proceeding. We spend a lot of time on that. All of you know about that process in your heads because you've learned it because you work in courtrooms, but I bet you were never taught about it by someone. It's not typically the subject of teaching, but maybe I'm wrong about that. All right, so that particular definition is not adopted in the Maldives, but I doubt this is a significant difference. The definition in Australia is not some work of unusual technical distinction. It is an attempt to describe the process we are all familiar with in words. The Maldives has done it a bit with 41B in a slightly different way, but I doubt the difference is too significant. So that is physical, logical, material relevance, but then there is also legal relevance. And that terminology is unusual to me, but is very important as the second requirement for evidence in the Maldives. So although it's called relevance, it's really about the law, not about common sense. Ordinary people out there in the Maldives would never take into account this issue when they are deciding whether to believe someone or whether what they think will happen or what has happened in the past. But the courts are required to do this, and this of course comes from the Maldives Constitution as well as other fundamental rule of law ideas. Evidence that is not prohibited from being admissible by the court under the Constitution or this Act or any other legislation, so there may be other laws that impinge on this, for the following reasons shall be considered as evidence with legal relevance, all right, where the evidence is illegally obtained, where the statement is obtained under compulsion, or where the evidence cannot be assessed because of this Act. So this is, as I said, of legal preconditions that tell a judge, once they've heard information from a lawyer, whether they can use it. All right. It is a familiar enough idea that if a statement has been compelled, although there might be exceptions, typically you would simply not use it. What's the point of a compelled statement? But more importantly, it's abhorrent, for example, for a court to receive evidence that might perhaps have been the product of, say, torture or some other abhorrent act. But the principles also include whether the evidence is illegally obtained. And read literally, Section 41C 1 would bar a court from using evidence that has been illegally obtained. In many ways that is intuitively sensible. If, for example, evidence has been stolen and then is presented to the court and the court uses it, the court is receiving stolen property. It is itself committing a crime, if of course it is aware of the illegality. So that's a familiar enough idea, but it is also controversial. The English courts famously said there is no such requirement in English law. In fact, they literally said, even if it has been stolen, we will still use it. And the reasons they say that is, we still want to get the right answer. And stolen evidence, abhorrent as it might be, it still could be, as a matter of common sense, relevant, perhaps very relevant to the cited case. And yet 41C1 says no, you cannot use it if it is illegally obtained. All of you would be aware of how difficult this issue could be, because all of you would be aware that the outside process of evidence making its way to a lawyer and then to the court has to comply with many, many laws. And it is very easy for some laws to be breached, perhaps minor ones, on the way to the courtroom. A simple example which recently occurred in Australia, to give an example, is there was a rule in Australia that if the police seize a computer under a search warrant from someone's property, and they do this, of course, because they want to take the computer away, analyse it, and learn what they need to learn, and they cannot do that typically easily at the property, although perhaps sometimes they can. The rule in Australia was they have 30 days to do that analysis. It's not a tough rule, because if they need more time after 30 days, they simply go back to the court and explain why they need more time. That's not a harsh rule. But there were some Australian police who realised suddenly that they hadn't kept an eye on the calendar, and 31 days was now up. They were 1 day too late. And what did they do? They didn't confess to the court, because the police often think that once they've breached a rule, it's all over. So they probably, if they'd gone to the court would have said, "We understand, we'll give you an extension." So instead, they pretended that they'd already done the analysis, which they in fact did on day 31, in the first 30 days. They lied. All right, so two problems. One, they broke the law. They weren't allowed to do the analysis at day 31. They hadn't got an extension, so that's illegally obtained. The information they got, which was highly important information, was illegally obtained. All right, and the Australian court doesn't have this rule that says you cannot use evidence that is illegally obtained. They have instead a different rule, which I put at the bottom of the screen, which is a discretion. Where evidence has been illegally or indeed improbably attained, then the court typically would not admit it unless, and there's an exception, the desirability of admitting the evidence outweighs the undesirability of admitting the evidence. They weigh up the pros and cons. That is not a straightforward decision. I think it's a very difficult decision, but at least it gives the court an option. And so the court in that case said, you know what, 31 days versus 30 is not a big enough difference. It's too minor. You shouldn't have done that, but if that's all you had done, we would have admitted this evidence. It's a minor issue. And as I look to the Maldives Evidence Act, there is no such distinction between minor and major illegality. Any illegality means that the evidence lacks legal relevance and therefore cannot be used by a court. I don't know if a court, I'm sure a court would look at that thing a bit surprised that such a tough rule applies, and as you are all well aware, courts are capable of reading literal words as a little less literal where they might have an absurd result, so maybe that would be the approach in the Maldives, or alternatively maybe there will be amendments to clarify, but of course this is a complex issue and would be affected by the Constitution. Could I mention the outcome of the Australian case though? The Australian judges ultimately refused to hear this evidence, which again was highly significant evidence discovered on this computer of sexual offending in videos. And it wasn't because that we went to 31 days, it's because the police lied. They tried to cover up their behaviour, and the Australian courts first said that's abhorrent, that's lying to the court, much worse than simply not following a time limit. And secondly, they saw their role, and one reason for this discretion is to deter police from bad conduct. They weren't concerned to deter the police from letting a time limit expire. They could cope with that, but they wanted to deter future police from cover-ups. The right approach, they said, would have been for the police to come forward to the court, apologise for letting the time go late, and seek, if they could, the ability for an extension. And the police made a bad decision. So that was the thing that led to the evidence being excluded in Australia. The Maldives rule does not, in its literal terms, allow for those sorts of what I would regard as a nuanced, albeit very fraught, distinction. It is much more firm. All right, so that is, I can only observe that difference. Maybe it will be interpreted away, maybe it will be amended away. Maybe, of course, I'm reading a bad translation and it is much more acceptable in the original version. So that is a difference between those two approaches. Australia has no concept of legal relevance, but it is instead dealt with, as it is in many jurisdictions, via an exclusionary rule in Australia, a discretionary one in America, a less discretionary one, but with exceptions. Time-wise, okay. So this brings me to a very difficult question. One of the central ideas of Australia's uniform evidence law, when the Australian Law Reform Commission modernised the law over the common law, was to formalise rules, but also have exceptions to the rules that allow for discretion. So the process was, there is a rule. Typically this is the rule you follow, but at least with some of the rules, there are discretionary ways out. And this just reflects everyone's experience, which is that rules are good servants but bad masters. They are good things to guide you, but at times when you try and write down a rule, you can't think of every situation, so you allow someone you trust the ability to create exceptions to the rule, ad hoc exceptions. That's what discretions are for. All right, so when I look to Section 114, which is in Part 3 of the Maldives Evidence Act, titled Relevant Evidence and applies the relevance definition that's in Section 41. Evidence may be deemed to have relevance to a fact where evidence containing legal relevance is admitted to the court due to having physical relevance, and my understanding is that is not the greatest of the translations of the original text. But look at those last words, an admission of which assists in proving the existence of a particular fact in issue in the proceeding. That language in the unofficial English version appears in many parts of the Act, it appears in many of the rules. It's a constant reference point, you'd all be aware of what the original words say. Admission of which assists in proving the existence of a particular fact in issue in the proceeding. And that question of whether something assists a court or not does allow for a yes or no answer, but you can imagine it varying from judge to judge, from case to case, from evidence to evidence. Some judges will say some evidence does assist, other judges will say it doesn't. And assists is also, it's not clear to me whether that term is just about common sense logic or about law, and it may be about assists in a practical way. We are all aware of those moments in court cases where some evidence is brought up and it just looks, although it's not irrelevant, it could make a difference in the case, albeit a small one, it's going to take a lot of time. And so you could spend a large part of a day in Australia, weeks, because Australia's cases take so long, in deep exploration of an issue which is only a minor one. All right. In Australia, this is dealt with by discretion. There is a bare requirement of relevance that I've already put on the screen, but Australia also has general discretions in part of the Evidence Act. And I've only put up one of the ones on the screen, but this one. The court may refuse to admit evidence, use evidence, I would say, if its probative value is substantially outweighed by the danger, by one of a set of dangers. This is a cost-benefit analysis of evidence. The benefit is its probative value. Will this assist in resolving the case? The costs are this list. All right, so there's a list, and one of them is be unfairly prejudicial to a party. This term does not appear in the Maldives Evidence Act, but is a mainstay of other jurisdictions. It refers to the risk that the court will go awry, will think badly about this evidence. That's what prejudice means. Not that it's bad for a party, but it's bad for justice. The court will reach the wrong decision, will be too influenced, too emotional, too confused, too motivated by the evidence, and will be led down a bad track. And everyone's aware of the kind of evidence that sometimes could lead anyone down a bad track. Evidence of horrific crimes, evidence of identification, which is not dealt with expressly in the Maldives Evidence Act, which everyone is aware can seem more compelling than it is. And there's many other categories of such evidence. Now, that is not referred to in the Maldives Evidence Act, and I think there's an obvious reason why, because it's mostly a concept for juries. The judge keeps information from a jury because judges are worried that juries who are strangers to the court process are brought in briefly to be involved, they're just ordinary people, and therefore they don't have the training that allows people to put aside prejudice. You're all used to the complexities of the world, the experience of court cases. Maybe juries aren't. That's the argument. I have to say, as someone who researches juries, and I have published a book on juries, there was I briefly mentioned this, there was a jury in an English murder trial who were deliberating. They had to think over, and they took all day. They hadn't decided, so they were sent to a hotel overnight. And they used a Ouija board that they'd made out of pieces of paper and a glass to ask questions of the deceased, the dead victim in the case, including whether the defendant was guilty. So that's what I wrote about. It's a notorious example of a bad jury, although I actually see it as a little more complex than that, not because I'm a fan of Ouija boards, but because I was sympathetic to the pressures that jury was under. All right, so as someone who researches about juries, I'm a little suspicious of the argument that juries are unreliable and can be sent awry, and that lay people don't understand how to do common sense or be fair. They can be affected by certain types of evidence in a way which means they lose all reason. I don't know if that's true. Nor do I know if judges are immune from any of that. Surely judges are people too, and they can be affected in ways by evidence, even if they choose not to articulate it, even if they aren't even aware of it, they can still be affected by evidence in some ways. It seems to me, and I'm not a psychologist, but that's my feeling. So this concept of unfair prejudice, it isn't necessarily just about juries, it could be about judges, but here's the catch. When you have a judge-alone trial, the judge already knows about the information before they make the determination of whether there are dangers of it. So even if a judge decides this is too dangerous, I shouldn't use this, it's too late. They already know about it. And that is why I think the concept of unfair prejudice isn't typically useful for judge-alone trials like the Maldives. That is why that is missing from the Maldives Evidence Act. But look at the other considerations in Australia. It's not just about being irrational. It's the risk that the evidence could be misleading or confusing. A judge might simply say, this sounds interesting, but I'm never going to fully understand it. And the lawyers in the room don't understand it either. There's a witness there who can speak about it, but we don't understand the witness because they speak in jargon, they're not good explainers and so on. We're all used to that. This isn't worth it. And we will send this away just because we don't know what to make of it. And a judge, I think, could fairly make that ruling about themselves. I could be confused by this. It's not, what we get from this evidence isn't worth that risk. A more compelling and a more common problem could cause or result in an undue waste of time. I like that term, undue, the possibility you could have a due waste of time, but it's a very familiar situation where a court just says, I don't want to spend days on this, it's not worth the trouble. And so that option is available to Australia. And there's even a fourth option. This is only in Victoria, my own jurisdiction. I was the one who suggested putting this in. A danger, particularly in homicide trials, where a defendant spends their time criticising the deceased. It's not, I didn't murder it. I'm not to blame here, the dead person is to blame. Of course, that might well be right, but the argument at the time, and this is why this ended up there, is maybe you should be careful and hold off, unless it's really necessary, saying mean things about the dead. So that kind of consideration. These are familiar considerations in Australia. Do they apply in the Maldives? Can a court make a choice to say, we're not going to go there, we're not going to hear this evidence? And I look at the provisions of the Maldives Act, and what is clearly most clearly missing from the Australian experience is discretionary exclusion. Every one of the other 14 jurisdictions that have adopted wholly or partly Australia's Uniform Evidence Law have adopted the discretions. That includes the Solomon Islands, which has this provision and others word for word, even though there are no juries in the Solomon Islands. Maldives stands out from that, and I don't think the lack of jury is the only reason, but my question, and I don't know the answer, is whether there is room, for example, in the concept of assisting improving, for a judge to exercise a similar kind of authority at times to say, this is not worth it, this is not worth the various troubles it will concern. And remember, this is not a generalised ability to say stop. It is only when the dangers are outweighed, the dangers aren't outweighed like what you're getting from the evidence. Important evidence, it's worth taking the time. It's worth puzzling out and not being misled or confused and getting to understand. It's worth the risk of prejudice. It's even worth demeaning the deceased in a homicide offence trial, but not minor evidence. So that's the way the discretion would work, and I only raise that question, which is unknown at this stage, of whether the Maldives Evidence Act allows for it. It is not expressed in the Act. One final thing I want to mention before I move on to examination of witnesses is a third part of the Australian Uniform Evidence Scheme. So the Australian Uniform Evidence Scheme, when it comes to admissibility or use of evidence, is rules, discretions, and then there's a third part, warnings. And so these are really this is really something that goes to some extent to the final part of the triangle. What use are you going to make of this evidence in reaching a verdict? And the Australian scheme, to an extent following the common law, to an extent following a peculiar approach of Australia's High Court, is very much built around the idea that there should be warnings in the system. Now, you're going to see a caveat right away. Here's Section 116 of Australia's Evidence Act, which is about identification evidence, titled Directions to the Jury. If identification evidence has been admitted, the judge is to inform the jury that there is a special need for caution before accepting identification evidence, and of the reasons for the need of caution, both generally and in the circumstances of the case. This is a way for a judge to impart the learning of the law, which we are all well aware of, that identifications can be misleading, that they can be horribly wrong, even though everyone is being honest. So that information is given to juries in Australia whenever there is identification evidence, and there is a further regime in 165 for any evidence of a kind that may be unreliable, and that has been interpreted to mean where, of course, any evidence might be unreliable, but this is the kind of evidence where its unreliability or potential unreliability is familiar to lawyers and judges, but is not familiar to lay people. The judge is required to familiarise the jury with all of those things. Now, of course, that scheme is not in the Maldives Evidence Act, and there's an obvious reason for that: no juries. But I do want to point out that this warning scheme in Australia is also used in judge-alone trials. And the way it is formally used in judge-alone trials, and it sounds a little absurd, is the judge warns themselves. In reality, this is a judge reminding themselves of the dangers, so they don't forget. It's also a way, when they issue reasons of judgment, of assuring the parties that they have remembered these warnings, they haven't forgotten about them or ignored them. They follow the common experience of lawyers on issues like identification evidence or certain sorts of unreliable evidence. They are also a mechanism for the lawyers in making submissions to the court, such as closing submissions, to emphasise why those warnings or that experience might be important. And finally, they are also actually treated as a command, not just a warning, to appeal courts when they review decisions. They must follow those approaches as well. They cannot put them aside. That Australian approach, of course, isn't in the Maldives Evidence Act, but I just want to note that just because it is built around juries doesn't mean it's a jury-specific rule. There is room for this approach in the Evidence Act, but it is not expressly there at the moment, though perhaps it could emerge in a variety of ways. All right, so the final bit of this morning session, do you think we need a break, or do you think we can proceed? Okay, we will proceed. I know this must be exhausting for you to listen to as it is for me. Actually, sorry, so before we just get to this, I guess this should be a moment where I check if there are questions at this stage before I get to examination. Yeah. That's a precondition, yes. That is such a good question. So there's a complex. So this is the question. I think what you're alluding to is, maybe we should treat this defence evidence differently, because the defence, even if the judge is a bit bored or worried or doesn't think it's useful, the defence wants to make its case. And the defence, of course, the defendant is facing prison or another criminal sanction in a criminal case, and in any case has high stakes. So maybe they need to be free to defend themselves. So there are a couple of answers to this, but it's a complex question. I should point out that I've only put up the general discretion to exclude evidence. There's actually a stronger exclusionary rule for prosecution evidence. That word substantially outweighed, it just says outweighed for prosecution evidence. So the idea is that judges should be more ready to exclude prosecution evidence, particularly because of that risk of prejudice, then they should be willing to exclude any other evidence, defence evidence or civil evidence. So that's part of the answer, but it doesn't solve the problem, because this provision still potentially allows for defence evidence to be excluded. And a particular issue which is very difficult is if there is a joint trial of two accused. And you might have evidence which is part of one accused's defence, but is very damaging, and not just damaging in a deserved way, but damaging in a way that might inflame the fact finder to the other's one. So for example, there was a case in Australia where the one defendant said they were forced to do the crime by the other defendant. That's fine. But then they said the way that the other defendant forced me to do the crime is that the other defendant said, you need to understand, I have killed, and they listed a list of people they have killed, and I will go after your family. And that kind of evidence very much explains why anyone would do a crime if there's that kind of threat to your family that's compelling from someone who actually claims to be a serial killer or something, a gang killer, but is very damaging into the other party in a way that could inflame a jury in that case, but even also a judge as well. The judge might think, oh, I want this person put away. So how do you deal with that? This went to Australia's top court, the High Court, just last year. And the defendant said, as you implied, it's not my problem that there's another person in the room who's affected. I need to put my defence. And my defence is much more compelling if I can say exactly what that man said to me, rather than allude to it, as the judge had said should have been the answer. And they particularly said there is an English common law rule along the lines you've said, which is defendants should be given a law of leeway. They should not be restricted from putting evidence on discretionary grounds. Quite the contrary, there should be a discretion in favour of admission. And the High Court, and this is an example of the phenomenon I talked about in the first part of my talk, in the past, I think, decades ago would have said, yes, that's a good rule. We should follow what the English do. It fits with our sense of justice, fits with my sense of justice. If we can't follow that rule, we should separate the trial. So one accused can do one, and one accused, they can have separate trials where one reveals this information, the other one does not. But instead, what the court said is, we've looked at the Act, and the terms of Section 135 are clear, and there is no room for the English approach. And so they said, no, you cannot take account of this extra consideration that this is a person whose life is at stake. Well, not life, but freedom is at stake. You just apply the law. So the sad answer, perhaps, is the Australian courts have said there isn't room for this. I should mention that the New Zealand Evidence Act, which partly followed Australia, expressly says in their similar discretion that one of the factors the court must take account of is the right to a fair trial. So it may well be you get a different answer in New Zealand. And actually, just to wrap this up with the earlier question about the relevance of American law, I criticised the High Court not because of their decision, I understood why they made their decision, but because they didn't think of an American solution to this problem. It's an interesting American solution. In American situations where there are two co-accused running a cutthroat defence, where they accuse each other of a crime, they don't have two trials, which is very expensive and difficult. They have a single trial in a single courtroom. The witnesses all speak once, but you know what they do? They have two juries. And both juries sit in the room, but every now and then one is told to go. And then that one goes and they give extra evidence, and then the jury is brought back. Very unusual. I would have thought unworkable, but the Americans have tried this many times and they said this works. I can't imagine this being adopted elsewhere, but I was disappointed that Australia didn't think of this idea. Imagine if doing this in the Maldives, a single trial but with 2 judges. And every now and then one of them leaves. Could you imagine that? I can't, and maybe you can't. But you know, this is the benefit of looking elsewhere. Maybe this is a solution to an otherwise unsolvable problem. So that's what I added. That's such an excellent question, though. Yeah. Any other questions? Yeah. Yeah, I don't think I'm in a position to say what is better because I'm going to be affected by what I'm familiar with. Probative value and assessments of it is just the heart of everything we do in Australia because it's built into these discretions. I teach to my students, I'm used to it, but I'm not here to say it's better. And in fact, the neatness you described, and it is kind of neat, isn't the reality. The reality is much messier because those 3 stages of the triangle can be blurred. Decisions about whether to ask a particular question of a witness, where you might say, and we're going to get to this with examination, maybe that question shouldn't be asked, maybe you should ask it in a different way, are sometimes looking ahead to questions of whether this evidence can be used properly by a judge, and even further ahead to whether the judge will find it useful. And so sometimes when a judge is saying, maybe you shouldn't ask that question, what they're really saying is, I'm not going to give this much weight. And that happens in Australia. So that neat triangle I describe is often quite blurry in practice. And in fact, assessments of probative value, how does a judge assess probative value, is actually one of the biggest debates in Australian evidence law because there was for many years a fight over whether the judge, when they assess probative value, should assume that in this case with a jury, that the jury will believe the witness and then just assess, if they believe the witness, how useful is this? Or should they take into account that maybe this witness looks dodgy and no one would trust them? There's a huge debate, and you can imagine the similar debate about trying to apply this rule where judges look at the witness and is saying, look, of course what the witness is saying is important, but I don't like that witness. They look too shifty and unlikely for me. That is why I don't want to go there. Effectively, that's a decision about the end of the process verdict, but it can be fast-forwarded to the stage of admissibility or even to the stage of submission. So I do like, as an academic, the neatness of these stages. I use it to teach, but I think the reality of any process is that these are all blurred. So I cannot say this is a necessary process because I don't think it's ever followed rigorously in practice in any case. It is a nice way of thinking is all I will say. So part of the reason I'm mentioning it here is to the extent that this thinking helps understand the Act or even helps apply it, it's worth it. But that being said, that doesn't mean that this thinking is essential. There are other ways to go about it. I should also mention, just in passing, there is a definition in the concepts part of the Evidence Act, the preliminary chapter, of a term which is, in English, is extent to which the evidence assists the court. And I'm pretty sure, and maybe this is even just a function of the translation, that just means probative value. You have relevance, which is a yes or no question. You have probative value, which is a how much question. And extent is a how much question. It is there in the Evidence Act, but you know what, I looked through the Act and I couldn't find anywhere that actually used that term. It's a term that's defined but is sitting there underused. What a court will make of that, I'm not sure, but it is right there. Any further questions? These are all, I know everyone always says this, but these are all questions that are raising such important issues that we all debate all the time in Australia. They're not remotely unusual questions. In fact, they're quite the opposite. They go to the heart of the dilemmas. All right, well, I'll start the final bit of the morning session now, and this is on witness examination. Why talk about witness examination? 2 reasons. One, everyone I've spoken to in the Maldives, every lawyer that is, or judge, this is the question they've asked about. They want to know more about these provisions. These feel like a significant part of the Act, one that makes a real practical difference, that needs to be understood, and it's one that potentially could change very familiar processes. This is why everyone asks about it. That's one reason. The second reason, it so happens that these are the provisions, the ones I'm going to talk about, refreshing, unfavourable witnesses and the like, which are taken from Australian law. Not word for word, always, there are differences, but this is the closest set of provisions. And I should also mention that in Barbados and the like, these provisions get the most attention as well and the most debate. So, Nuffa suggested I talk about this and I'm very happy to do so. Again, with the further caveat, there is a lot about Maldives procedure which I don't know about and is unusual to me, and I've spent a while learning about it, so of course I will make errors in some of my discussion again or miss some issues. All right, so I'm really going to just talk about a few bits of examination. The provisions on witnesses in the Maldives Evidence Act, like everywhere else, there's many issues they cover. They cover capacity or competence, they cover oaths, they actually also cover some proof issues, assessments of the credibility of the witness and so on. And I'm not going to talk about all of those. They divide, as you'd all be familiar, examination into the 3 stages of examination, or called examination in chief or direct examination, cross-examination and re-examination. I won't go through all of those. There are some really interesting provisions in the Maldives Evidence Act that are specific to those issues that could be problematic. I'm happy to talk about those in questions. Instead, I'm mostly going to talk about 3 particular processes. So the first one is, I've called it reviving memory in court, although mostly it's called refreshing memory. This is an area where the concept of refreshing, the Australian Law Reform Commission said, it's a strange jargon, reviving is a better jargon. I don't know if that is true. It appears, you see the word revive appears in the English translation of the Maldives Act, but not in the title. All right, so section 103 of the Maldivian Evidence Act says, it's called refreshing the memory of the witness. A witness shall not, at the time of testifying in court, view any documents to revive their memory without leave of the court. All right, so that's a particular process. It's the first stage of that triangle. A witness wants to talk, but this witness doesn't want to talk just off their own head. They want to look at a document as they do so. Notice that this provision is about looking at the document at the time of testifying in the court. We all know that witnesses, before they come to court, sometimes prepare, and sometimes that involves reading things, documents that might be that they wrote, it might be the things that other people wrote, because they were trying to be helpful. They don't want to make errors, all right? But this 103 is, of course, only about the moment of being in the courtroom. They've been asked a question, and they asked to look at a document. And the answer, section 103, of course, says they can't, but then it has its exception built in without leave of the court. So they can if the court agrees to it. That's the rule. All right. And there's a second rule at the time of testifying in court: view any documents to assist in reviving their memory in relation to a fact or opinion without leave of the court. They seem to say the same thing, but one is more specific. It's only about a specific issue, and the other is generally. I guess that's the intention there. There are similar provisions in, for example, New Zealand and the like. All right. I've put the Australian provision there as a bit of a contrast. I don't know if it is a contrast, but it is something of a contrast. The Australian provision is called attempts to revive memory in court, and that's very deliberate language in Australia. A witness must not, in the course of giving evidence, use a document to try to revive his or her memory about a fact or opinion, unless the court gives leave. That I think just combines the 2 rules in section 103. But it also says there's a consideration, so it provides some considerations for the court, what the court has to consider. And then it says, if a witness has, while giving evidence, used a document to try to revive his or her memory about a fact or opinion, the witness may, with the leave of the court, read aloud as part of his or her evidence so much of the document as relates to that fact or opinion. So what the Australian, and this is all deliberate by the Australian Law Reform Commission, they decided that we shouldn't require, when we should permit someone, if a person is permitted to read a document to revive their memory, we shouldn't require anyone, the witness or the court, to find that their memory was actually revived. It is enough if they tried. And I think the reason for that is because we all know that it's almost impossible to assess whether a person's memory is actually revived by reading a document. The witness themselves might not be sure. They read the document and they go, I guess that's what happened. But in any case, a witness trying to be helpful to the court might just be tempted to pretend, oh yeah, I remember now, when the reality is they don't remember, but they're just reading out the document. And the Australian Law Reform Commission said, let's not pretend. They should go through the process of trying, and then with the permission of the court, they just get to read out the document. That doesn't mean the court will always let them read the document. The court will look at the witness and try and work out whether the witness has no idea what's going on, or whether the witness is being conscientious, has made a good attempt to revive, and simply needs help because their memory has faded. And also the court will look at the document itself and the circumstances in which the document is made to make sure that the witness, in reading it out, isn't reading out a document that has nothing to do with the witness's prior account. So there still might be a document written by another, but they'll make sure that this is a valid document that plausibly relates to what the witness saw. So that's the Australian provision, and the question is, what's the approach in the Maldives? It doesn't use the attempt language, at least not expressly in the unofficial translation. It says the document can assist in reviving their memory. And my question would be, does that mean that the witness has to claim that they now remember? And they put away the document and they now speak? And you can imagine a witness who, yes, I remember now, let me just have one last look, staring, and then says by rote what's in the documents. I don't know how realistic that is, but maybe that is nevertheless the requirement in section 103. All right. Alternatively, maybe this can be read because of its similarity to Australia as allowing a bit more flexibility on that process of trying to revive and making some precautions to ensure the attempt is genuine, the document is genuine, and so on, as opposed to formally requiring the reviving. Notice a couple of things. One is there's, in the Maldives section, just as in Australia, leave of the court at each stage is required. But in the Maldives, there is not always information to the court on what should guide that decision about leave. There will, of course, be submissions from the parties, at least in some cases, if these things aren't decided on the spot. But what guides the court? All right. In Australia, there is a general provision that says whenever a court is required to give leave, here are a list of things that they should generally look at. There is no similar provision in the Maldivian Evidence Act. It is often referred to in Australia, that general provision. Maldives doesn't have it, so this would be a matter for, well, the hard question is it a matter for each judge who has their own practice, or is it a matter that ultimately a higher court might impose on all courts, either via a decision or via regulations? And of course, there are proposals for Supreme Court regulations on evidence law, which do guide some discretions, not all. All right, so that's the first thing I wanted to talk about. And the second thing I just want to mention is what happens when a witness relies on their own document is that there is a form of hearsay, because the document is really the source of evidence. The witness just reads the document, stands by the document perhaps, but it's the document that the court will be using. All right, and in the afternoon I will talk about the hearsay rule and whether that is or isn't consistent with the Maldivian hearsay rule. I'm of course well aware now that the practice in the Maldives is that witness statements are part of the package that goes to the court. They're part of the charge process and so on, and the court will be aware of those witness statements. But that's bringing the witness statements to the court's attention. There's that second step. Is the court going to use the witness statements? The language in Australia makes it clear that when a document is read or aloud, it becomes part of the oral testimony of the witness. But I'm not sure the Maldivian approach is as clear on that point. I want to draw attention to a further provision in Australia that is not in the Maldives Act, Australia has a provision called attempts to revive memory out of court. And all that process refers to is what I described earlier. The witness in preparing for a trial tries to read a lot. And the reality is that that witness may not remember, but simply then recounts to the court their memory of what the document says. So it's been 5 years later, oh, I don't remember what the person looked like. Okay, I'll read what was said in my earlier witness statement, and now I'll tell the court, yes, I remember what the person looked like, and they looked like this. But really all they're describing is their own earlier statement. We all know this happens. It happens to different degrees. Sometimes witnesses feel it's the wrong thing to do. Sometimes witnesses don't have access to the documents or are told not to do so. But we all know this process can happen. And of course, there's a similar process of talking to others where documents aren't involved. The Australian Law Reform Commission said we should try to acknowledge this process. And the way they did it was simply to say that if this is known to have happened, a party can ask for the documents. That way, at least when a witness does this, we don't have to pretend the witness remembers. We can say that the witness has been prompted by a document, and at least everyone can see the document. Amongst other things, we can check that the witness has got the document right, they've remembered it correctly, so the document will also go. And this, of course, I'm aware that witness statements go to the court anyway, but if the witness has relied on some other document, and that comes out in examination, because of course witnesses can be asked what they did, and they may or may not admit that what they did, then it's simple enough to bring that document to the attention, not just of the court, but of the other party to assist in things like cross-examination. And there's a further control that where the witness doesn't make that document available, the court can, again at its discretion, say that the witness can no longer testify. And that is a constraint to try to make sure that this information comes to the court. Okay, there's a third point which is relevant in both the Maldives and Australia, a different rule for police. This was a late addition to the Australian Law Reform Commission's draft. Barbados did not pick it up because they picked up the earlier draft, but the later Caribbean jurisdictions put this in. It's sparked a huge debate in the Caribbean. A special rule for evidence given by police officers. Maybe I'll start with the Australian rule first. Despite Section 32 on the reviving memory rule, in any criminal proceeding, a police officer may give evidence in chief for the prosecution by reading or being led through a written statement previously made by the police officer. And the idea here is to acknowledge that police officers deal with many, many cases. They won't remember everything they did. The reality we all know is they go and read their notes or their notebook or their statements prior to coming into court. And the reality is, although many of them can have good memories, they're not going to remember everything, and they will defer to what they wrote at the time. In fact, they are professionals who are well aware that it is best to defer to what they wrote at the time rather than creating inconsistencies that can be exploited. So of course, they're also professionals in another sense. They're good at remembering, memorising what was in the statement, I guess, is one way of describing it, and then presenting their testimony without any hint of that. So again, the Australian Law Reform Commission said, we know that is happening. Let's not pretend. Let's not go through a process. Let's not force the police officer to hide the documents. Let's not force the police officer to go through a process of trying to revive memory. Just read it out. All right, so that's the rule in Australia, and there's no discretion built in except for the police officer. The police officer is the only one who gets to decide this. Are they going to read out this statement or not? A police officer might decide they'd rather talk, and are more convincing if they talk without their statements, but they might just say, I don't care, I'll just read this out and then I can go home after the cross-examination, that is. So that is what is allowed in Australia. All right, pretty controversial, mind you, because it means that effectively the police officer isn't the witness, their statement is the witness. Again, this would be regarded as hearsay in Australia ordinarily. The Maldives rule. Statements given by officers of the investigative agency, that's perhaps a little broader than a police officer, in any criminal proceeding where an officer in investigative authority is testifying in relation to a witness statement previously given by that officer, so they have to be testifying in relation to that statement, based on the subject of their testimony, the officer may be allowed, again this is the English translation, to view the statement during trial. The officer may answer questions put forth in relation to the statement. This does not seem to be as generous. It, for a start, seems to be a little narrow in when this can happen, although perhaps covers more officers. Secondly, it says not the police officer may, but the officer may be allowed. Allowed by who? The judge, the parties, the prosecution, the defence. This English translation doesn't make it clear and seems to suggest it might be the judge. May be allowed to view the statement during trial. How is that different from the ordinary process of refreshing memory, which has the same process? But it makes no reference to any pretense of revival. The police officer doesn't have to try to revive their memory. The police officer doesn't have to revive their memory. They just view the statement. After they view the statement, what happens? The officer may answer questions put forth in relation to that statement. That doesn't seem to be the same as simply reading it aloud, but I'm not sure what the difference is exactly. All right? So, seems similar. I don't think it's clearly not a copy of the Australian rule, but what is it exactly? Relevantly, and here I need to mention the proposed evidence regulations of the Supreme Court. If I'm understanding them correctly, again I'm relying on the English translation, those regulations tell judges the factors to consider in applying Section 109A. And yet, it's not totally clear that... sorry, I have left out, and sorry, I always leave things out. There are some conditions. And sorry, I really should have mentioned this up front. Both Australia and the Maldives don't allow this in every case, they impose conditions. And the conditions are that the document was originally written at a time when the facts were fresh in the police officer's memory, and that they were, I think, signed. Is that does anyone have the particular text? Something like that. There's a formality about them. We need to make sure this wasn't written later. It wasn't supplied to the police officer by someone else. So there are those conditions. In Australia, that's all that needs to be established. The way 109B, which sets out the condition, is written, that appears to be the only two conditions that need to be applied as well. And yet the evidence regulations say, here are some more factors for the court to consider. And when I read that, I'm not sure the evidence regulations are entirely consistent with what would otherwise be less discretionary language in Section 109. They certainly wouldn't be consistent with the Australian approach in Section 32, which doesn't give the court any discretion at all, just the police officer. So I think 109 is more ambiguous, but those regulations may be based on a wrong understanding of how 109 works. At least they're based on a particular understanding of how 109 works. All right. But again, noting there's a lot that's unclear about 109. When may an officer be allowed to view a statement, and what can the officer do with the statement? Answer questions put forth in relation to the statement could mean what's in the statement, but it could also mean why is what you're saying in court different to your statement, which is a very different thing. All right, I want to talk about a few other aspects of examination. So we're now at the cross-examination stage, and I just want to draw attention. I won't talk about this at great length. That one of the areas where the Maldives follows Australia is a ability of a court to stop certain questions. This is controversial. Cross-examination is the area of examination which is relatively free of rules. Examination in chief, re-examination, you can't lead. Cross-examination, you can lead. Re-examination must be limited to the subject matter of cross-examination. Cross-examination typically isn't limited, although there is a provision of the Maldives Evidence Act which does seem to impose some limits on the subject matter of cross-examination. But the purpose of the Australian rule, which has been at least mostly adopted in the Maldives, is to create a further control. And the idea here, as you'd all be familiar, is cross-examination is an awful process for witnesses. Many of them come out of cross-examination shaken. Of course, that is perhaps the point, and its purpose is to shake a witness. There's the belief, especially amongst English and American lawyers, that cross-examination is the greatest engine for discovering the truth. It's why we have a hearsay rule and so on. So cross-examination has a lot of benefits, but it has this massive downside, that it can be horrible. And we all, of course, know the reality that, of course, the horrible aspects of cross-examination are sometimes necessary, but sometimes are not necessary, and instead are a weapon or an example of bad lawyering by the lawyer doing the cross-examination, or it might be a party doing the cross-examination. So the idea in Australia was the court should take a more active role, not in the subject matter of the cross-examination, but the style of the cross-examination. The court, and there are a number of versions in Australia, I think this is Victoria's one, the court must disallow a question put to a witness in cross-examination or inform the witness it need not be answered, because the question might, of course, already have been asked, if the court is of the opinion that the question is misleading or confusing, unduly annoying, harassing, intimidating, offensive, oppressive, humiliating or repetitive. That word unduly is there because sometimes that is the point of a cross-examination. Is put to the witness in a manner or tone that is belittling, insulting or otherwise inappropriate, that is being rude. And there's a further one, has no basis other than stereotype, a particular concern in Australia, not appearing in the Maldives provision. The Maldives provision, during the cross-examination stage, the court may order the witness not to answer the question or to stop a question being asked of the witness. It's a little stronger than need not be answered, in the following circumstances. The question is asked in a manner that misrepresents the fact. The question is asked to annoy, harass, intimidate, offend or belittle. The question that is asked bears no relevance to the matter contained in the testimony given by the witness. So that's a bit of a subject matter constraint and perhaps a slightly controversial role for a judge. Or, and this is just straight out, the question was previously asked. That's a very blunt rule. You can't ask a question twice, the witness will be told not to answer. That can't be the practice because, of course, sometimes you do need to repeat questions for clarity or for emphasis or to give a witness a chance to correct an earlier statement. Though I think there is an argument that those later sorts of repetitions aren't actually repetitions. They're follow-up questions, so there is that distinction. All right, the Maldives Evidence Act gives some examples, but the examples are a little odd. It says an example of an annoying question is a repetitive question, but repetitive questions simply aren't allowed at all. The Australian Act actually has some explanation that says some things that aren't improper. So it's not improper to tell, a question isn't improper simply because it accuses the witness of being a liar or dishonest. And of course, that's the bit that many witnesses hate the most, is a bit accused of being a liar, but we all know that that's at the heart of cross-examination. It's a key part, it's required for fairness. So that isn't improper in Australia. Also not improper in Australia, the fact that the subject matter of the question is about an embarrassing or humiliating matter. That is, of course, also witnesses being forced about things they would rather not talk about, especially in public, is a fact of life in the courts. That is specified in Australia, but is not specified in the Maldives. A thing I want to say generally about these provisions is that these are often talked about in Australia and other jurisdictions that have followed this model. They are actually part of public discussion in Australia. Every time there's a high-profile trial and someone endures a terrible cross-examination, the media asks, why isn't the judge applying Section 41 on improper questions? It's the most publicly discussed evidence law provision in Australia. It's also discussed in academic and policy and stakeholder circles. For example, advocates for victims of crimes, particularly sexual crimes, ask about this all the time. But there are almost no cases on this provision. No rulings by higher courts on whether a judge should or shouldn't have stopped a question. It's almost silent on this issue in the case law, despite 30 years of having this provision. And I think there's a similar pattern in other jurisdictions. Why? It's because, in Australia at least, judges are reluctant to use it. That might be originally because the judges were former barristers who were used to asking these sorts of questions themselves, and they defended themselves and said there's nothing wrong with them. But more recently, it's because of the concern you raised, which is particularly for defendants, cross-examination is their main tool to defend themselves. And judges are reluctant to stop that tool being used. Partly their view is if the defence lawyer is being badly behaved, the jury will punish the defence for that, The judge doesn't need to step in. That is probably also true of judges in some situations. So the further reason is the judges in Australia say, we are scared that if we stop questions, then although the trial will be resolved, an appeal court will say you shouldn't have done that. They don't want to be the judge who derailed an entire prosecution because they stopped one question or a series of questions. They'd rather, there's far less risk to the integrity of the appeal by letting the question be asked than by not letting the question be asked. So to some extent this is a failed reform because it was meant to give judges an active role, but they keep saying they're reluctant to use it, and they almost never do. That isn't to say they don't intervene at times, but they rarely apply this provision. They simply give a little admonishment to the lawyer. Maybe you need to tone it down, or let's take a break, or that's enough of that, without expressly saying this question is disallowed. So the question is whether a similar approach will happen in the Maldives or whether a stricter approach will occur. This ban on previous questions that were previously asked is expressed in mandatory terms. Well, no, sorry, I'm wrong. May order the witness. So no, it isn't expressed in mandatory terms. That term may, I guess, gives the court that discretion, but it's expressed in stark terms. And notice that there's no ban on simply repeating questions in Australia. The question is whether the repetition itself is unduly annoying, harassing, intimidating, offensive, and so on. I want to talk about one last bit before we take questions and then stop. And this is the other question I got asked routinely about, the law on what are now called, in Australia, unfavourable witnesses, and the English translation in the Maldives is uncooperative witnesses, though I don't think that's an ideal translation, perhaps an accurate one. This is another innovation from Australia that has been clearly adopted in almost identical terms in the Maldives. So this is an area where the Maldives, at least partly, should be guided by the Australian approach, and there are Australian decisions. So this is what used to be known as hostile witnesses. And everyone is familiar with the term hostile witnesses. It's a term that even has made it into the wider population. Lay people know about this idea. As you're all well aware, the idea is that sometimes a witness you call becomes your enemy, and so in that situation you can't effectively examine them without leading questions, and so you get permission from the court to put leading questions. As well as that, it also allows you to attack the credibility of your own witness, something that's otherwise either forbidden or very difficult to do. So that's the purpose. That's not changed in these two provisions. What is changed is when it can happen. So the old idea of hostility is you convince the court that the witness hates you. Hate is probably too strong a word, but something like that. This is a witness who has turned against you, is not helping you, is not doing what's meant to happen when you call a witness, which is assisting you in getting information out to the court. Of course, witnesses aren't obliged to help a party, but they are obliged to answer the questions the party is asking. All right, that is not the approach under this provision. It's much, much broader. In both jurisdictions, that old approach, hostility, is dealt with in the middle of the three options. So in the Maldives, it's where the court finds the witness is uncooperative in giving truthful information in respect of something believed to be clearly within knowledge of the witness, or is hesitant in testifying in good faith, or not putting in sufficient effort to testify in good faith. That goes a little beyond hostility. This is just a witness who isn't trying. Okay, and the same, obviously similar language, a genuine attempt to give evidence, appears in the Australian provision. They're basically identical. But that's just one of three options. The first option is quite different, where the witness testifies unfavourably against the party who called the witness. This is a witness who may well be trying to give genuine evidence, who is trying to help, but simply says something that hurts the party who called them. And that is sufficient under Section 105 of the Maldives Act, just as it is in Australia, for a court to exercise a discretion to allow cross-examination via leading questions and a credibility attack. All right? So that's a second option, and that's why the Australian provision is called unfavourable witnesses rather than hostile witnesses. And then there's a third option, inconsistent statements. So this witness is simply one of those witnesses, and there are plenty of them, who doesn't always say the same thing. All right, and at that point, it gives the option of the court giving leave to the party to lead and attack credibility. All right? So this is an area where I think the change of terminology is important, and that using the old terminology is dangerous. There are plenty, and this happened all the time in Australia and happened in Barbados and elsewhere, judges would say, oh, so this is about hostile witnesses, and then they would look confused or chagrined when someone says, no, that's not the problem here. This witness simply said something that doesn't help us. The witness is there trying to be helpful. They're clearly genuinely trying, but we want to be able to lead this witness and ask questions. If everyone keeps using the term hostile or the local equivalent, there's a danger that this much broader approach will be ignored. And it is clear in this situation that a broader approach is intended by Section 105, deliberately adopting the Australian approach, which was clearly intended to be broader and has been accepted by the court, of course, as being a good deal broader. Effectively, you could have a witness who satisfies only one condition but not the other two. You could have a witness who is helping, who is testifying favourably to the party who called them and is being consistent, but is not trying hard enough. That's enough. You could have a witness who is trying hard and is being consistent, but simply gives an answer that hurts the party. That is enough. You could have a witness who is giving favourable evidence and is trying hard, but isn't always being consistent. That is enough. Okay, and that is completely different to the old system of hostile witness. It is much, much broader. I want to draw attention to one potential difference between the Australian and Maldives approach, which is that the third option in Australia is whether the witness has at any time made a prior inconsistent statement, and there's a term of art meaning a statement made before the proceedings that is inconsistent, an out-of-court statement. The Maldives version in the English translation, and I'm told that the original is less clear, but is not clear either way on this, where the witness makes inconsistent statements during testimony. And that means a witness who is saying one thing and then another during their examination. All right? That's a different condition. My understanding is the original is a little bit more ambiguous about timing, but could be interpreted either way. That is a significant difference if it could be interpreted in that narrower way. All right, so that's the only one I want to draw attention to. But the main reason I'm talking about this one is because it is a dramatic change and is intended to be a dramatic change and will shock many who are used to the older system. For example, the prosecution may call a witness knowing the witness is going to say something that hurts them. And that happens in Australia. In fact, prosecutors are required to call all sorts of witnesses in Australia that might hurt them. That's not the rule in the Maldives, but still. The courts have ruled in Australia that even when the prosecution is not taken by surprise, they expect this to happen, they can then be given permission to lead the witness in cross-examination. So the Australian courts have wholly embraced an entirely new approach to witness examination imposed by this provision. My belief is that is the intent of the Maldives provision, but some will resist it because it seems to be against an expected practice. All right. We're done. That's tomorrow. That's the afternoon session. So we have time for questions before we go for lunch. Yes?
I have two questions. Shall I?
Do you want to do a microphone?
Yeah.
Yeah, sure. Where?
Two mics.
For the tape, I guess.
I have two questions. One about the police statements. Specifically to do with how a police statement is taken and what the Act intends to refer to. It's common practice in the Maldives that after a police raid, an incident report is drawn up, and based on that incident report, that the content of the incident report is informed by diverse portions of information provided by various officers. And then this incident report is used as the basis for all statements that are then signed by each individual officer. So it's not the fact that all of the officers are actually aware of all the facts, but the statement is kind of a summary drawn up by a separate person altogether. Is this what the Australian Act refers to as a written statement by a police officer? Is there a difference?
No, that's a very good question, and of course we're all familiar with the problem that the police officers will talk to each other to make sure that they all say the same thing. And of course the courts have some awareness of that, but the jury might not. So unfortunately the terminology in Australia is a written statement previously made by the police officer. It makes no reference to the possibility that the written statement is itself a compilation of others' views. The way this would be dealt with in Australia is that there might be questioning to try and work out what this police officer specifically saw, and to the extent the police officer, in reading out this written statement, is referring to things they didn't personally see, the hearsay rule would then be applied. So that's how that would be dealt with in Australia, but that's not particularly satisfactory because, of course, how would you know necessarily that the police officer has done this or is being clear? They might not even know, in fact, what they saw personally and what they were told by someone else. So all I can say is the language doesn't address that issue. It pretends, perhaps, that every officer writes their own statement. I should mention that my understanding, and it's only very indirect at police practice in Australia, is that this incident report being used by multiple police officers, that is not acknowledged as a formal part of the policing process in Australia. Police officers routinely get in trouble with courts, even disciplined, if there is evidence that they have collaborated on a statement. Major criminal cases in Australia, hard-fought ones where, for example, police officers have been killed and a very lengthy trial is held, have been overturned in one case 20 years later after the discovery that someone altered their statement in response to what another police officer said. So to some extent the answer in Australia is the courts hate this practice and they take enormous steps whenever they discover it to stop it, and I think to some extent the police have taken that on board. But no, it's not expressly dealt with in this. In fact, it's facilitated by this provision. So hence the controversy. As I mentioned, Barbados, they had big fights about this. That Caribbean Court of Justice provision statement case was specifically about that kind of problem. I should also mention the other thing that might be in a police statement is it might record someone's admissions, and yet the person will deny making them, and yet it's being read out. In Australia and in the Caribbean, it is understood that where a police officer is recording what someone else has said, the hearsay rule will still apply to use the other person's statements. Specifically in the case of admissions, the rules that govern admissions would still have to be followed. That's what the Caribbean Court of Justice ruled. That is the express approach in Australia. So I can't give you a better answer. And I certainly, an interesting question is whether the Maldivian version in its original form is somehow clearer about this. I think the ultimate answer is that this is a matter for cross-examination, with the caveat that we all know the cross-examination might not be effective.
Potential for collusion exists, and
Yes.
ultimately the discretion lies with the judge.
Yeah, and this is true for all witnesses, though, of course, it's more extreme because of these provisions for police officers. And again, in the Maldivian version, where it seems to allow the judge some discretion, there could be submissions to the judge that this risk means that the witness should not be allowed to look at their statements. I mean, there are ways to manage this. Let them testify first, then read their statements. None of that deals with the problem that they've, of course, looked at the statement outside the courtroom.
To address that, if I could ask a follow-up question. I think our experience is unique in one way from the Australian one when it comes to this piece of legislation, because we're trying to move away from a very recent past where the courts were at the lowest tier of the justice system and subordinate to the prosecution and also the Attorney General's office. It was only very recently, in 2008, the courts became independent and stopped being, subordinate to the Attorney General's office or the prosecution, because the prosecution existed within the Attorney General's office. Most of the judges still come from the culture, and these vestiges do exist in practice. Is it advisable? Because why I mention the context is because of that, judges are hesitant to question the findings of police or to even hint at the possibility of police collusion. I was once given a strict warning by the High Court bench when I spoke of the possibility of police collusion, that I should not be speaking in such a manner which would cause disrepute to a public institution. So cross-examination is often limited by these sorts of strict warnings from judges and interventions. In such an instance, should we be looking at legislative guidance for the judges to move away from the culture, or should the handbook address such things? What kind of solutions do other jurisdictions use?
I mean, the handbook is a matter for the Prosecutor General's office, but and it's meant to be a descriptive, informative, educational handbook rather than a policy document, though of course there's sometimes a blurring. I think part of your question relates to whether it's appropriate for the Maldives to pick up provisions that are developed in other situations. So I should say that when this provision was written in Australia, you could sort of say the same thing about Australia and its deference to police. So the big issue in Australia was, as I'm sure it is at times here, the police say that someone made a confession, but the suspect says, I never said that, or it was the product of violence or something like that. And there was a large phase in Australia where the courts would just dismiss that out of hand, regard it as outrageous and so on, reluctantly let the defendant make the claim but then denigrate the defendant for doing so. And then that changed. And the reason it changed is because of high-profile miscarriages of justice, where it became obvious that the thing that the defendant confessed to couldn't have even happened. At that point, you start to believe them that maybe they didn't make the confession or didn't want to make that confession. That lesson got taken on, and Australia's top court, the High Court, became a leader on this. In a very divided decision, they ruled that they invented a new warning to juries that it is dangerous to rely on uncorroborated evidence of police officers, which is extraordinary. It's the kind of warning that used to be given about prison informants or about, sadly enough, complainants in sexual cases, and police officers were bundled in. It was hard fought because some of the judges said it's inappropriate for the courts to turn against the executive and do so, but the majority said no, it's appropriate for the courts to call the things as they see them. So that process went through. And that decision again of the Caribbean Court of Justice was the Caribbean Court of Justice telling the courts of Barbados, you should follow that approach from Australia because the Barbados Parliament has followed it. So this isn't a good example here because this is a very facilitative of police officers, but to some extent drawing on other jurisdictions could lead to that change. But ultimately, I think the real driver of that change is a change of attitudes that comes typically from experience. Everyone now knows that identification evidence can go terribly wrong. There will come a point when everyone will know that police officers can go wrong. The answer I will add the other bit of that in Australia is that the particular problem of claims of of disputes about whether someone confessed or not was partly dealt with in Australia, as I'm sure it can be here, by recordings. The police initially resisted recordings. They didn't want to be recorded, but they now love it. They see the recordings as protecting them because they are not open to someone falsely claiming that they were forced to testify. Recordings have their limits, mind you, but the police came around to that. And to some extent that could happen with the wider problem you're discussing. The police might like the idea of being able to collude, but if there are processes in place within the police that reduce that chance and disciplinary actions when the police do collude, that ultimately makes it easier for the police to be credible in court. Because they can say, of course I didn't collude. If I colluded, I would lose my job. And they would be credible in saying that. So that's, to my mind, where the cultural change comes. But I do think it is a reason to be careful about adoption of other jurisdictions' approaches. So I don't think that's a complete answer to your question.
My second and last question has to do with subject matter limitations of cross-examination.
Yep.
A very controversial issue here in the Maldives because we're only starting to creep towards a situation where the defense can actually really attack the credibility of witness or really get at the heart of the problem. Right now, the current interpretation of the Evidence Act is that the defense is only allowed to clarify a statement already given during testimony. We're not even allowed to step on new territory based on the subject matter. Is this the same in the Australian Evidence Act? Or
It is.
there vast differences?
It is not the same in the Australian Evidence Act. I'm familiar with the provision you're talking about. I think it's Does anyone remember the number? Do you remember the number? Let's put sorry? 99, yeah. So the problem is 99B, a witness shall be cross-examined only with respect to the matters contained in their testimony during the stage of examination. There is no such limit in Australia, and it would be regarded as a wrong limit. I should note that there is, 99A is a bit at odds with this. So it says the chance to cross-question the witness about previous answers, to check the accuracy of the answers, question the witness about inconsistent answers, those two are consistent, and to acquire useful information from the testimony. That last bit is inconsistent with B in my reading. And I don't think I'll venture into policy, I don't think it's an appropriate limit. In any case though, when I look at B, I think there is different ways it could be read. So for example, a question about the credibility of a witness is also in part a question about their testimony. So to some extent, any credibility question, even a question about whether they've lied on a separate occasion, is about their testimony now. It's about whether you can trust their testimony now. A harder question, and this is where I get more disturbed by 99B, is what if the witness has witnessed something else the prosecution hasn't asked them about, but the defence wants to ask them about? In a straightforward example is an expert witness. Sometimes defendants can't afford an expert, so the prosecution uses the expert for one thing, but the defence thinks, well, now I've got the expert on the stand, I'm going to ask them about some other things that help my client, which might be entirely separate from the testimony. That is very common in Australia. It seems sensible as a way of sharing resources. It's actually good information because the fact that the expert is willing to help the defence seems important to it's better than the defendant hiring their own expert who might be a gun for hire. So yeah, I do think this is very problematic, 99B. One option, but it seems a weird one to deal with this problem, is that there seems to be no bar on the defence calling the same witness as their own witness. Of course, they can't lead unless they have that witness declared unfavourable. Perhaps that could happen, but nevertheless, that is an opportunity. It seems clumsy to me, but it is an opportunity to deal. That is subject to constraints on late changes to who you're going to call, because I understand there's a system of notifying of witnesses and the like. But that is a partial answer to this. But no, I don't think this is appropriate. I'm not aware of other jurisdictions which have similar limitations, and it doesn't make sense to me. Cross-examination is just a heightened form of examination. It's not a narrower form in any way. The only limit on cross-examination doesn't appear for examination achieved in this system, in most systems, is the ban on improper questions. All right, so what I actually got on the screen, two things. On the left-hand side, there's a diagram which is contained in Australia's Uniform Evidence Law. This is part of the statute. It's not a guidebook, it's the statute itself. And I should actually mention, for what it's worth, that the Australian Uniform Evidence Law, most of the versions, are full of guidance. There are notes, there are examples, very brief examples, mind you, but still examples. Some examples I even disagree with, but that's another matter. And lots of cross-referencing. So, for example, when the hearsay rule is mentioned in the Uniform Evidence Law, there's a note saying, there are exceptions to this rule, and it lists all the exceptions in the Act so that someone can find them. You could say that it does make the Act a lot longer and sometimes harder to see the specifics amongst the rules, but it was designed with, the drafters wanted everyone to be able to apply it as easily as possible. And so it also includes a diagram. This is a diagram for Chapter 3 of the law, which is the admissibility of evidence, the assessing evidence part of the law, and it's just a complete guide on how to apply it, with a lot of detail hidden inside it. And as you can see, the very first question is the evidence relevant? If yes, you continue. If no, you go to the box on the right-hand side that says the evidence is not admissible, can't be used. Yes, you just get to a new question. Does the hearsay rule apply? And it gives a guidance to which parts you have to look at. There's a part on the hearsay rule, but then there are also major exceptions in another part on admissions and another part on character, which I'll get to. I won't be talking about admissions today, but I'll get to character. Yes, if the hearsay rule applies, and that means applies without exception, then the evidence is inadmissible, can't be used. If not, you go on to the opinion rule, and so on. And this is a very simple diagram, but is meant to make it clear that every piece of evidence has to get through multiple hurdles before it can be used. In practice, you know instinctively and you know intuitively after a while that most of the hurdles won't apply, or there are exceptions that apply, but this is the practice you have to go through to rigorously apply the Act, and it's intended to work this way. It's only at the bottom, right underneath, should a discretion to exclude the evidence be exercised or must be exercised, because some of them are mandatory. If no, then finally you get to the last line, the evidence is admissible, the evidence can be used. All right, so that's the pattern expressly in the Uniform Evidence Law. There's a bit of a debate about whether these diagrams are binding or are simply helpful explanations, but I'll leave that aside. And although there are no similar diagrams in the Maldivian Evidence Act, my belief on reading the provisions is that by and large they work the same way. That is, that every piece of evidence must get through multiple rules before it can be used. That makes it sound very onerous, but like I said, it's mostly straightforward. Many of the rules are straightforward for most pieces of evidence. Because you have to get through every rule, it's important to recognise that getting through a rule and being an exception to one rule is not enough for the evidence to be usable, because it still might be caught by another rule. I think sometimes we tend to divide in our head a classification of evidence which is not in the Evidence Act, it's not in the classification sections, that evidence is either hearsay or opinion or credibility or tendency, as we'll get to, and it has to be one or the other, and so you just work out which one it is and then you apply that rule. But I don't think that is correct. It certainly isn't correct in Australia, and I don't believe it is correct in the Maldives either. Rather, one evidence can engage every rule. So, for example, evidence that the defendant's employer comes to the court, gets asked about the defendant, and says, "Yeah, I've asked around about the defendant, and everyone says that they are not a trustworthy person. They wouldn't trust them." Very straightforward thing. We hear people say this in regular life outside courtrooms all the time. We rely on such statements. If someone you know who you trust says that they've talked to people and they say someone else is untrustworthy, you act on that, all right? But for a court it's more complex, because that little piece of evidence is hearsay about an opinion, about a tendency, about credibility, right? Out-of-court statements about other people's assessment of a person's behaviour in terms that reflects on their credibility. And that means that the evidence has to satisfy 4 rules. The hearsay rule, and that means there must be an exception to the hearsay rule, the opinion rule with an exception to that rule, the tendency rule with an exception to that rule, and the credibility rule with an exception to that rule. Okay, so that's the burden of evidence law. Is it's not just a matter of going to the relevant part of the Act, you actually have to apply the whole Act, mostly done intuitively and instinctively and quickly, but the rigour is that you do go through each of them. This is me with my teaching students hat on, is to remind people not just to jump to a particular section of the Act. Of course, even in the example I gave, you would all know a subtlety. It depends on what the evidence is being used for. And in many instances, what looks like hearsay evidence isn't hearsay evidence because it's being used for a non-hearsay purpose and so on. That might be true in the example I gave. So some of the examples in the Evidence Act have that problem. It depends on what you're using that evidence for, and yet the example just says the opinion rule or something would apply. So part of the reason I want to go through a scenario is because then we aren't just talking in the abstract, we aren't just talking in one-liners, we're talking about a real case where you can understand the uses of particular evidence, and there might be more than one use. I've put on a blue dot just to note the 5 rules really I'm going to be talking about. So I'll start with hearsay, then talk about opinion. I'll actually jump, to credibility and then end up with tendency and coincidence. The order does not matter. And actually, sorry, probably should have pointed out, despite this chart looking like it has a set order to deal with things, there is no set order in the Act, and everyone accepts that you could apply these rules in any order. All right. So I want to leave tendency and coincidence to last because it's the least familiar and in some ways the most interesting of the rules. So who's that on the right? Her name is Erin Patterson. And so this is the case I mentioned in the morning. In 2023, she organised a lunch at her house in a small part of Victoria, not Melbourne where I live, but a couple of hours away in a small town, a pretty town. She lived there, and she invited a number of people to lunch. 4 came to lunch, and they were her husband's parents, Don and Gail Patterson, and Don Patterson's brother and the brother's wife. So her husband's uncle and the husband's uncle's wife. They were Ian and Heather, I think Wilkinson. I hope I've got that name right. So 4 people came for lunch, and Erin Patterson was the 5th person, and she cooked. And I'm sure, I understand this story has got attention elsewhere. When the trial was on, there were hundreds of international media in this small town in Victoria, in a courtroom which was absolutely tiny, so it was quite a burden on everyone following this case, and it was carefully followed by everyone in Australia. So the story, of course, is that 4 people at the lunch, everyone had lunch, the 4 people went home, and they got very sick overnight. At first they thought they just had mild food poisoning of the sort that just gives you a terrible night but is not actually life-threatening, although they were all old people, so it's not a minor thing to get serious food poisoning. But eventually they realised the situation was worse, and they went to a local hospital, and the hospital quickly started to suspect that they had been poisoned by mushrooms. So mushrooms are widely eaten in Australia as they are elsewhere. You can buy them in supermarkets in a variety of sorts. You can also buy specialty sorts, but they also grow out in the countryside in various spots, and there are a variety of those. I don't do this, I'm too scared of this sort of thing, but lots of people do pick wild mushrooms, and the reason I'm scared of it and careful about it is that there are some mushrooms which are poisonous. And the most notorious poison mushroom in Australia and elsewhere is the aptly named death cap mushroom. And it's a good name, it's a good health message, because there can be no doubt that this is simply something you should never eat. Its effect is it introduces a toxin to your system which destroys your organs. It eventually clears out of your body, but your organs are gone by the time it clears out. It's reputed to always kill, although there's a debate about that, and in fact in this case it didn't always kill. The 4 people who got sick, 3 died, one of whom died even though they were given a liver transplant in an attempt to save their life. But the 4th one, who was also given a liver transplant, miraculously survived. He was expected to die. The treating doctor testified at the trial that he was shocked and couldn't believe it when this 4th person survived. After a clearly terrible time for many months, and he's still not well, but alive. But of course, the survivor has lost his wife, and his brother, and his brother's wife. Erin Patterson's husband, who she was estranged from, they were still married, but they had been living separately for several years. He lost his parents and his uncle, and his uncle's wife, but his uncle survived. So at first, this story in Australia was just a story which is unfortunately a bit familiar, that someone made a terrible error and a whole lot of people got deeply sick. This happens every now and then. It's not common, but it's not that surprising either. People do forage mushrooms, they make mistakes. But 2 things made everyone really suspicious. Firstly, Erin Patterson did not get sick. She certainly didn't get anywhere near as sick as the others. She definitely didn't die. And yet she ate the same meal, and it became obvious that the meal was the source of the problem, because the meal was called a beef Wellington, which is a large piece of beef wrapped in pastry, but with a sauce in between, and the sauce is typically a mushroom sauce. In fact, she used a popular cookbook in Australia, which I also own, which has a detailed recipe for beef Wellington, and yet she didn't get anywhere near as sick. And so that was the first suspicion. And the second was, and this became notorious in Australia, that she disposed of some of her equipment in the days afterwards. So she had a dehydrator, sort of device that you use to dry picked food, and she threw it out in a public rubbish tip, an area where you go to throw out rubbish for a fee, and that was all recorded on closed-circuit television camera, so that news also got out and everyone started to suspect her. She put out a statement saying this is all a terrible accident and she's very sorry, but she does wish that everyone would stop calling her a murderer. But that did not work, and she was eventually charged with 3 counts of murder and actually several counts of attempted murder, but the relevant one was the attempted murder of the surviving person. So that's the story, and that's the one I want to use just to draw out examples of some of these cases, because I'll draw on some of the evidence that came out, as well as some other evidence that was not used at the trial. All right, so let's start with the hearsay rule, and this is where I always start the rules of evidence in Australia. It's notorious as a difficult rule, so I try to get my students to get on top of it early in the course. All right, and in the Evidence Act, it does appear early in Chapter 3 of the Evidence Act. All right, it's I put the Australian rule at the bottom. It's a little more complex, the way that the rules are described in the Maldives Evidence Act. In Australia, the rule is set out in Chapter 3, but in the Maldives Evidence Act, a lot of key terms are defined in Chapter 1, which sets out key concepts. And so Section 24 of the Maldives Evidence Act defines hearsay evidence. And it says hearsay evidence means evidence given by a witness based on what has been reported to the witness by another person, as seen, heard or experienced by that person, rather than what the witness themselves has seen, heard or experienced. This would be a familiar kind of definition to everyone, and you'd all, I'm going to assume, are aware of the purpose of the hearsay rule. The idea is, of course, that that other person should be available to the court. They should be on oath, and therefore subject to the consequences of breaching an oath if they're lying. They should speak in the courtroom, and therefore allow judges to do something which everyone thinks they can do. I don't know if it's true. Tell by looking at them whether they're being honest or not. I'm not sure that is actually a real skill, but people believe they have that skill. And third, and I think this is the one that's dearest to everyone's hearts, be subject to questioning by the other side to make sure that you test. And these are all things you can't do if the person, of course, doesn't come to the courtroom and instead the court hears about what this person said in some other way. All right, so for example, that employer who said, lots of people say that the employee is dishonest. Who are these other people? Maybe they're people who are enemies of the accused. Maybe they're people who are themselves dishonest. Maybe by dishonest, all they mean is isn't friendly around the office, rather than, or doesn't go to parties or something, doesn't go to functions, sorry, or the like, or isn't a good worker, rather than actually dishonest, shouldn't be believed. And you can't clarify it with those people because they're not there. You all know this purpose of the rule. So that's the definition used in the Maldives. I think that there are some contrasts. It does not follow the Australian definition. The Australian definition, which is actually written in a quite technical way, says evidence of a previous representation made by a person is not admissible to prove the existence of a fact that can be reasonably be supposed that the person intended to assert by the representation. That's a very much more technical, less accessible definition, but it is also a different definition. So if I could break it up a little, it says evidence of a previous representation. It doesn't say evidence given by a witness of a previous representation. No matter how the court learns about the previous representation, and I'll say previous representation just means the out-of-court statement of a person, the hearsay rule applies. And I think one difference at least is that the Australian rule clearly covers documents, written documents. A written document where someone writes something down, here I've got one here, appointing me as an honorary associate of the Prosecutor General's College. This is evidence of a statement by the Prosecutor General that if the court got to read this document, they would not have the Prosecutor General in front of them, not speaking on oath, they wouldn't be amenable to cross-examination, all they have is a document to look at. It's the same as having someone else describe what the Prosecutor General said. In Australia, the intention is that whether the court learns about a previous representation from a document, or from a video, or from a chain of information, or anything like that, it's all governed by the hearsay rule. But the English wording of section 24 seems narrower. It's only when a witness tells the court what someone else said, a document is dealt with potentially differently. Now, with a caveat, there are special rules about the use of documents that might narrow the effect of this, but that does seem to be a difference to me. So just to give you an example from the case, on the top left side of the screen, there's a diary entry from one of the deceased people at the lunch. And the diary entry just said, lunch at Erin's with Heather and Ian. I think it was from Gail Patterson, one of the husband's mother who died. And so that is not evidence given by a witness. There's no witness around. You just hand that document to the court. There might be a witness who says, here's where I found the diary, but they have nothing to say about the statements inside the diary. They might not have even read it. It's a big book, right? But the court looks through it and reads that and thinks, oh, okay, this gives information. It's not controversial information, mind you, about the plans for lunch. All right? And in Australia, that would be evidence, the document, of a previous representation. Gail Patterson writing down the words lunch at Erin's with Heather and Ian, made by a person, made by Gail Patterson, which cannot be used unless an exception applies, to prove what? The existence of a fact that can be reasonably supposed the person intended to assert. What did Gail Patterson intend to assert when she wrote down lunch at Eric's with Heather and Ian? Well, she intended to assert, I guess, a couple of things. One, that she was planning to go to lunch. Secondly, perhaps that she'd been invited to lunch. Third, that she'd been told that Heather and Ian were going to lunch. She surely intended to assert all of those things, and therefore that would be covered by the Australian hearsay rule, unless an exception applies, and of course there will be exceptions. I'm less sure that it would be covered by the Maldives hearsay rule, because it is not evidence given by a witness. All right, it's just in a piece of paper. There's another difference between the two rules. In Australia, as is typical with a hearsay rule, not all out-of-court statements are hearsay. It's only hearsay, whether it's hearsay or not depends on what is being used to prove. If you are trying to prove that the person who said the words saw something or heard something or perceived something and what they've said in the words did actually happen, that is a breach of the hearsay rule. That is hearsay evidence. But you might be using the words for lots of other reasons. Those words might have had an effect on someone else, or they might have significance in and of themselves in some other way, whether or not they are true. All right? And so there are situations when people can say things where the words are important, even if they're false, or even if they're not true. All right? So I haven't put it up on the screen, but part of the history of this case was a series of Facebook posts, text messages, where Erin Patterson, the accused, was in a fight, a small fight, I don't want to exaggerate this, about a family law issue, how much child support should be paid, who should pay for the schooling of their children. And so they talked about it, and eventually they said things a little harsh about each other, and Erin Patterson spoke some harsh words about her in-laws on a Facebook page, because she was friends with a bunch of people who she discussed true crime with, and she posted those words on that page. None of those words are being used because they're important because they're true. No one cares who was the correct person in this fight about child support. No one even cares if there was a fight about child support. What mattered is that Erin Patterson acted as if there was a disagreement, and that then provides a possible motive for her actions. It's perhaps worth me mentioning at this point, when the prosecution went to trial with the trial against Erin Patterson, they went there with a lot of evidence against her, some of which I'll describe today, but they said at the start, we don't know her motive. We simply don't know why she did this, and in Australia that is no bar to a prosecution for murder. If you kill someone for no motive, you're pretty much just as much a murderer as if you kill someone for a motive. Quite whether you're worse or better, I don't know. But there's no requirement to prove motive. Motive is often a good way of proving someone is a murderer, but it is not required. And so the prosecution took on the burden of proving that Erin Patterson was a murderer without being able to suggest a motive, though they did bring up this evidence of this mild, and it really was a mild dispute about who to pay for schooling as part of their case. All right, so when you look at these true rules, the Maldives hearsay evidence definition is not limited by the use of the hearsay evidence. Any time a witness says what someone else has said and has experienced, what someone else has experienced, that will be hearsay evidence. All right, even when what is being said is not being used to prove the truth of what that witness said. Australia is clear that not only must it be used to prove the truth of what they said, but what they intended to assert. If they unintentionally gave away information in Australia, that is not governed by the hearsay rule. I put down in the bottom left, that's the survivor of the lunch, well, the two survivors of the lunch, but this is the one who got sick and then survived. And so there's one further difference to cover. Notice that it says evidence given by a witness based on what has been reported to the witness by another person. In Australia, the rule is evidence of a previous representation made by a person is not admissible to prove the truth of what that person said. And that formulation includes prior statements by the same witness. So, for example, the survivor of the lunch, Ian Wilkinson, he testified in court because he'd recovered enough to testify by the time of the trial 2 years later. He, of course, described what he saw at the lunch, but he was also asked about and described what he had previously said, because he and it turns out the other victims of the poisoning said a few things while they were sick in hospital that turned out to be really important in the case. They described the lunch, and they described some suspicions they had, even at that early stage, about Erin Patterson. They thought it was a weird invitation to lunch because she was very insistent on it. They said that she said the purpose of the lunch was to tell them all that she had cancer and that she wanted to consult with them about it, and they thought that was an odd thing to do, and it didn't sound right. They wanted to say that, oddly, although beef Wellington is usually served as a big log, you made as a big log, and that's what the recipe book said to do, which you then slice up. She created individual beef Wellingtons for everyone, and they also wanted to say that there were 5 plates for the lunch, 4 of one colour, 1 of a different colour, and that the 4 of the one colour were given to the 4 people who got sick, while Erin Patterson had the 5th one, which was a different colour. These are highly important statements that really did bolster the prosecution case. And in the case of Ian Wilkinson, he was able to come into court and say those things. But crucially, he was also allowed to tell the court, the prosecution wanted to tell the court that he had said the same things very early in his illness. Why was that important? You all know the reason for that, because it's possible that his memory 2 years later has been affected by what he's heard. But at the time of his illness, he wasn't so affected, and so what he had to say then could be more relevant. It's also possible that he no longer remembers very distinctly, but he had better memory back at the time. Of course, he was deeply ill, so it's a little complex, but the earlier statements were really important. In Australia, they were nevertheless affected by the hearsay rule. He wasn't allowed to tell the court what he earlier said unless a hearsay exception applied, and there are exceptions for this situation in Australia, but with conditions. But I think in the Maldives, he would be allowed to say what he previously said without it being hearsay evidence, because he is not he's not giving evidence based on what was reported to him by another person. He's just saying what he recalls saying in the past. All right. My students struggle with the idea that the Australian hearsay rule covers the prior statements of the witness in the court. What they say is none of the purposes of the hearsay rule are served by excluding those prior statements. The person is now speaking on oath, the court can now see them talk, and they can be cross-examined. But the approach of Australia says, yes, that is all true, but if all they are doing is relaying what they previously said, and they may no longer remember it, then none of those things are effective. They are not, if they recall saying words but no longer recall what they were, the actual details, and those earlier words turn out to be false, they are not guilty of perjury because they are telling the truth, what they said previously. If when they say the words, when they repeat the words now, we don't get to see them what they said when they said it back then. We don't get to watch whether they were being honest back then. We get their own recollection of what they said. And cross-examination is, at the very least, much less effective when the witness just keeps saying, yep, that's what I said, I don't remember now, but I remember saying it back then. So the Australian approach is all those problems, those factors are still a hearsay problem, and you should have to come with an exception. But I think the Maldives is a bit narrower. Assuming this is a correct translation, the Maldives hearsay rule is narrower. And here, sometimes I think, oh, there must be an error. But I don't think so this time, because the Maldives approach, where the witness's prior statements are not covered by the hearsay rule, is actually also the approach in New Zealand, a hybrid jurisdiction which partly follows Australia but partly goes its own way, and is also effectively the approach in England. So the Maldives is not alone in doing this, but it is separate from Australia. That's all I'm observing there. All right. So, I've now got to the exceptions. I think I probably should have included the specific wording of the hearsay rule, but I think the wording of the rule just says, subject to this act, hearsay evidence is inadmissible. So let's get to the main exceptions in the Maldives. And here I've only got the Maldives on the screen. I haven't put Australia up because it's quite important to read these two sections together. Section 118 in its English version is titled Admissible Hearsay Evidence. All right? And it says the following hearsay evidence may be admissible under this Act, and it has a big long list, and I've only included 3. That's why I put ... afterwards. I don't want to put them all up on the screen. And so you can see some of the exceptions. You'll be familiar with these. A statement made by a person on their deathbed about some fact or matter, and of course in this case there were statements made by 3 people on their deathbed. This is not quite the same as dying declarations. There's no requirement that they are under settled expectation of death and the like, but deathbed is clear enough in this context. There's a second exception to prove the existence of a circumstance where the witness observed the person make a sudden statement, reaction or gesture in response to a sudden incident or circumstance. This is part of what used to be called the res geste. It actually seems to be in similar terms to the Federal Rules of Evidence in the United States has an exception for spontaneous reactions. So it's of that genre. All right, and a number of in the aftermath of the lunch, when people started getting sick, a few people started saying things very suddenly recorded the thing about the plates, suddenly said they had suspicions. Erin Patterson's husband said to Erin Patterson, "Did you try to kill them?" So those sorts of statements could fall within that particular bit of the exception. It also, and the wording's a little odd here, evidence may be submitted by a person in the form of hearsay evidence to the court to prove an incident where the observation of persons present during the incident were conveyed to the person by those present at the time of the incident. So of course there were 5 people at lunch, 3 of them aren't around to talk anymore, another one is the accused, and yet they of course spoke to all sorts of people in the aftermath. Now, I've gone through just 3, and there's many more on the list. There are business records and official statements and all sorts of other things. But there's a trap in section 118, which I kept falling into, and I've seen others also briefly fall into, which is it cannot be read alone. There are 2 features of it that are particularly important and dangerous. One is, notice at the start it says the following hearsay evidence may be admissible under this Act. My understanding of that is the court has a discretion. It's not automatically admissible under the Act, though perhaps the original Act might be clearer on that language. So there is a decision for a court to make. It's not automatically in, perhaps. More importantly, section 119, right after section 118, hard to miss, and yet I think it's going to happen. I think people are going to miss it, has a big qualification on section 118, a huge qualification. It is so tempting to read through the list in 118, land on B or something and say, aha, we've got this in, it's admissible hearsay evidence as the title of this provision says. But those people will be greatly misled because 119 then puts qualifications on it. I think it's a pity that Section 118 doesn't say subject to Section 119, the following may be admissible under this Act. That would signpost things a little bit. It's sometimes a bit of a clumsy way of drafting things, but it's used elsewhere in the Act. But in any case, Section 119 is clearly a qualification on 118. The hearsay evidence admissible under Section 118 shall be submitted to the court, so that's a little bit of an unusual way of putting it, only where the court is satisfied that the person cited as having made a particular statement or having committed a particular act as per the testimony, so that's the person speaking out of court, falls under one of the following circumstances. And here's the discretion, where the court permits the evidence to be adduced. So that's the clearest language where there's also a discretion for the court not to include the evidence but to exclude it. And then there's a list, and it's a pretty narrow list. This is the whole list, not a segment. The person cannot be found. The person is unable to testify, for example, because they're ill. Where it would take more than a reasonable period of time to summon the person to court to testify, where it would cost more than a reasonable amount of money to summon the person to testify, or where the person is deceased. So clearly the deceased categorisation would cover the 3 deceased people in the Erin Patterson case. That's easy. It would also have covered Ian Wilkinson, the surviving person, if he had survived but was too ill to come to court. He was still recovering, and he was indeed very sick for a very long time. It would also cover someone who ran away or someone who was overseas or the like in at least some circumstances. But that's it. This is what in Australia would be called an exception for unavailable witnesses, with unavailable having itself a generous but not too generous definition. All right? And so 118 is really just about unavailable witnesses. That is despite some of the things on the list being the sort of exceptions you usually have for available witnesses as well, things like business records. Usually a business record can be used even if whoever wrote the record is available, on the thinking that people who write business records are useless. They don't remember anything they do. They'll just come in and go, I don't remember that customer, or I don't remember that consignment, or whatever it is they typed in, because they do thousands of these things a day. And yet business records exception in 118 only applies to unavailable witnesses. So that's the big trap in the Maldives hearsay exceptions, is this one. You have to narrow it down to Section 119. It makes for a very narrow set of exceptions to the rule, but that of course should be read with what I said earlier, which is the Maldives hearsay rule is itself narrower than other jurisdictions like Australia, in that it doesn't apply to a witness's own prior statements. That witness, of course, will be available, but the hearsay rule won't apply to them. And it also doesn't apply to, it seems, documents that contain evidence, although there will be other potential requirements for putting a document before the court. All right. So I just want to briefly note the other way of doing things. This is because this is how it works in the Maldives, but just to point out that there are other ways you could go. I guess this could be relevant if there are ever amendments, those planned amendments to the Evidence Act. So how does Australia, which has a broad hearsay rule, deal with this issue? For a start, it actually has a wider definition of unavailability. I've just again given you the start of the Australian definition of unavailability. Again, it covers the person who is dead. It also covers a person who, for almost any reason, is not competent to give evidence. So there might be a number of reasons for that reason, including age. And this one, the person is mentally or physically unable to give the evidence and it is not reasonably practicable to overcome that inability. That is a little bit like where the person is unable to attend the court to testify after making a statement, but I'm not sure they'll have the same operation. Paragraph C was included in part to deal with witnesses who are too scared or traumatised to testify. So in that situation, they would be within the definition of unavailable witness. The fairly generous Australian exceptions for unavailable witnesses, with some caveats, would apply and the witness's earlier statement would be used. So those are some of the examples. There's also situations when people can't be compelled to give testimony. So for example, spouses and children typically can't be compelled to give testimony, though they can choose to. But if they choose not to, their prior statements can then be used under the unavailable unavailable person hearsay exceptions. I just want to cover a couple of other nuances of the Australian approach which don't appear in the Maldives. Section 61 says that many but not all of the hearsay exceptions only apply if at the time the earlier statement was made that person would have been competent to testify. So this covers a situation where the person may or may not be competent now, but they weren't competent back then. The thinking in Australia is if we're exceptionally allowing them in, we should apply more or less some of the same constraints as they would apply if they were testifying in court. Of course, they aren't giving an oath now, but they should at least be competent. Interesting question how that would work in the Maldives, where, although I haven't gone into detail, there are some unusual competence requirements, such as being of sound mind, not being under 15, being credible, not having a conflict of interest, and so on. Maybe some of those wouldn't be appropriate for a rule like this, but I would note that there is an equivalent to Section 61 in the Civil Procedure Code of the Maldives, which is additional rules that apply to hearsay evidence in civil matters. So there is an equivalent section there. So this is unheard of in the Maldives. But the other one I want to mention is one that is of enormous practical significance in Australia, and it does not appear to be present in the Maldives Evidence Act at all. It is statements, contemporaneous statements about a person's health, etc. There's a lot buried in that, etc. The hearsay rule does not apply to evidence of a previous representation made by a person, an out-of-court statement, if the statement was a contemporaneous statement about the person's health, feelings, sensations, intention, knowledge, or state of mind. So the health side of it would, of course, cover people saying things about their health, all right? And the idea there is that we don't need to apply the usual processes of oath and cross-examination and the like when a person is describing their own internal state. They are the only ones who know how they're feeling, health or mind, and so that we should trust the statements they make, or at least be willing to apply different kinds of tests, the usual ones, in assessing those statements. And in practice, it's very difficult to bring a person to court to say what they were thinking back at another time. It's not how most of us think. We think about what we're thinking now, we remember things we saw back then, but getting someone to describe particular feelings they had inside their head back then might be a more complex matter. So Australia treats those things as an exception, basically as not part of the hearsay rule. That doesn't mean that a person can then be, that you can circumvent the rule by simply saying what did the person believe to be true and then using that to infer maybe it actually happened. That would still be a breach of the rule, but you can at least learn what's on their mind. I've given an example here, which on the bottom left, Erin Patterson, when after the lunch and once her relatives all started getting sick, the hospital, of course, became concerned about her health. They realised that she'd eaten, in theory, the same beef Wellington everyone else had, and so they said, well, you need to come to hospital so we can give you preventative medicine, because there are ways you can try and ameliorate the effect of death cap mushrooms by protecting your liver and the like from toxins. And so she turned up at hospital, they explained this to her, and she said, look, I've got a lot on today. I've got to take my kids to ballet, I've got to pack, I've got to clean up the house. Maybe I'll come back later, and she left. And they got her to sign a discharge form where she acknowledged that she had been warned that there was a danger to her health and she was going to disregard the warning. Now, that's proof. That's something to. One thing that can be used to prove is that she knew at that point when she started disregarding warnings. She'd been given the warning. She acknowledged having been given the warning. She knew about it. So whether she was actually given the warning or not isn't the issue. It's that she knew at the time. She believed at the time there was a warning. Okay, and so this exception allows that kind of proof. All right, not currently an option in the Maldives, and given the narrowness of Section 118 and 119 in some respects, potentially a gap. That's all I want to say about the hearsay rule, so maybe at this point I should pause for questions about that rule. Yes? Yes, she was, though there's a longer story to say, but yes, 2 weeks ago, the jury gave a finding of guilty. So yes, she's been convicted. She is awaiting sentence, but everyone expects her to, she'll clearly get a life sentence and most likely get a life sentence without any possibility of parole. There's no higher penalty in Australia. So the harder question is she is also appealing. So whether her appeal stands is a slightly more complex question, though if I had to predict, I would predict her appeal would fail. So, as I'll explain in a bit, there is other evidence against her, including evidence that was not raised at her trial that leaves me, at least, confident she is in fact guilty, although it was a much debated issue during the trial. Happy to answer any question about the Erin Patterson case if you want. It's a very interesting case. Likewise, also the hearsay rule. Is there a particular thing you want me to elaborate on? Yeah, this is only a problem typically when the witness is available, because there would be usually unavailable witness exceptions when a witness is dead or something. But if, for example, the prosecution wants to prove that a person likely went to a particular location, so they rely on their statements that they intend to go to a particular location, and that's outside the hearsay rule because of this exception. And then, having learnt that the person intends to go, they reason, well, people who tend to go to a place typically do go there. That's a reason to think that that person went to a location. So that's the classic example. There's an Australian High Court case on that particular argument. Another one, in a self-defence case, where a murder case where there's an argument about self-defence, the accused says, I didn't go to the person, they came to me and attacked me. The fact that or the accused claims that it was a friendly meeting and then it went bad. The fact that the other person had gone around telling everyone they're scared of the defendant and wanted to keep away from them, that's a reason to doubt the accused story. None of that means they had good reason to be scared. Maybe they had no reason to be scared. Maybe they misunderstood. But that doesn't matter. They're still scared, and therefore it's unlikely the accused's account is true. So that would be another example. All right, well, let's keep going then. I'll just check the time. Cool. All right. So my next one to talk about is the opinion rule. Like I said, I'll talk about opinion, then I'll talk about credibility, and then after a break, I guess, I will talk about the two most unusual rules in the Maldives Evidence Act, at least for the Maldives, which is the tendency and coincidence rules. So, opinion rule. All right, this is the second rule in order in both the Maldives and the Australian Act. So in the Maldives, there's a definition of opinion in section 16, and this doesn't define the rule, it defines just what an opinion is. Sometimes that isn't always the approach in the definition section. Opinion means what is understood by a person when they mentally assess an act or thing that is visible, but it also includes inferences drawn from seeing, hearing, or experiencing a fact or set of facts presented. That's the English translation. So this definition is, I think, a good definition, and Australia has no definition of opinion. I always teach my students that opinion is when a regular person, or a person anyway, finds facts. Just like a judge finds facts, we all find facts all the time. We process in our head what we see, and then we reach conclusions. And just like everyone, we don't apply a standard of proof. We don't apply beyond reasonable doubt or balance of probabilities. We just reach conclusions in our head. The conclusion might be tentative. The conclusion might be certain. We might make decisions because of our conclusion, but we are finding facts ourselves. And so an opinion is whenever a person finds facts, and I think that's what the Maldives definition reflects, when they mentally assess something that's visible or they draw inferences from things they've experienced. They are finding facts. You could argue that literally everything a person does and says involves some finding of facts. I look at all of you and I'm making a finding that you are actual people. I'm not having a hallucination. You are looking at me or something, whatever, all that sort of thing. Even the most banal descriptions of what's going on around you is a form of fact finding, but everyone also accepts the definition of opinion is something beyond that. It's that further step. If I find as a fact that you all look interested, that's the further step. If I find as a fact that you all looking tired, that is a further step. It's my opinion of those things, all right? That isn't expressly said in the definition, but it commonly isn't. At least there is this definition. All right, the opinion rule in the Maldives, section 120. Unless otherwise stated in this Act, evidence of an opinion by a person about the existence of a particular fact is by itself inadmissible. So a couple of things about that. First of all, of course, quite correctly signposts that there are going to be exceptions to the rule, as there are to all rules, or as there are to most of the rules. Secondly, it says evidence of an opinion, and that means there's any way a court learns about a person's opinion is covered by this rule. And that's important because the court might learn about an opinion by a witness stating in court what their own opinion is, but it might also learn about a person's opinion by learning about a person's out-of-court statement of what their opinion is. That's a combined form of hearsay and opinion, but it might be either outside the scope of the hearsay rule, or within an exception to the rule, it still has to satisfy the opinion rule. The main Australian case on its opinion rule, which is in similar terms, involved a person who was found lying in a drain in a park. He'd hit his head, he didn't remember how he got there, he just remembered leaving his house hours earlier. What happened to him? Was he assaulted? Did he just fall over? Or did he trip over a wall to the drain? And the relevance of that is if he tripped over the wall, then he may well be able to successfully sue the local authority who built the wall, who he argued built the wall badly in a way that caused people to trip. But how do we know which of them? Well, the ambulance officers who arrived at the scene were there. They were called in by someone who found the person unconscious. They came in, they provided immediate health assistance, then they arranged for transport, and then they did a third thing, which is part of their job. They wrote down a note for the doctors at the hospital with information the doctors might need, and the note said, fell off a wall. All right, and so the ambulance officers didn't see him fall off a wall. Rather, they presumably saw from something they saw at the scene, his position, where his head was, where the blood was, something like that, maybe even information they were given by others, it's hard to tell. They formed an opinion that he fell off the wall. In fact, they actually put a question mark in front. Possibly fell off the wall, which is a little more ambiguous. But what the High Court said correctly, I think, is that this evidence, which was allowed in as a hearsay exception under Australia's business records exception, the ambulance drivers were not called as witnesses by either side for whatever reason, was also governed by the opinion rule in Australia. All right, that's even though the opinion was said outside the courtroom. All right, so I think the same as in the Maldives. It doesn't matter where the court learns the opinion from, via a hearsay exception or via a witness speaking in court. The opinion rule applies and renders the opinion inadmissible unless an exception applies. 120C, and I'll get to the other bits of 120 in a moment, in the next slide. Notwithstanding subsection A, the opinion rule does not apply if an opinion given by a person about the existence of a fact is admitted for a purpose other than proof of the existence of the fact. Now, this is an area where I think there is a fairly close following, but not entirely similar following, of Australia's approaches. Australia says evidence of an opinion is not admissible to prove the existence of a fact about the existence of which the opinion was expressed. And then section 77 says the opinion rule does not apply to evidence of opinion that is admitted because it's relevant for a purpose other than proof of the existence of a fact about the existence of which the opinion was expressed. What does that cover? Like the hearsay rule, whether something is a forbidden opinion or not, in part depends on what it is being used for. You might rely on people's opinions that their co-worker is untrustworthy because you want to judge the co-worker. But you also might rely on their opinions for a different reason, to learn that the co-workers gossip about, say things about, are willing to express views about their co-worker. And you think, maybe I don't want to work at this place because it's the kind of place where people are judgy about other people. That's a non-opinion use of an opinion, all right? In Again, in the Erin Patterson case, there was video of Erin Patterson leaving the hospital, and in the video, I can't play the video here, this is just a still shot, a medical worker comes up and remonstrates with her, and you can see the workers panicking, saying, "Why are you leaving? You could die." And Erin Patterson then just leaves. That opinion is relevant for two reasons. One, because, well, maybe she might die if it's an opinion about the dangers of death cap mushrooms. But it is also relevant because it's, again, more information about how odd Erin Patterson was behaving. It's a very peculiar thing for someone who is told, "You might die," to nevertheless say, "Anyway, I'm busy," and off they go. And of course it is used to suggest that she knew full well she wasn't going to die. In fact, there's a further wrinkle to this. There were 5 adults at the lunch, but Erin Patterson had 2 children. They were away for the lunch. In fact, she sent them away for the lunch. She said because she wanted to tell her relatives about her cancer, and she didn't want the children to hear that. But the hospital. But then she later told the hospital that the kids had eaten leftovers from the meal. The hospital, of course, panicked and said, "The kids could be at risk. You need to bring your kids here." And she again said, "Oh, no, I don't want to trouble my kids. They're at school. I don't want to panic them." And although you can sympathise a little with a desire not to panic your children, the alternative is they might die. And so again, it's a sign that Erin Patterson had her own reasons to not heed this opinion. And that's the relevance of that opinion. It's something she ignored. All right. Another example is her husband said to her within days of the lunch, "I think you tried to murder my parents." And right after that conversation, she took her dehumidifier that she'd used to dehydrator, which she used to dehydrate mushrooms, and took it to that rubbish tip. It was right after that conversation. So the relevance of the husband's opinion in this case isn't whether he's right or not that she tried to poison. That does reveal something about his thinking. It might, of course, reveal something about reality, but most crucially, it seems to explain why she threw away that dehydrator. Interesting question, much debated in Australia. Did she throw away the dehydrator because she was worried she would get caught for a crime? Or did she throw it away because she'd come to realise that the deaths were her fault due to her foraging of mushrooms, and she wanted to try and make sure that the news didn't get out? Both are bad, but one is much worse than the other, deliberate poisoning versus accidental. All right, let's get to the exceptions to the opinion rule. And in the Maldives and in Australia, there are 2 exceptions, and for that matter, in the Federal Rules of Evidence. Lay opinion and expert opinion. And both jurisdictions use the term lay opinion in the titles of their section, although only the Maldives uses the term lay opinion in the text of the section. All right, so lay means ordinary, not professional, and it's usually used in contrast to expert. You're either a professional opinion holder or you're like the rest of us and you just hold opinions because you're human. All right, so a layperson is that latter category. An opinion given in the following circumstances by a layperson may be admissible as evidence. The opinion is based on what the person saw, heard, or otherwise perceived or experienced about a matter or an event. That is, the person is an eyewitness, or ear witness, or nose witness, or touch witness, but you understand what I mean. And evidence of the opinion is necessary to obtain an adequate account or understanding of the person's perception of the matter or event. If you look at Australia's Section 78, exception lay opinions, it's almost identical. This is clearly a copied provision from Australia. It's not like a groundbreaking provision or anything like that. The common law that applies in Australia has long had a similar exception. It's just meant to cover a fact of life, which is most of us aren't precise in our observations or in our memories or in our communications. Most of us cannot describe a colour without using approximation, or describe a person without using approximations, or describe the speed of a car or anything like that. We aren't video cameras who can precisely record everything we see, nor are we televisions who can play everything we see. We use words, and our memories also have approximations in them. And the idea is that although it's better if people just describe facts that they perceived, remember, and now recall and communicate, the reality is most people would be unable to give evidence on crucial points if that's all they were limited to. So instead, this exception says, if you saw something, or perceived it, that we want to know about, and the only way to get the information from you is if you give it in the form of an opinion, then that is okay. So that's the lay opinion exception. In the Erin Patterson case, plenty of people wanted to tell the court whether Erin Patterson was actually sick in the days after her illness, after the lunch or not. She claimed eventually that she had been sick, not hugely sick, but she'd suffered gastroenteritis, diarrhoea and the like in the days afterwards. She claimed that, but she was the only source of that information. Could still be true, it's not as if everyone else can see that, but plenty of people want to say, she didn't look sick. And now, we all know that statement, we all know what that means, but imagine trying to pin down what exactly led you to think she didn't look sick. You might say she didn't look sweaty, she didn't have an uncomfortable expression on her face. How would you describe, someone said, what do you mean an uncomfortable expression? Does anyone know how, you'd have to like mimic it or something, I don't know, in court. She didn't look uncomfortable, she wasn't crossing her legs, she didn't keep disappearing and coming back and so on. But most people don't have that kind of level of memory. Just, she looked fine, she looks well, right? And that's the kind of statement that this provision would allow, all right? But notice that limitation to an opinion given in the following circumstances by a lay person. Because quite a few people who observed Erin Patterson were not lay people. That is, they weren't ordinary people like you and me, they were professionals. Many of them were doctors or nurses in the hospital. She went to a hospital and she left, and a few hours later she reluctantly came back. She was transported in an ambulance to a much more serious hospital, and all the people who were watching her then were also checking, as they should, as part of their job, to see if she was sick. And so what about their opinions, all right? And in Australia, they would be able to give their opinion under the lay opinion exception. They would describe, oh yes, just like anyone else, she didn't look sick to me. They might be, the only difference with them in Australia would be, because they're doctors, they probably have better terminology and better sense of their own thinking to better describe why they thought someone was sick. So a doctor might be able to say, yes, they did not appear to have a temperature, they showed comfort, they were lucid in their conversation, they were not looking distressed. You know, they would say things that most of us wouldn't be necessarily as able to articulate. And that, if they were able to say those things, then they might fall outside the exception, but otherwise they would be fine. And of course, they might not be able to always recall those things. All right? But in the Maldives, it is possible and arguable that they would not be allowed to give that statement under this exception. Of course, there's another one to come, because they are not laypersons. So in the Maldives, and this also follows the Federal Rules of Evidence, which has a similar distinction, you are either a layperson and you use the lay opinion exception, or you're an expert and you use the expert opinion exception, but not both. On the other hand, in Australia, you could be one or the other. You could use both. You can be an expert who also happens to be an eyewitness and who can express themselves in that way. All right. And in that case, I mentioned about the ambulance drivers who wrote down, fell from a wall. All right. It's a difficult question in their case. Ambulance drivers are, of course, experts in things like, is the person conscious? Is the person in danger? Do they have concussion? Have they lost blood? Are they in danger of their life? But is an ambulance driver an expert in any sense in whether someone fell off a wall? Now, the simple answer might be no. They're not physicists, they're not engineers. But the more complex answer is they respond to falls all the time. They have much more knowledge of falls than you or I do. So maybe they are an expert of a sort by experience or by training or something like that. Part of their training may involve recognising when someone has fallen, as opposed to being beaten up or something like that. Police officers might also have that ability. So are they lay people or are they experts when it comes to the question of whether or not someone has fallen? All right. In Australia, that wouldn't be an issue. They could still use the lay opinions exception, although the High Court ended up ruling that the ambulance officers probably could have given more information than they wrote down on that form, so that they didn't satisfy the second part of the exception. In the Maldives, I'm not sure whether they could use this exception or not. Let's go to expert opinion, or in Australia, opinions based on specialised knowledge. So I might just start with Australia here. Australia's Section 79, which is based on the Federal Rules of Evidence, has an exception for opinions based on specialised knowledge. It doesn't use the term expert at all. If a person has specialised knowledge based on the person's training, study or experience, the opinion rule does not apply to evidence of an opinion of that person that is wholly or substantially based on that knowledge. So they have training, study or experience. That gives them specialised knowledge, knowledge that not everyone has, and then they can give an opinion that's wholly or substantially based on that knowledge. It might also include some common knowledge. So that's the Australian approach, and it was deliberately written to avoid the idea that experts have to have qualifications, uniforms, or the like. You can have an ordinary person who acquires expertise by experience. The classic example, which was taken from the United States, is someone who works a lot on their car and gets to know how a car works in the way that most other people do. They would fall within the expert opinion exception, even though they have no training or qualifications. They've just got a lot of experience in cars, their own car in particular, I guess. All right. Some of this language does appear, but only indirectly, in Section 122 of the Maldives expert opinion exception. 122B says, there's 122A just allows for an exception for expert opinion, but B is the crux of the exception. Expert opinion may be admissible only in the following circumstances. And when first you read this, you think, wow, there are 6 different circumstances and any of them will do. But that is not how this reads and how it works. All 6 have to be true. 6 requirements for expert opinion. So firstly, that the specific area of training, experience and education attained by the expert is generally accepted as an area of special education, training and experience. That's a traditional test sometimes used but no longer used in the US or Australia, that there's general acceptance of that field. Secondly, where the expert is believed to have attained an adequate level of education, training and expertise, says the translation, in a specific field, and as a result, the expert is considered qualified to give an opinion to the court. That seems to be pushing towards this idea of experts as qualified people rather than potentially anyone who has the right level of knowledge, specialised knowledge. Third, this is pretty narrow to me, where it is crucial for the court to seek the opinion of a third party who is not a party to the case, due to the nature of information sought from the expert, and such opinion would assist the court in deciding on a matter. So assist seems like a low bar, but crucial for the court seems a bit higher. Again, this might be different in the original version rather than the translation. Fourth, where the opinion of the expert shall not be deemed an opinion which determines a verdict in a case prior to the court reaching a verdict. So this is a version of what the common lawyers call the ultimate issue rule. An expert must not testify on the ultimate issue that's before the court. For example, whether Aaron Patterson is a murderer or not. Some murder expert might want to testify before the court on that thing. Maybe a police officer, they would be barred from doing so. They could testify on whether she was sick or whether she was shifty or something, but they could not testify on whether she's a murderer. That rule has been abolished in Australia. Fifth, where the facts upon which the opinion of the expert is based cannot be challenged or disputed by another expert. So this looks like you can't be an expert if anyone disagrees with you, but it doesn't quite say that. It's where the facts you are relying upon are uncontroversial. So experts, of course, third-party experts are brought in, they haven't seen anything for themselves, they're supplied information, they reach an opinion, but this rule says those facts have to not be disputed, although it refers to being disputed by another expert, which is a little strange. It might just be a layperson who disputes the relevant facts, but that is what the wording is. And finally, where the expert opinion is not given in order to favour the interests of a specific person, and that's again a bit of a understandable concern. I teach a course on expert evidence in Australia, and a major concern is the problem of bias. State experts are biased because they work for the state and are paid for by the state. Defence experts are biased because they're guns for hire or just give an opinion for whoever pays them. I mean, we know that that's not quite true. We also know it is a little bit true. How does that fit with a rule that you can't give an opinion in order to favour the interests of a specific person? I think it is only getting at a situation where an expert says, tell me what you want, what opinion you want, and I'll say it for you. As opposed to, you pay me and then I'll tell the court my opinion, which is a slightly different thing. Okay, so it's a set of fairly onerous requirements for expert opinion, although, let me just check if I've got this on the screen. Yeah, there are some carve-outs in the Maldives Act which allow a little more flexibility when it comes to some expert opinions. Here's some expert opinions from the Patterson case, just so you can think about how these would work in the Maldives. The doctor who saw Erin Patterson and some of the other patients who died, after the trial he came out to tell everyone that he thought Erin Patterson was evil, and that he thought that the first moment he met her, and he decided that she was guilty of murder the moment he asked her, where did you get the mushrooms? And she answered, I got them from a major supermarket in her hometown of Leongatha. So you can buy mushrooms at any major supermarket, or in fact any shop almost in Australia. But you cannot buy death cap mushrooms at those shops, not even accidentally. They're all carefully checked. There are a particular variety of mushrooms. Death cap mushrooms are difficult to find. They're not everywhere. It's just impossible that you would end up with a death cap mushroom from your local supermarket. And that doctor decided right away, as soon as she gave that explanation, that she's hiding something and it must be that she's a murderer. Now, he's a doctor, so he's just not qualified, of course, to make that pronouncement to the court. This is the kind of opinion which is more interesting not for its truth, but for what it reveals about him. It is kind of interesting, though, that that early on he decided that what everyone thought was unimaginable for a while was actually what happened. He claims to be the first one to realise, although I think there's more information to come about that, which I'll get to. The other experts there were many other experts called to the courtroom, but just to give you some other examples, there were mushroom experts, of course, who wanted to tell everyone how death cap mushrooms work and how to identify them. In particular, there was one person who was an expert on mushrooms, that was his field, but he also contributed to a website. And it's a website which allowed people with an interest in mushrooms or a concern about mushrooms to just post information about mushrooms. So he posted once in the months before the lunch that he had seen a death cap mushroom near where Erin Patterson's house was. That was combined with another expert the court called, who looked at Erin Patterson's phone records and found that on that occasion she went to that location, or at least her phone was near a cell tower in that location, the day after that posting appeared on that website. So, a couple of things of interest. His opinion is, his expert opinion is useful to know that the place where Erin Patterson went had a death cap mushroom. So that's just using his opinion. He's a mushroom expert. To describe something he saw. Note that he's not a third party. He's kind of involved in the case. He's the one who tipped off the murderer the alleged murderer, on where to find the mushrooms. But he's also just a generalist expert on mushrooms. So I'm not entirely sure how well that would fit with 122B3, but it was no problem for him to say that in Australia. The cell phone tower people were, of course, able then to talk about their expertise when it came to cell phones. Perhaps I should mention at this point, because I was asked about this a little bit before lunch, this mushroom expert was called by the prosecution, but the defence, when they cross-examined, applying Australian rules on cross-examination, made good use of him for the defence. So they, in particular, what they actually did in court was show him 20 pictures of mushrooms, like an identification parade of mushrooms. And he had to concede that he couldn't tell which ones were death cap mushrooms and which ones were harmless mushrooms. And that's even though that's his area of expertise. He said, no, they're ambiguous. You can't be sure of this one and this one and this one. And of course that helps the defence, who eventually want to argue that Erin Patterson, yes, they conceded, had poisoned her relatives, but that she did, though, accidentally by simply picking a mushroom she thought was safe, which turned out to be poisonous. So the defence made use of this expert for that purpose. Notice also that his expertise is also has a non-opinion use because he posted it publicly on a website which Erin Patterson might have read. It provided an explanation of how she knew where to find death cap mushrooms, otherwise something she might not have been able to locate. All right, I want to cover a few extra Maldivian wrinkles on the expert evidence exception. So within section 120, the opinion rule, there are some further ways to bring in expert evidence or opinion evidence independently of the 122 expert opinion exception. So 120B says, notwithstanding subsection A, the rules therein do not apply to an opinion stated in a document or an official certificate or an official document made pursuant to a law or regulation, if the reasoning on which the evidence was based is stated by the person who signed it, and such opinion may be admissible as evidence. So I think the key words there are made pursuant to a law or regulation. This is not any document. It's got to be a document someone is, well, pursuant is a tricky word, required to do by law, maybe also allowed to do or expected to do or given a function to do by law. And their opinion, that doesn't seem to require any other satisfaction of any other rules, except for the requirement that they state their reasoning in that document. So it's a particular sort of exception, not one that's available in Australia. D says subsection A does not apply, so notwithstanding subsection A does not apply, it's a bit reductive, to expert opinion obtained pursuant to the principles stated in this Act, and such opinions shall be admissible. That wording seems to invite a search of the Act to see when the rest of the Act says it's okay to use expert opinion. And there's probably a number of places you could go, but one I want to draw your attention to is section 42, which is the first section in the section on oral evidence. It's 42F says, where a public, so this is supposedly on oral evidence, but it's really not about oral evidence at all, where a publicly available document contains an expert opinion on a particular matter and the reasons for that particular opinion, such document may be submitted to court as proof of the opinion under the following circumstances. And then it uses a set of circumstances which are about the unavailability of the opinion holder. They're deceased, they cannot be found, they're unfit to give testimony, it will take too long to summon them to court, or it would be too expensive to summon them to court. So that particular argument knows it has to be a publicly available document. This is not some internal document held by the police or the government or something. It's publicly available, though there might be arguments about what that means. Looking at that, what comes to mind for me are published articles. So in fact, the mushroom expert in the Erin Patterson case was asked himself about a published article from 2017 in Germany on the topic of mushroom poisoning. There are 4 authors, I think there's also a 5th as well. None of them were called to testify, but he told the court about them. Presumably finding those 5 people, whoever they are, from 2017, bringing them from Germany, getting a translator and all of that, that's a pretty expensive thing to do, although this was a high-profile trial, so not out of the bounds of all expectations. But crucially, the defence was able to establish that this particular article on mushroom poisoning contradicted the widespread belief that death cap mushrooms are always deadly. In fact, it identified 4 possible outcomes of eating a non-trivial amount of death cap mushrooms, which of course included death and extremely serious illness. But not just that, but also, in the least serious category, gastroenteritis, which is exactly what Erin Patterson said she experienced. So they were able to use this, and they didn't have to call any. Who knows who these 4 people are? Yes, they published an article somewhere. It doesn't even say a peer-reviewed article in 42. It's a publicly available document. No one can be bothered bringing these people all the way to Australia to testify, so you just raise the article. And that seems to be permitted under the Maldivian opinion exceptions. All right, so I've been working through the main exclusionary rules, covered hearsay and opinion. Just before I go on to credibility, there's one question I've had a few times during various breaks, which is about unfavourable witnesses. You'll recall that the Maldives and Australian evidence laws both allow the order that was usually made in relation to hostile witnesses to be now made in relation to a wider category of people. People who give unfavourable evidence, people who aren't trying, and people who say inconsistent things to some extent. And the result is that the party who called the witness, who can usually only examine and re-examine the witness, can now also cross-examine the witness. Relevantly, that means that the party can ask leading questions of the witness, something usually, but not always, forbidden outside of cross-examination. And secondly, it allows questions about credibility, as we'll see in a moment. But one question I got asked a couple of times was about what happens to the other party in an unfavourable witness situation. So in the old law on hostile witness, it's now abolished in the Maldives and has long been abolished in Australia. The idea was that effectively the witness who's being called by one party is betraying that party, has joined the other camp, and so is no longer that person's witness, but is actually the other side's witness. That isn't always how hostile witnesses work, but it's often how hostile witnesses worked. That is not how the new system works. The wider definition of unfavourable witness does not require any finding that this witness is betraying the party who called them. They might just be an inconsistent witness, for example, which is neutral. Inconsistency could be bad for one or both sides, it doesn't matter. They might also be unfavourable to the party, and that just means says something which damages the party who called them case, without otherwise betraying that party. And the clearest example of that is where they generally give favourable evidence to one side, but on one point, even an important point, they give unfavourable evidence to that side. And so, like many witnesses, and this is the reality, witnesses aren't always on one side or the other, and this witness is simply not entirely on that party's side. I might mention in passing, although I don't want to overly complicate this, that in Australia, a recent practice of the last decade or two is that prosecutors are obliged, as part of their duty to the court, to call any witness who saw an important event that the court needs to know about, and that's whether or not the witness is for that party or someone else. So in Australian trials, most of the witnesses are called by prosecutors. The prosecutor, there are exceptions to this, the prosecutor doesn't have to call someone they think is a liar and the like, but otherwise the majority of witnesses are called by the prosecution. But there are cases where the majority of those witnesses are in turn speedily declared unfavourable, which means the prosecution can cross-examine them. All right, but the question then now comes, what happens to the other witness under the new regime? And my view is nothing happens to the other witness under the other party under the new regime. The other party can also cross-examine. So you get, now everyone can cross-examine, or at least if there are two parties, everyone can cross-examine that witness. So it doesn't change the status of the other cross-examination. That's the simple take, and I think it's the correct take, but there are some nuances to flesh out. So one thing I didn't mention during my earlier presentation, which I really should have, is that remember that it's a court's decision on whether or not cross-examination can happen. And in Australia there's express provision to this effect, but I'm sure it's still the case in the Maldives without an express provision. The court can give its leave to cross-examine with conditions. They can say, yes, you can cross-examine, but, and then they can impose conditions on that party. And a classic example of a situation where they will almost always impose conditions is where the problem with the witness's evidence is only partial. So, for example, the witness is generally given favourable evidence to the prosecution, but then says something unfavourable to the prosecution. Typically, the prosecution will be told, yes, you can lead, yes, you can attack credibility, but only on that bit of the evidence, not generally. All right? Likewise, if the witness has has an inconsistency with an earlier thing they said, that's the thing you can ask about and lead about, not generally. And if the witness is generally being helpful, but on one point looks all reluctant and doesn't want to help, for whatever reason, embarrassment, hostility, it doesn't matter, then typically the ruling will be on that issue you can ask about, you can ask leading questions or attack credibility, but again, not generally. It's not a complete flip. So in that situation, obviously, the other side will still want to cross-examine on every other issue. So that's the wrinkle there. And then the second wrinkle to mention is that although cross-examination usually means that you can lead and usually means that you can attack credibility, the court in some situations, certainly on leading questions, can say, not this time. I'm going to order you not to lead or to limit how you lead in some situations. So in Australia, sometimes there will be situations where the other side will be told you can't lead. The classic example is a young child testifying. So in Australia, there's no age limit on testifying, and there's a narrower capacity limit on testifying. So sometimes very young children, 6 or 7 or something, can testify in court, obviously with special procedures and the like. And almost invariably, the other side is told you cannot lead this child, for the obvious reasons that when you lead children, they follow. Their evidence, leading a child is not worthwhile evidence. They get told, no, you actually have to try and ask the questions without leading. Or at least the requirement will be, you must first try not to lead and only lead with later permission if nothing else works. And the court will be very cautious about the results of that. And so I guess it is possible, but I'm not sure this happens much in practice, that if a court decides not that a witness is just a little bit flawed to the party, a little bit unfavourable, a little bit inconsistent, a little bit not trying, but has actually switched sides and become the other side's witness. I guess it is possible in that situation the court, in its discretion, will tell the other side, this witness is so favourable to you and so partial to you and has so betrayed the person who called them, this is effectively your witness and I won't let you cross-examine. I don't know if that happens in practice. All I'm saying is it's a theoretical possibility. But to my mind, the idea that the unfavourable witness rule involves a switch between parties is old school thinking. It doesn't reflect the purpose of the new provision, which is simply just to make it easier for everyone to examine a witness as necessary. It's not to assign a particular role to a particular witness. That's the thinking behind the Australian provision, and it's clearly been picked up in the Maldivian provision. Okay, so I just wanted to address that. Otherwise, we are on the home stretch. I think everyone's a bit exhausted, but that's fine. We have 3 rules to cover, but 2 of them are very closely linked. So there's really 2 topics to cover. And I think I'll be able to cover the first fairly quickly, which is the credibility rule. All right, so this is, we're now in the area of in part judging patterns of behaviour, looking at a person and saying, not just what do we know about what they saw, but who is this person? Tell us more about them. All right, and generally most evidence law systems resist this kind of inquiry. They see that witness is there, not so we can learn about the witness, but we can learn about what they witnessed. All right, and there are a number of reasons for that. A witness is forced to come to court, and so they understand why they have to come to court because they've seen something important. But the idea that they then have to bare their souls, reveal all their worst deeds, show all their biases and emotions, reveal their handicaps and so on, that's asking a lot of a witness. And I am well aware that in the Maldives there's a continuing problem of people being reluctant to testify for all sorts of reasons, in part due to everyone knowing each other and so on, but there's plenty of other reasons. And so evidence law everywhere has long resisted the idea that just by turning up to testify, you become a piece of evidence that people can pick apart. All right? So in part that's dealt with by the constraints on cross-examination, but it's also dealt with by rules like the credibility rule. All right, so in the Maldives, there's a section in the definitions or concepts section of the Maldivian Evidence Act, that is part 1, section 25, which is titled Credibility Rule, and does indeed define the term credibility rule, but in my opinion it really just defines what the word credibility means. Credibility rule means the rule under which, and it describes some evidence, this is the point, evidence is submitted to the court to indicate the extent to which the court may rely on the witness or their testimony, or the rule under which evidence is submitted to nullify the credibility of the witness or the testimony given by the witness. All right, I'm going to come back to that wording, but here I need to put the caveat. In discussions with not just prosecutors but others, many people have debated whether this is a good translation of the original Act. So you need to take this particular translation with particular caution. Of course, you should do that anyway. And then section 127, also titled Credibility Rule in the English translation, A says, unless otherwise stated in this Act, evidence submitted under the credibility rule is inadmissible in and of itself. That language in and of itself or by itself does actually appear repeatedly in these rules. I'm not quite sure what it does, I have to say, and maybe it's a problem of translation. Is it suggesting that the evidence is admissible in combination with something? I don't understand what that would be, in combination with what. I think this is a flourish of language, if I had to guess, but I don't know. Or a mistranslation, I guess. There is a similar structure in the Australian credibility rule, and in fact, Australia's credibility rule, section 102, is very brief. Credibility evidence about a witness is not admissible. Of course, there are exceptions, and they come later on in Australia's Evidence Act. There's no signposting in the wording of the rule. But there is also then a definition of credibility evidence and of credibility. So let's just look at the definition of credibility, which is in the dictionary to Australia's Uniform Evidence Law. Credibility of a witness means the credibility of any part or all of the evidence of the witness and includes the witness's ability to observe or remember facts and events about which the witness has given or is giving or is to give evidence. All right? Now that language, and includes the witness's ability to observe or remember facts and events. So that's often called the reliability of a witness. So there's credibility. Are they trying to tell the truth? Are they honest people? And the like. But ability to observe or remember might be not to do with their character at all. It might be to do with their eyesight. Me, if I don't have my glasses on, my evidence of what I see is not particularly worthwhile. Or remember facts and events. I must say sometimes my memory isn't the strongest, so also true of me. And neither of those, I think, reflect on my character or my honesty. I'll try and do my best, even though I'll be pretty useless at the end of the day. So credibility in Australia doesn't just mean honesty. It also includes reliability. And I say that because that is not always the approach taken to this rule. New Zealand, they don't have a credibility rule, they have what is called a veracity rule, just another term, but it's specifically defined to mean the disposition of the witness to lie or to refrain from lying. It's about their character, it's about their honesty, it's not about their reliability, whether they can see or not. It's not about the accuracy of their testimony, it's just about them. Are they the kind of person who lies or the kind of person who isn't? All right, so that's one different way of describing credibility, and it makes me look at the credibility rule in the Maldives, and it doesn't clearly state either way whether it includes things like reliability. All right, it doesn't refer to ability to observe or remember, doesn't use the term or an equivalent term to reliability. It talks about the term credibility, but it doesn't make it clear whether reliability is part of that assessment. On the other hand, look at that last bit of the English translation, and again I am told by many that this might be inaccurate, but it certainly caught my attention. It says it correctly defines credibility evidence by saying it's defined by how it's being used. Someone raises an issue for a purpose, like most rules of evidence, and the purpose might be to nullify the credibility, it might be to bolster the witness, to indicate the extent to which the court may rely on the witness, might not be much, it might be a lot, or to nullify the credibility of the witness, to say that they are not a believable person in one way or another, or the testimony given by a witness, to nullify the testimony given by a witness. Now, again with a caveat about the translation, if those words were taken for granted, if they were read literally, calling evidence that what the witness said in court is incorrect would be an attack on their credibility, all right, under this rule, would be part of the credibility rule. Now, in a sense, that makes sense. I mean, if you say something and then someone says, nope, that's wrong, I saw it and you're wrong, they are attacking your credibility. You would feel attacked by this. You would be sad about it. If they say, you're wrong because I saw you at a different location at the same time. Again, you've been accused of being a liar, right? But they are also just disagreeing with what you said. all right? And we all know that in proceedings it's totally normal to disagree with what a witness says. It's kind of part of the point of the proceeding is to contradict a witness at times with other evidence. There can be no assumption that everyone agrees during a trial. All right, so if, and it's a big if, the Maldives credibility rule covers not just the extent to which a court can trust a witness or the creditworthiness of a witness, but also the extent to which the testimony given by the witness is incorrect or nullified, then that's a much broader credibility rule. All right? Maybe that's not the intent. It's certainly not how the Australian rule is read. That being said, its main effect would be to limit contradictions of a witness's testimony initially to their cross-examination. That is, a witness speaks, and before a party calls evidence saying that witness is wrong, they first have to cross-examine that witness about what they said. And that isn't too unusual. There's a rule of fairness that applies in many jurisdictions. It's called the rule in Brown and Dunn in English and Australian jurisdictions, which says if you're going to contradict a witness, you have to put that to the witness as a matter of fairness. So if the Maldives credibility rule is that broad, then, well, it's not necessarily a crisis, even if it's a bit unusual in terms of comparisons to other jurisdictions. But I, of course, cannot say with any certainty that that translation or my reading of it is remotely correct. I don't have that level of confidence. Can I also point to a different difference between the Maldives and Australian rule, which is potentially of some significance? So Australia has a definition of credibility, it has a credibility rule, and it has a definition of what is called credibility evidence, which is a complex definition, and I've only given part of it. It says credibility evidence is evidence relevant to the credibility of, say, a witness that is relevant only because it affects the assessment of the credibility of the witness or person. That's a traditional approach of common law jurisdictions. They distinguish between evidence that is only about credibility or evidence that is about more than just credibility. And so where you contradict a witness, sometimes you are saying not just that they are incredible, but that they are wrong. And that is regarded, that's often worded as going to a fact-in issue rather than just credibility. So that's a distinction, very difficult distinction, I must say. I find the line between the two sometimes quite hard. I'll try and give some Patterson examples of this. But nevertheless, it's a very traditional distinction. But when I look at the credibility rule in the Maldives, it is not express. There seems to be no distinction between evidence that is that a court may rely on for a credibility purpose that is partly perhaps being offered for a credibility purpose, but is also being offered for other purposes. That doesn't seem to appear in the Maldives rule. All right. Okay, so like I said, the heart of the credibility rule is this idea of looking at the person rather than just their testimony, although of course the Maldives might go further. In the Patterson case, there was a lot of scrutiny of Erin Patterson, and another thing that turned the Australian public against her, not that that needed much doing at that point, was that it turned out she did seem to have a history of lying in various ways, big and small. So she did tell various lies in the aftermath of the investigation about things like where did she buy the mushrooms from and where did she get the mushrooms from. It also turned out she'd told lies prior to the lunch and indeed during the lunch. So during the lunch, you might recall that she held the lunch ostensibly for the purpose of telling these 4 relatives of hers that she had cancer and she wanted their advice on how to break it to the children. This is very heart-rending stuff. And so that actually did happen at the lunch. The witnesses said she had that conversation with them. And of course, this was all relayed at a time when they started getting very ill. And the prosecution called a lot of evidence to show that she did not have cancer, had not received a diagnosis of cancer, had nothing like that. And in fact, she conceded in her own testimony, and I think through her lawyer, that she did not have cancer. All right. So that's a sign of a lie. It shows, I mean, people who say they have cancer and don't have cancer, people think pretty lowly of those people, I've got to say. That's a pretty bad hit. I wouldn't trust anything that person said after that, typically without some extenuating circumstances. Here, though, it's not just relevant to that, it's also, it's kind of incriminating for a different reason. Not just she's an untrustworthy person who says, makes claims about her health that are false. But the question comes, why did she make this particular claim? And the obvious explanation was to ensure that people came to her lunch and didn't keep away, because she said, I have important news to tell you, but also to ensure that her children weren't at the lunch. The nicest thing you can say about Erin Patterson, she made a lot of efforts to make sure her children didn't get death cap poisoning. I think it's the only nice thing you can say about it. Well, we'll get to another in a moment. But that's the thing, the cancer story wasn't just a lie, doesn't just mean she's a serial fabricator. It's part of her plot, would argue the prosecution. This is how she achieved her goal. And that's exactly the distinction, I think, between evidence that goes only to credibility, where it's just proving she's a liar, don't trust anything she says, and evidence that goes beyond to a fact and issue. This was part of her plot. Together with actually baking the beef Wellington, she had to create a situation where the people she wanted to kill, for no known reason, were in the room and her children were not. All right, so that's an example. Here's the interesting thing, though. She actually has a history of lying about her health. So there were texts put into the case where she'd made claims about other bodily problems she had, all right? And those weren't to set up poisoning, they were just because she likes to lie about her health. So weirdly enough, one of her defences in this case was, I know it looks suspicious so I lied about cancer, but I always lie about my health, was her defence of her actions. Not, of course, it doesn't make her sound more credible, it makes her sound less credible, she sounds crazy, but it does take the sting off the idea that this is part of her plot, because actually she's the kind of person who does this all the time. Difficult position she was in this case, I have to say. And the defence did a pretty good job trying to come up with or to support these scenarios. On the witness stand, she also claimed that the reality was she lied about the cancer not because she was trying to set up a poisoning or even that she just liked to lie, but because the reality was she was overweight and wanted to get an operation, stomach stapling or something, to cause her to lose weight, and she was deeply embarrassed about it. So because she wanted to hide the embarrassment of needing surgery to avoid being so fat, she made up a story about cancer to remove the embarrassment while still giving advice about things. She wanted to make sure that someone could care for her kids while she was off getting her surgery or whatever. So that was her other explanation. I guess it's a plausible explanation, and I should also add that she also claimed that she had an eating disorder, which meant that she would binge eat and then vomit every now and then. In fact, that was her explanation for why she didn't get sick. She said she ate the beef Wellington, and then after everyone left, she also ate a massive big cake and then vomited it all up, and that's why she didn't get sick. I mean, it's an amazing effort to come up with a story, but it's kind of got a bit of plausibility to it. Except when she tried to say, then they said, so where are you going to get this operation? She said she named a clinic in Melbourne. On the stand, the prosecution had never heard of this before, but they went away. She was on the stand for 5 days, and they came back and they said, we've asked that clinic and they don't do this operation at all. They don't do anything like that. They're like skin treatments and things like that. And so she had to concede on the stand that whatever was going on with that clinic had nothing to do with what she just said was going on. All right, so that's another instance where it attacks her credibility. Again, makes her look very much like she shouldn't be trusted. But it also goes that little bit further and says that the story she gave, her explanation for why she told the earlier lie about cancer, is itself seemingly a lie. And we are starting to really worry that actually maybe she is what she appears to be. All right, so those are some examples. Let's just look at the cross-examination exception. So the credibility rule is not really when it says you cannot use credibility evidence, it's not being honest. Because the reality is you totally can use credibility evidence. Everyone knows in trials that you can use credibility evidence. With a wrinkle we've already asked about, but I'll refer to again in the Maldives. The point of the rule generally is that the credibility conversation should start in cross-examination. That is, no court wants to take time listening to how great a witness is. but they are open to listening to how bad a witness is, and that will be raised. And the rule is, and not only that, they first want that to be raised when the witness is on the stand, not just with some other witness who wants to badmouth the first witness. So the rule is, and here's the Maldives version, 127B, except under the following circumstances, evidence submitted under the credibility rule is inadmissible in court. What are the exceptions? I've listed two here, and the first one is evidence adduced in cross-examination. I'm sad to see that word adduced there, but it is what it is, and it's the translation that's there. And it also mentions evidence adduced in rebuttal by a witness during cross-examination. I find that a little bit cryptic, that one, but it certainly seems to cover things being said during cross-examination. It could perhaps cover the situation I opened this segment with, where two different parties cross-examine a witness and the second cross-examination is used to rebut the first. I guess that could be what it's talking about. The equivalent in section 103, the exception cross-examination is to credibility. The credibility rule does not apply in evidence adduced in cross-examination. Very similar wording to the exception in 127B1, but there's a caveat. If the evidence could substantially affect the assessment of the credibility of the witness. Not just affect, but substantially affect. The idea there is to shield a witness from minor attacks on credibility. Asking the witness, isn't it true that when you were 5 years old, your mother told you to clean your room, and you said you cleaned your room, but did you clean your room? And the answer will be no. That's not going to affect anything, right? So minor lies, strange indiscretions. I mean, you could go further than this, but this is meant to be protecting witnesses from things that are relatively unimportant and focusing on the more important attacks on credibility. And there's guidance. So there are two matters the court has to consider: whether the evidence tends to prove the witness knowingly or recklessly made a false representation when the witness was under an obligation to tell the truth, and how long. It's one thing to look at recent lies, it's another thing to look at lies from 10 or 20 years ago, I guess, all right? But the Maldives credibility rule does not have that substantiality requirement. On the other hand, there are other protections against improper questioning for cross-examination which might have some effect to this extent. All right. I better mention here this elephant in the room to an extent, which is section 99B of the Maldives Act, which I've already mentioned, which purports to put a different limit on cross-examination. The cross-examination must be about the testimony. Depending on how you read that, that could limit some credibility evidence which could be regarded as separate from testimony. I can't say I'm a fan of that rule, but that might be its effect in that situation. So one problem with that rule is how to reconcile it or read it consistently with section 127. I think it is possible to read them consistently, but I think it's also a bit awkward to do so. Something needs to be sourced out one way or the other with the interaction of those two rules. Right, as I said, there was a fair amount of attacks on Erin Patterson's credibility, and these were all initially raised with her in cross-examination. So things like that when she spoke to the police, she told various lies. So one was that she said that she'd never had this dehydrator, which in fact she had recently thrown out. Another is that she actually not lied, but acted in a deceptive way. This is the bottom left picture is a picture of her when a search warrant was being executed at her house. They were trying to find signs of poisoning. She handed over her phone, but then she took a brief break, went to another room, had another phone, and auto-wiped the phone she had handed over. Again, this is in the area of she seems pretty dishonest and unhelpful and odd, and I wouldn't trust her, but maybe it's a little more serious than that. Maybe she had something to hide in the dehydrator or in her phone. All right. But she said, just for what it's worth, all that was happening was she was panicking. She was someone who had made a terrible, terrible error. She had accidentally killed 3 people and grievously harmed a 4th, and simply hoped that she would not be caught for that accident. That is, of course, a terrible thing, but it is not murder. So that was her argument, is that bad as these things looked, they were not that bad. Australia has special rules about how to deal with some of that evidence, but they do not appear in the Maldives Act. All right. I do want to cover some extra rules in the Maldives about rebuttal. So the initial rule of the credibility rule is you start the conversation in cross-examination. You ask the witness about the problems with their credibility. Didn't you tell this lie? Didn't you tell that lie? Didn't you have this problem in your past? Are you sure you had cancer, and so on? You ask all those questions in cross-examination. Ideally, that resolves the issue. The witness, being honest and on oath, says, yes, I do tell lies. Yes, I didn't have cancer. Yes, I did act suspiciously. Yes, I wiped my phone. Yes, I'm a dishonest person. Yes, I had prior convictions, and they give a big long list of things. And that would be the end of the conversation. The reality, of course, is that many witnesses will deny that claim in cross-examination. For one of two reasons. One is the claim might be false, and the other is, of course, the claim might be true, but they are simply telling a further lie. It would be invidious if that could be not explored further, so all jurisdictions allow further steps after that denial has come. The Maldives does so at several points. Let me just talk about some of these. So, 127B has two further exceptions, which aren't expressly about rebuttal, but would cover some aspects of this, or rehabilitation of evidence. Evidence submitted in respect of a statement made by the witness during cross-examination to show the credibility of the witness. So this allows a reply, I think, in other evidence, for example, in re-examination or in a future witness that rebuts whatever it is the witness said in cross-examination. So that means if the witness admitted to being a liar or admitted to being uncredible, the further evidence could clarify that and perhaps diminish it a little. Might explain why they told a lie for a good reason or something like that. If they denied being a liar or tried to explain it away, the further evidence could clarify that and say, actually, no, their denial was false, or that it is much worse than the witness presented. There's also one specifically for an accused, and this is the closest Maldives gets to the general permission that most jurisdictions have for an accused to lead evidence of their good character, which is that an exception to the credibility rule, but not the other rules, is evidence that will demonstrate the credibility of the accused. So in the Maldives, you could lead evidence that the witness is a credible person without complying with the credibility rule. Note that you would still have to comply with the hearsay and opinion rule. So putting in a reference from someone saying, I would trust this person, a letter or the like, depending on the nuances of the hearsay and opinion rules, would be barred or would have to find an exception within those rules. Section 128, which is titled a little bit misleadingly in the English translation, evidence during cross-examination, is actually about what comes after cross-examination. The credibility rule does not apply to evidence that is submitted to disprove any statements by the witness during cross-examination. I do look at that and wonder, how does that sit with 127B2 exactly? They seem to be similar ground. Note there's a caveat in 128B. Evidence may only be submitted pursuant to subsection A if the evidence assists in proving the existence of a particular fact. There seems to be language that says it's not good enough just to give a disproof of the statement made by during cross-examination to show that the witness is incredible. You're actually trying to prove that what they said was wrong. I can't assist further with the particular meaning of 128. If anyone's got an insight, I'd be keen to know. And finally, then 129 is entitled evidence which proves wrongful intent. Again, that's a bit of a cryptic heading. The ground is actually very traditional grounds on which you can explore credibility issues beyond that witness. So you have a witness who is asked various questions about their credibility, they deny them. 129 says, well, that's okay, the conversation can continue, further witnesses can be called by the opposing party, I guess, but it could also sometimes be the same party trying to rehabilitate on these issues. Whether the witness is biased or has a motive or intention to be untruthful about a certain matter. Lack of awareness, and this is a sign that the credibility definition in the Maldives does indeed include some aspects of reliability. Whether the witness has made a prior inconsistent statement, it doesn't expressly allow consistent statements which might bolster a witness. Whether the witness was convicted of a similar or related type of offence as the current case. That language seems to assume that the witness is the defendant, but that won't necessarily be the case. and whether the witness has knowingly or recklessly made a false representation when the witness knew he was under an obligation to tell the truth. Notice the caveat at B. Any evidence specified in subsection A may only be submitted if such evidence was obtained based on sources other than from the witness, and where the witness denies the subject matter of the allegation. So this is a situation where the witness has been asked about it, says that's not true, then you call your new witness to say, actually, on these 5 topics, it is true. Notice it's only those 5 topics. Other attacks on credibility are not expressly allowed by section 129. These are really attacks that go to character. There might be other ways to attack someone's credibility. It's not clear how they are allowed. You'd have to rely on 127B2 or 128. And I find those, I'm not sure exactly what is intended by those. Can I just draw everyone's attention to how this is dealt with in Australia, given that some of the language is borrowed from Australia, but not all. So 106, exception rebutting denials by other evidence, is very much the same ground as is 129. The credibility rule does not apply to evidence that is relevant to a witness's credibility and is deduced otherwise than from the witness, same language, if in cross-examination of the witness the substance of the evidence was put to the witness denied or did not admit or agree to the substance of the evidence, and the court gives leave. So very similar language to 129B, but a general ability for the court to give leave no matter the subject matter. Now, one thing I haven't put on the screen is that the later section of 106 say you don't need leave in some situations, and those situations are the same as the ones listed in 129A, 1, 2, 3, 4 and 5, pretty much the same ones. So I think there's clearly some relationship between the Maldivian 129 and the Australian 106, but the Australia's 106 is simply not that limited. If you get the court's approval, you can do any rebuttal of a denied claim about credibility. So the Australian court one is broader. That is actually a relatively recent change to Australian law, and it was done because this earlier list in 129A that is now there was regarded as too confining. There were other situations where it was appropriate to rebut a denial of credibility. I also want to note 108, which is an express exception for something which isn't really expressly covered, at least in clear terms in Maldivian law, re-establishing credibility. 108.1 just flat out says the credibility rule does not apply to evidence adduced in re-examination of a witness. That is, the credibility rule does apply in examination in chief, doesn't apply in cross-examination for the most part, and doesn't apply in re-examination. Right? Re-examination, as you all know, is responsive to cross-examination, so effectively, if there is an attack in cross-examination, it can be responded to in re-examination. In practice, that makes perfect sense, of course. The witness admits that they're a liar, but in re-examination you say, well, tell us more about that. And it turns out the lie was to protect a life or something, some nice reason to lie. You rehabilitate the witness that way. There's also a further exception, which again does not appear to be in the Maldivian rule, which allows evidence of the prior consistent statement of a witness. I know that in the Maldives it's typical to have the witness statement of a witness. This may not be limited to the witness statement, a prior consistent statement of the witness. In one of two circumstances, if they've been accused of making an inconsistent statement in the past, you can also bring up their consistent statements in the past, or alternatively, if it's been suggested that what they're saying now has been recently fabricated. You can say, no, it wasn't recently fabricated. I fabricated it a long time ago, and here's my evidence that I consistently said the same thing back then. Again, that needs court leave. So those approaches in Australia are only partly picked up in the Maldives, and just noting that difference. We've got to the tendency rule, but I'll pause there. We're on the final section, you'd be relieved to hear, but are there any questions either about the credibility rule or any other topic? Yes? It's novel in the Maldives, yeah. I mean, questions are surely asked about credibility at times in the Maldives, but are you saying the rule itself is novel?
Yeah, I mean, it was incorporated into legislation, like through the
the thing is, like, in practice, my question really is regarding procedure. So I'll give an actual example. So in one case where at court, during cross-examination, actually we submitted the evidence under this rule. But then the question shifted to a matter of relevance, because the main fact and issue is obviously related to the crime.
Yes.
But then the evidence was submitted with regards to the credibility of the witness to disprove something that they were actually giving testimony for. So my question is, like, how is the court procedure in Australia? Like, if there is any chance of evidence where do you submit it prior to the trial, or like during trial? Because it's not always some things that we submit its documents and so and so. So that's my question. How is the procedure? Because it's kind of, since it's new, like we're still in the process of testing it out as a court.
Yeah, I mean, one thing I've been learning from the prosecutors here is that there is a significant difference in procedure in some respects. So typically, in Australia, when someone can be arrested and the charge may come much later. Sorry, I've got that wrong. Someone is arrested and they might be charged straight away with an offence and either bailed or remanded. But the prosecution will get involved later and will only communicate later with the other side, start disclosing and provide particulars. But my understanding is in the Maldives, the arrest happens and then 45 or so days later, a charge is laid, and the crucial difference is at the time the charge is laid, a list of witnesses and statements and the like are available, and then there's a discussion that more or less binds the prosecution, except with narrow circumstances. So everyone comes into a Maldivian prosecution with a much clearer idea from the moment of charge of what is going to be argued. Australia is much looser. The charge might just be a general charge and the evidence gets worked out later. Now that being said, of course prosecutors have to disclose all evidence of the offence, both evidence they're going to rely on but also evidence they're not going to rely on, particularly evidence that helps to exonerate the accused. So the accused will have a whole lot of information, but that is different from knowing what the prosecution is going to argue. So the other thing about, and then the other looseness is, while many rules of evidence in Australia require notice to the other side, hearsay exceptions do, tendency and coincidence do, there are some notice requirements now in Maldives under, or proposed under regulations. Credibility does not require notice. No one has to tell the other side they're planning to attack credibility. In fact, if anything, I think this is a little uncomfortable, but it's true, the idea is you ambush the witness and the party with this information. So the approach in Australia is looser and allows for less notice in this particular field. But I understand the Maldives is not like that. So there's a really interesting question of whether this rule is a good fit and how it fits exactly with Maldives practice. I don't have an easy answer to that, but all I can say is that that does strike me as a quite different approach. I mean, I've asked a lot of questions about the approach because I keep getting surprised by it. Things change, things happen. You can never wholly plan. In between the charge and the trial, things will change. During the trial, things will change. During a witness's testimony, things will change. And I keep wondering, how do you deal with that? In Australia, it would be commonplace to deal with those problems. Here it seems more exceptional. So I don't otherwise have any easy answers on how to deal with that problem. Yeah. And just noting, of course, remember that there are all these caveats. So Section 99B, of course, really on one reading limits these kind of credibility attacks anyway, which might reflect the assumption that these sorts of extra ambushes aren't really proper part of the trial procedure here. I'm not here to criticise that, I'm just saying what I'm used to, not at all that that's a bad system. In some ways it might be a good system. One thing I might have just addressed more generally, I realised I was going to mention this and didn't. It's worth noticing that the Evidence Act deals with credibility multiple times throughout its provisions. I've just dealt with the credibility rule, but terms like credibility or similar terms, and again translation is an issue here, appear at least two other points in the Act. One is that at the point of assessing competence or capacity. A witness must not just be the right age and made an oath and so on, but also is required to be credible. But there's a specific definition of credibility, which is about the lack of particularly disqualifying factors. And even then there's an exception if that person is the only witness. That's, to my mind, really about not the subject matter of the credibility rule, which is about all sorts of features of a witness, but rather about a very narrow sense of whether they're credit-worthy. And I understand, of course, that reflects some aspects of Sharia. That's one point. There's another provision, I'm sorry, I don't have the number in my head, but it's one which says that a party can request a court to make an assessment of the credibility of the witness, and when a court does that, it addresses the following factors. It's in part 2 somewhere. I can't remember the number, though. I can look it up later if need be. To my mind, that's actually less of that's less about submitting evidence. It's not even about what I call assessing evidence, the decision on whether you're allowed to take account of a witness. It's really about what use you make of this witness on the path to a verdict. You decide whether they're credible or not. And so that to me more sounds like a proof rule. It's a little bit confusing though, because the Act uses this term in so many different spots, and I'm not sure the various rules fit together without some way of distinguishing the subject matter of each. So, but that's another complication in the Act. In Australia, of course, there's no test of credibility at the capacity stage, and nor are there any set rules on how a court determines whether to trust a witness at the end of the day. That's left to common sense or to the judge's thinking rather than any rule book. All right, okay, are we right to do the home stretch and finish? Or, yep, everyone's cool with that. All right, so we come to the last 2 rules that I want to cover today. I put them on separate pages, but they are often read as being together, and it's generally how I'll treat them. And that is the tendency rule and the coincidence rule. The terminology is very much an Australian invention. This terminology did not exist previously in any jurisdictions. It wasn't borrowed from the Federal Rules of Evidence. It was developed by the Australian Law Reform Commission. The history to this idea was that there is a long-standing difficulty in everyone's evidence law, but particularly in Australia's and England's, about how, not about when the trial can become about a particular witness, or when a trial becomes about the accused. So a trial is meant to be, of course, about the question of what did the accused do, what was the accused thinking on a particular occasion. That's how these criminal trials work. But there's always a temptation to instead say, is this person a good person or not? All right, and many people in their real life are always keen to know about the person at the heart of the allegations rather than the evidence at the heart of the allegations. That was certainly true in the Erin Patterson case, as it is in many. Everyone was desperate to know more about her. Who is this person? Is she a nice person? Is she a bad person? Is she a crazy person? Is she a stupid person? Is she a smart person? Is she a psychopath? All those questions, everyone was desperate to know the answers. Most jurisdictions hesitate to let a criminal trial become about those questions. They will say, no, the question is, did she poison them and did she mean to poison them, rather than who she is. So for a century or more, the courts in Australia and England and elsewhere have struggled with this question because although they say that the trial should just be about what the accused did and said, they do concede that there are situations when knowing the background of the accused can be quite revealing. So they keep trying to find hopefully narrow situations when you can learn something about the background of the accused. And there's a terrible history of courts saying, we've come up with a rule, this is the rule, we've settled it once and for all, and then 3 years later saying, we've changed our mind, this is the rule, we've settled it once and for all, and they do this sequentially, and every time they find a reason to let in the evidence in the case before them, while purporting to say that this is a very narrow situation and they're not going to do it much again, and yet they do. It reflects, I think, ordinary people's desire to know about the accused rather than just the evidence against them. So the Australian Law Reform Commission said, look, we're going to try and work out what's going on here. We're going to try not to make this just about the narrow context of things like whether the court can learn of the accused's prior convictions, which is often the focus of these inquiries. Let's come up with some general rules that try and regulate this issue. And so they came up with 2 rules. They couldn't come up with just one, they came up with 2, although as I'll describe, they are 2 very closely related rules on 2 closely related ideas. They overlap. All right. So, I'll start with the Maldives rule. I never know which order to do these in. So section 22 of the Maldivian Evidence Act defines tendency rule, and this time they actually are describing a rule, not just the concept of a tendency. Tendency rule means the rule where a defendant has maybe they are defining evidence. Tendency rule means a rule where a defendant has previously acted in a particular way or with a particular state of mind under particular circumstances in the past may be used to infer that the defendant also acted in the same way with the same state of mind under similar circumstances in the ongoing case. This is actually a very similar formulation to the draft the Australian Law Reform Commission came up with in the 1980s and then got adopted in Barbados. So what this is about is the idea that people don't act randomly, or they don't always act randomly. Sometimes there's a pattern to their behaviour. If someone does a particular thing at one point, everyone's experience, at least for some of those things, is they may well do it again. And if there's evidence suggesting they might have done it again, it's much more believable if they've done it previously. Okay, so that's what the rule is about. And then in the Maldives, the actual tendency rule in section 123 says, evidence shall be admissible in court under the tendency rule if, I think this means only if, upon its admission, the evidence will assist the court in assessing the existence or non-existence of a particular fact in issue. All right, so, and that language, will assist the court, strikes me as pretty mild language. It reads as if it's just a test of relevance, although note what I said earlier, that the language will assist the court might go a little bit beyond relevance to also include a capacity for a court to exercise a degree of discretion in deciding what counts as assistance and what counts sufficiently as assistance. And we'll get to the detail provided in section 124 about that in a couple of slides. I want to contrast this with section 97 of Australia's Uniform Evidence Law, which is its tendency rule, and like I said, this is the start, this is where this all came from. It says, evidence of the character, reputation or conduct of a person, or a tendency the person has or had, is not admissible to prove that a person has or had a tendency, whether because of the person's character or otherwise, to act in a particular way or to have a particular state of mind. And then there are, unless, and it provides 2 requirements for such evidence. So I'll just get to those 2 requirements in a moment, but notice that this is in some ways a different rule. It is not limited to the character, reputation or conduct or tendencies of the defendant. It's any person's behaviour that could be subject to the tendency rule. So for example, in an Australian murder trial, the tendency rule would govern not just questions about the tendency of the accused, but also perhaps questions about the tendency of the victim. That's an example of that. If I could use an example from the Patterson case, we have an exchange that got a lot of attention, a text exchange between Erin Patterson and her estranged husband. He was also invited to the lunch. And the day before, he texted her, and it's a little bit hard to read in my version, but I'll just give you the gist of it. He said, sorry, Erin, look, I don't feel comfortable coming to lunch. I'm very happy to talk to you about your health, but let's do it by phone. All right? And right away, that's actually evidence of his relationship with his wife, and something about him that he's a little hesitant to go near her, which could be revealing in all sorts of ways. That could be within the tendency rule in Australia. It would not be within the tendency rule in the Maldives because it's not about the defendant. What could be within the tendency rule about the defendant in the Maldives is her response. She sent back a response saying, I'm so disappointed in that. It's so disappointing to me you're not coming to lunch. I put a huge amount of effort into this beef Wellington I'm making, and you've really devastated me by not coming. Please reconsider. Now, one way that reading that is that she has a tendency to, no big deal not coming to lunch, right? But she has a tendency to make a big deal of that. Maybe because she's the kind of person who just takes affront easily. Maybe because it's revealing of the complexities of her relationship with her estranged husband, that she's putting a bit of emotional burden on him for a simple thing like not coming to lunch. It could also just be a sign that she really, really wanted him to come to lunch for whatever reason. So that's a possibility. It could be a sign of something very bad, that she actually was trying to get him to endanger himself in some way. All right. The other thing to note about the Australian rule, which differs from the Maldivian one, is the Australian rule has two requirements before tenancy evidence can be used. One is a notice requirement. The idea is if you're going to go to the question not of what happened, but who are these people, what are they like, then you need to tell the other side you're planning to do that. Prosecution, of course, has to disclose all the evidence they have anyway, but there's an extra requirement. They have to tell the other side, we are going to talk about who these people are, their tendencies. The defence also has to give notice to say that they plan to talk about someone's tendencies as well, outside a situation where they're rebutting the other side's tendency argument. The notice requirement is a little bit flexible, but here I better talk a little bit more about the notice requirement. There's no such notice requirement in the Maldives Evidence Act, but there is a proposed notice requirement for tendency evidence and coincidence evidence in the Supreme Court's evidence regulations. It serves a good purpose. Notice is a good thing. Everyone should know what's coming. I like notice. But I have to say that notice is a very complex thing for a very subtle rule like this one. The difficulty that a notice requirement can cause, and this isn't a reason not to do it, it's just a reason to recognise it can be hard, is for a start, it can be hard to pick when something is a tendency or not. Is someone getting annoyed at another person on a couple of occasions a tendency, or is that just life and a relationship? What counts? What's the line between tendency and no tendency is a hard question at times. Secondly, a notice requirement, typically, it's not enough just to say, I'm going to raise a tendency argument. What tendency argument? So someone's going to have to describe the tendency. And the thing is, we aren't very good at describing tendencies. Tendencies can be subtle, contextual, can use difficult language, could be 5 different tendencies bundled into one. Views could differ about which tendency you talk about. I described a dozen tendencies each for this boring exchange of text, or seemingly boring exchange of text between parties. Having to put it into notice can be quite fraught, especially if you don't quite manage to capture the idea you have in mind, and yet you're meant to notify the other side. And third, typically you then have to identify in the notice what evidence you're going to rely upon. And again, that's a subtle thing, because different evidence has different qualities. It's one thing to rely on a particular prior conviction or something, but what if you're just relying on the fact that one person described what could have been a particular interaction, but we're not totally sure, or 3 people saw different things and 2 of them seem to describe something consistent with a tendency. It gets hard. So I'm not saying that tendency notices are bad things. I think they have positives, but they are complex things. And although I'm not in practice in Australia, I read a lot of the appeal cases about these matters, and there's a recurrent theme of having difficulty with these notices. That being said, part of the solution there is flexibility. The court should be willing to let people make reasonable changes to their notice, although, of course, bearing in mind fairness to the other side. The second requirement in Australia is significant probative value. It's not enough just to have some relevance to the tendency, it has to make a big difference. Okay, and quite what counts as a big difference is a hard thing to capture, but that is the requirement. A small difference is not enough, and I will give some examples of sorts in a couple of slides. But notice that in the Maldives, that isn't the requirement, just that the tendency will assist the court. It seems to be a lesser requirement. I've given an example just at the top left. Erin Patterson, in the months before her lunch, posted to her friends on Facebook, the ones who she talks true crime with, that she'd learnt a new trick to get her kids to eat their vegetables. She powdered mushrooms with her dehydrator and then hid them in the chocolate brownies she made for the kids. So she's basically mentioning that she has a tendency to surreptitiously give mushrooms to people. So that's the kind of tendency that does kind of look bad in a case of alleged poisoning, and doing it intentionally and deceptively looks bad. But of course the other side of this is she's just trying to get her kids to eat their vegetables. This isn't outside bounds of behaviour or anything like that. It seems much milder. The kids have no idea. She's doing it publicly. It's not the most damaging thing. So, yeah, it's the kind of tendency that I think would struggle to meet a significant probative value standard in Australia, but might assist the court, I guess, in the Maldives. Now, there's more to say about that rule, but I want to address the other companion rule, which is the coincidence rule. This is the real sign that the Maldives has taken on Australian idea, is to have both of these rules, and especially the coincidence rule. Okay, so section 15 defines coincidence rule. And again, it's really defining coincidence evidence. Coincidence rule means the rule where a person does an act under two different circumstances, and having regard to any similarities in the events or circumstances in which they occurred, it is improbable that the events occurred coincidentally. I better mention here there is a definition of both tendency and coincidence themselves in the Act, but they are in such general terms that I don't think there are any assistance in understanding these terms, but I better mention that in passing. But here the idea is there are two different circumstances, and because they are similar, you think these are connected circumstances. This is all about looking for patterns. The way I think of the tendency and coincidence rules is they're both about patterns, about how human behaviour comes in patterns. With the tendency, you try to understand the pattern by understanding the person, and with a coincidence argument, you understand the pattern by understanding the events. If you know a lot about the person but not much about what they did, you use a tendency argument. If you know a lot about the events but not much about what might have been behind them, you use a coincidence argument. And here's the thing, if you know a lot about both the person and the events, then you use both tendency and coincidence, all right? Because both arguments apply. All right, so the most startling of coincidences in this case, the one that started off everyone's suspicions, is that 4 people got sick from the one lunch, all right? And it would be a coincidence if they all got independently sick. Maybe one of them got sick one way, one got sick another, but would 4 really get sick right after a lunch unless there's a common link? Of course not. And so that's a classic example of a coincidence argument. And the common link, the obvious culprit for the common link is the food, but of course it could have been something else. One of them could have had an infectious disease, the water in the house might have been bad, a kid might have been sick and infected everyone, there was, I don't know, the air was bad, something like that. There's a number of possibilities, but there's a common link. All right. The wording of the Maldives coincidence rule talks about a person doing an act under 2 different circumstances. It's not entirely clear to me that it would cover this particular coincidence. So here I have to talk about a problem with the term coincidence. We use the term coincidence in a lay sense in a lot of different ways. Here's an example of a coincidence we'd use in a lay sense. After the trial, it got reported, but the jury wasn't told about it, that you know how Erin Patterson dumped the dehydrator at a tip at some point a few days afterwards? That wasn't her only trip to the public landfill area. She also went to that same landfill area at 3:30 p.m. on the day of the lunch, and the lunch ended at 3 p.m. She went for some reason to a public disposal area half an hour after the lunch. Here I should mention some Australian ways of life. All Australians in most places have bins that they can put things in their own home that get collected weekly. You don't have to put your regular rubbish go to a public tip. It's an unusual thing to do unless you have a very big item. And yet she went and dumped us a bunch of small items that you couldn't quite make out in the CCTV 15 minutes after the lunch. Now, everyone would say, that doesn't sound like a coincidence to me. It sounds like she's dumping something from the lunch, right? But this is not the kind of coincidence that's covered by either the Maldives or the Australian coincidence rule, because it's not about similar events. There's nothing similar about these events at all. Here the coincidence is a coincidence of timing. It reflects the idea we all have in our head. If 2 things happen at about the same time, that might not be a coincidence. They might be linked, all right? That isn't regulated on my reading by either the Maldives or the Australian coincidence rule. If you look at the Australian coincidence rule, it says evidence that 2 or more events occurred is not admissible to prove that a person did a particular act or particular state of mind on the basis that, having regard to similarities, it is improbable that the events occurred coincidentally. That rule says you just look to the events and you think there's a person behind them. The Maldives rule, and so that would cover, I don't know, whether, would you count the lunch party as one event or as 4 events? There are 4 illnesses, they're kind of like 4 events, but just the one party. I don't know how you deal with that. Under the Maldives coincidence rule, you'd ask an act under 2 different circumstances. Well, there isn't an act under 2 different circumstances, is there? It's an act under the same circumstances affecting the same people. So that central coincidence is only on the borderline of the coincidence rule. All right, the other things to note, the Maldives coincidence rule, unlike the Maldives tendency rule, is not limited to defendants. It covers a coincidence involving any person, not just the defendant. All right? In practice, it will often be the criminal defendant who is that person, though. The test, again, in the Maldives is that the evidence will assist the court, rather than in Australia, where the test is the same as the tendency rule, reasonable notice and significant probative value. All right, let's now get to the details of the Maldives rule. So each of the rules, the tendency rule and the coincidence rule, is followed up by a list of factors the court shall consider. And I think this is the heart of the rules of the Maldives. It's not just an open-ended question, will this assist the court? The court must consider these factors. It doesn't mean they're limited to these factors. It doesn't mean that any of these factors is a test in and of itself for whether the evidence will be admitted. The court just has to think through each of these. So there's a list about the kind of contextual factors we require, how many circumstances are there that happened, when did they happen, how close were they really close, or were they only vaguely close, and so on, that sort of list. I'm not going to go through all of it. Whether it's been disputed, whether it's being rebutted, that sort of thing, whether the actions of the person are observed, whether a similar pattern of actions are recognisable, whether the way the person does a certain act is recognisable otherwise. So that's the kind of thing to think about. The coincidence rule has a similar but not quite the same list for a court to factor through. What courts do with this list of factors? Do they just look through the list and then shrug and say, well, I'm helped by this or I'm not? That's something I think that's going to have to sort it out by the courts of whether the details of these factors matter in particular cases more than others. Just to give you a few more examples from the Patterson case. Erin Patterson put into evidence pictures she'd taken of mushrooms years before the lunch incident. Because she initially said she bought the mushrooms at a supermarket and only later admitted she'd been foraging them, and then said she must have foraged death cap mushrooms accidentally, the prosecution was dubious and said, how do we know you were foraging mushrooms at all? Maybe you just made this up and the only mushrooms you've ever foraged are the death cap mushrooms that killed everyone at the lunch party, or almost everyone at the lunch party. So she said, no, I do have a habit of foraging, and put in some slight evidence. It wasn't very strong. She had a picture of some mushrooms. She had her kids said that she once took a photo of a mushroom when they were visiting a park. Not super evidence that she had a tendency, but given it's being adduced for her to rebut a claim that she was lying about foraging mushrooms, I think this is a plausible argument. Here's a coincidence argument from the Erin Patterson case. Remember I said there's a website that reported death cap mushrooms in an area that wasn't very common until 2023. They'd never reported any death cap mushrooms on that website in her area, but they did it twice in 2023 in the months leading up to lunch, 2 different locations, and both locations, cell phone evidence suggested that she went there the next day. So it's one thing if she happened to go the next day on one occasion right after the death cap mushrooms had been introduced. That could have been a coincidence. But doing it twice, no, it's sounding like there's a connection. What's the connection? Her checking the site and wanting to find death cap mushrooms. A classic coincidence argument under both the Maldives and Australian law. And so the court would consider the proximity in time between the 2 incidents. They were only a month apart and a few months before the lunch party. The extent of relevance between one incident and the other, they do seem pretty close. Remember, cell phone evidence is not the strongest evidence. We don't know for sure she was picking mushrooms. All we know is her phone pinged on a tower. The extent to which the events that occurred in one incident occurred in the other, well, we don't know much about either incident. The number of times, just 2. But this is just 2 of a very suspicious thing. The circumstances, we know nothing. The noticeable similarities, we know little. The primary reasons for the occurrence of each of the incidents, we don't know either. So a bit of a mixed list, but the proximity in time is the one that I think, and the unusualness of the events, strike me as most important. All right, we're almost at the end. I want to briefly talk about a rule in Australia which does not apply in the Maldives, and that is, I think, turned out to be crucial in the Patterson case. Australia, you might recall, requires reasonable notice for tendency and coincidence evidence. It requires significant probative value for tendency and coincidence evidence, but that is not enough. Australian courts say tendency and coincidence evidence is extremely dangerous, that when you start looking away from the events that are in question, what happened at the lunch, and move to who is this Erin Patterson person, what's she like, you take the risk of a miscarriage of justice, because it's easy once you put someone under scrutiny to dislike them. It's easy once you put them under scrutiny to judge them. I mean, the idea is we all have things in our past that if someone looked at, they might judge us for, because we tend to judge others a little more harshly than we judge ourselves. So the courts routinely say you need to be very careful about this evidence. There was an earlier poisoning case in Australia. This is a woman named Emily Perry, she had 3 husbands and 1 de facto partner, just a man she was living with. All 4 got arsenic poisoning over the course of several decades. So 1 died, and then another died, and then the 3rd died. And when she married her 4th husband, literally on the morning of the wedding, he received a phone call from the earlier husband's relatives saying, "Don't marry her, you're going to die." And he said, "That's nonsense," and hung up on them. And then he got arsenic poisoning, but he didn't die. He in fact appeared as a witness for the defence at her trial and stayed with her after she was convicted and then later cleared of the charge. Crucially, Australia's High Court said it was unfair to her to rely on this history of arsenic poisonings. Yes, it's very interesting that her husbands keep dying of arsenic poisoning, but the circumstances of each was quite different, and it's too risky. There's too much danger that a jury will decide that once she's had enough problems in her life, it's all about her. She's the problem here, okay? Not sure that's a correct ruling, but that's what they ruled, and that's why she was ultimately died outside of prison, happily married to the husband who she was acquitted of attempting to murder. All right, so the way this rule now works under the Australian Uniform Evidence Law is we have a further restriction, not on all tendency and coincidence evidence. Remember, this rule applies in civil and criminal proceedings. It applies to prosecution and defence evidence. It applies to any person, not just the defendant. But there's a further restriction for the usual situation where the prosecution leads evidence of a tendency or coincidence evidence about the defendant. Okay, and in that situation, in a criminal proceeding, and in that situation there's an additional rule. Tendency evidence about an accused or coincidence evidence about an accused that's adduced by the prosecution cannot be used unless the probative value of the evidence substantially outweighs any prejudicial effect it may have on the accused. This is yet another discretion, but it is designed to be weighted in favour of exclusion. The evidence has to be way stronger than the risks. Not just stronger than the risks, not just outweighed by the risks, but way stronger than the risks to use it. All right, so that's the test. And here's one thing I want to tell you about the Erin Patterson case that you might not know about, and that almost no one in Australia knows about because it's illegal to talk about it in Australia in a public way. So here's the big secret, which is, and I'm reading here from an article published in the Daily Mail in England. This rule doesn't bind anyone in the Maldives or in England or elsewhere. There's an article there which revealed that there was information that was kept from the jury. The information was why Simon Patterson said to Erin Patterson, "Actually, I'm not going to come to lunch after all. I don't feel comfortable with coming to lunch." And you'll recall she said, I'm really disappointed. The reason why, because he got very sick on 4 occasions in the past year, including 2 hospitalisations, one of which was a near-death incident. He required repair to his kidneys and the like. And he, at first, just thought he was having problems with his health. But then he came to a realisation that each of the incidents, the 4 incidents when he got sick, followed eating food prepared for him by Erin Patterson. They went on a family camping trip. He ate a stew. She made some cookies for him, and he got sick. She made a big spaghetti bolognese. He got sick. He was so concerned, he created a database. He went back through his records to determine the link. This wasn't just a vague suspicion. He kind of put it all together, and he didn't keep it to himself. He told people that he's worried that Erin Patterson was trying to poison him. He told his doctor that his wife was trying to poison him. She gave him more cookies, and he wouldn't eat them, and she kept sending him texts saying, have you tried the cookies yet? You should really try the cookies. Why haven't you tried the cookies yet? And he threw them out. Unfortunately, he should have kept them, of course, but he didn't. So once I heard that evidence, maybe you're the same as me, I thought, there's no doubt whatsoever in this case. I'm still confused what her motivations are. I don't know if she even has motivations. But she's clearly a murderer, a serial killer or something like that, because while I would discount Simon Patterson just saying, in hindsight, now I think about it, I did get sick a lot when she fed me, but it wasn't in hindsight. He openly recognised at the time that there was a problem. And remember, she did try to convince him to go to lunch, and that's why he said no. So that is explosive evidence that, to my mind, takes a case that was pretty strong for the prosecution and turns it into an inevitable win for the prosecution. So here's the thing. Why doesn't anyone in Australia know about it? Well, because the court had ruled prior to the trial that this evidence could not be used in Erin Patterson's trial for the over the lunch deaths. The prosecution actually had brought charges against Erin Patterson for the attempted murder of her husband on the 4 previous occasions, but the court had ruled that would have to be heard separately from the allegations about lunch. Now, I don't know why, because none of that has been published. Eventually it will be, and we'll get to read the judgment, but I'm pretty sure it's because of Section 101. I reckon what the court decided is, yes, this is strong evidence, but there's too much risk that the jury would do exactly what I just said, and thought, man, she's just a killer. And they said, that can't be a fair trial if that happens, all right? Now, this is complex because I haven't seen the judgment and I don't know what the ruling was, but it strikes me as a wrong ruling, even under Australian law. I think the probative value is far, far stronger than the risks about this evidence. And in fact, leaving this evidence out created a risk of miscarriage of justice, a wrongful acquittal by the jury. I'm shocked that it happened. I think the Australian legal system was lucky that the jury nevertheless convicted, which of course it was a strong case. It's not surprising they convicted, but they took 6 days to deliberate. Maybe they would have failed to convict, and I think the Australian public would riot if it came out later that the jury was not told about this other evidence. Maybe I'm being hyperbolic, that is nevertheless my feeling. I might be convinced otherwise when I read the judgment. Why then? So in Australia, because we have juries, whenever evidence is ruled as something the jury can't hear about, courts take steps to make sure the jury doesn't hear about it from another source. That's why no one could report on this evidence in Australia. And in fact, extreme steps were taken, which in hindsight now make more sense, to protect the jury from conversations with others. A jury got dismissed simply because he talked to his family about the case. The jury were kept hidden at a hotel for part of the trial. This was all to keep this evidence from them. This is the lengths Australia went to stop this explosive evidence reaching the jury. And the lengths continue. Even though Erin Patterson has now been found guilty of murder and will be sentenced in coming months, it's still being kept from the Australian people because of the risk that if she successfully appeals her trial, they'd have to hold a retrial before a new jury, and the moment this information reaches Australia and is allowed to be published by the Australian media, it'll be impossible to find a jury who doesn't know about this evidence. The only reason she might win her appeal is because it had already been public knowledge that she'd been charged with attempted murder of her husband. But the details of that allegation were never revealed, and at the start of the trial, the jury was simply told those charges have now been dropped, and you should put them out of your mind. I don't know if the jury did put them out of their minds. I even doubt the jury avoided hearing this information, because I think the whole town that they were working in would have known this information, but who knows. So that's the extremes Australia goes to in this area, just to manage tendency and coincidence evidence. In the Maldives, none of that, because there are no juries, and because a judge would be the one making all these decisions, and to the extent that it's impossible for a judge to give someone a fair trial having heard this evidence, there's no other solution. The judge would simply rule, well, I don't know what the judge would rule, but the judge would know this information. You would have to have a system where one judge decided admissibility and another decided what use to make of evidence in order to quarantine this information. I don't think that's a system that's imaginable in the Maldives. All right, I want to show you one last provision, and I think that's the end of it, yes. Oh, what have I done? Okay, current slide, that should do it. Just want to draw your attention to one last rule in Australia that does not appear to be in the Maldives Evidence Act, except in part. As I said, the purpose of the tendency and coincidence rule is to stop the trial being about the accused and just make it about what the accused is accused of. But there has always been an exception in Australian and English legal systems which says the accused can choose to make the trial about them. I would like to think if I was accused of a terrible trial, what I would do is call a bunch of people who are credible and good and nice seeming, who would say I'm a nice person. I can't imagine Jeremy murdering 4 people. I hope they would say, maybe I'm wrong. And I would try and make it about me. I guess that's my hope. So the idea is that an accused can do that, and they can call evidence to say they're a good person. And in Australia, this is considered so important and such an important right of the accused that none of the rules of evidence, or almost none of the rules of evidence, apply to such evidence. The hearsay rule, the opinion rule, the tendency rule, and the credibility rule do not apply to evidence adduced by an accused to prove that the accused is a person of good character. So you could literally call someone who had heard that others thought that you were generally nice, all right? And that would do. I mean, I could put in this letter of appointment in my trial to prove that, wow, I must be a good person because I am an honorary fellow appointed by the Prosecutor General. Hearsay, opinion, tendency, credibility, none of that would matter. I could do it. As it happens, there is actually evidence that Erin Patterson is a nice person, believe it or not. It got a lot of publicity, which is that she was quite wealthy. She'd inherited a lot of money from her mother or something, and her family are all dead, hopefully of natural causes. She had $2 million. What did she do with it? She lent it to everyone. Low interest or no interest loans to multiple relatives, including several of the people who were killed at the lunch. And no one suggested that there was something sinister in any of that. She just thought, I've got the money, I should help other people. It's a pretty nice thing to do. So that did come around, right? It came out actually not because she put it into evidence, but because it was part of the background to her relationship with her husband and these other people. It's part of the reason the prosecution felt they don't have a motive, because money just doesn't seem to be important to her. She's not trying to make money. She lent money to these people and didn't ask for the money back. She doesn't seem to think they're enemies. This really is a mystery. Although I firmly believe she killed them deliberately, I still have no idea why. That's evidence of her good character. So that rule, apart from credibility evidence, does not appear to be in the Maldives Evidence Act. It's not clear that there are exceptions that cover good character evidence. That isn't to say the evidence wouldn't come in, but it would have to go through each of the hurdles in the Evidence Act. Australia provides an easier path to bring that evidence in, but it also imposes a cost. The cost is that if the accused says they're of good character, the prosecution is free from the same rules to rebut that evidence, to say, yes, yeah, you're good in that way, but here's some ways that you are bad. Now, the way the Australian rules work is they distinguish between saying you're generally a good person, me waving around an honorary appointment, or an accused is allowed to say, I'm good in one specific way. I'm a generous person, or I'm an honest person, or I'm a peaceful person, or I'm a clever person, or whatever. All of that are specific aspects of character. If you raise your character generally, the prosecution can attack you generally. If you raise your character specifically, the prosecution can only attack you in that specific respect. So that's the Australian scheme for dealing with this issue, just noting that there's no equivalent scheme in the Maldives. And I should mention that although the Australian public is not allowed to know about this explosive evidence from Erin Patterson's husband, after the trial there was a whole lot of information published by the media, not about that, but about other aspects of Erin Patterson's past, that she'd, so mushroom chef Erin Patterson's drunken rampage uncovered. She'd lost her licence for drink driving after a particularly bad incident. And a bunch of people from her earlier work. Remember I was talking about your workmates having things to say about you. She used to be an air traffic controller in Melbourne Airport, and she wasn't very popular amongst the fellow employees at the air traffic control place. They said that she was troubling in all sorts of ways at work. They called her surname then was Scudder, Erin Scudder. They called her Scudder the Nutter. This is years back. One person claimed, though I really wonder when this claim emerged, that he felt sure she had poisoned his lunch in a refrigerator once, so pretty damning information if true, but I don't know if it's true. That's the kind of information that even when you can say I'm a generous person, you would be careful to confine your argument to generosity, because you wouldn't want the prosecution to be free to raise, yes, you're also a terrible drunk and a bad driver, or yes, all your workmates hate you, as rebuttal evidence. I should, of course, say that all of this evidence in Australia is still subject to discretionary exclusion. A court can still say, enough, we don't want to hear about Scudder the Nutter, we've got too much to do in this trial, stop, keep the drunk driving out of it. But nevertheless, that's the general rule, not in the Maldives. And I've reached the end. That's everything I want to cover. So the rest is questions from you, and otherwise we are free.
Question is regarding the classification of types of evidence. If the classifications are primary and secondary evidence,
yep.
The law is pretty clear on what could be characterized as primary and secondary. My question is, does the law foresee the parties to make the classification, or is it upon the judge to do so? And if it is upon the judge, then for whatever reason, the judge is to classify a primary piece of evidence as secondary for whatever rationale, then doesn't it open the verdict to be contested on error of law?
Mm-hmm.
Because in different fragments of the provisions containing that, we can see that there are ways for every piece of evidence to be characterized as primary and secondary.
So, Evidence Acts have a general issue, which is they tend to just declare some evidence can be dealt with in this way, some evidence is to be dealt with other ways, and so on. They don't typically say who makes these decisions. There are assumptions built in about who makes the decision. The answer I would give to you is it's not the parties or the judge, it's the statute that decides these things. It's setting a rule. And the judge's job is to interpret the statute, and the party's job is to make arguments, if necessary, about the meaning of the statute. It's only where the statute gives a discretion to the court, or is understood as giving a discretion, that it becomes a decision by the judge, rather than a decision of the judge understanding a decision of the statute that is to be interpreted by the judge. So the general answer is the judge's role is to interpret the law, not to decide for themselves how to classify things. The law is the one that sets out the classification. Of course, lots of laws are ambiguous, and lots of laws have room to decide things, and lots of laws use terms like will assist the court, which clearly involve a degree of flexibility or allow different judges to have different views in different circumstances. But ultimately, classifications, I would say, are for the statute with the judge's role simply to interpret the law, not to make their own independent decision. I should also mention though, and this was a criticism, remember I showed you at the very start of this, the Barbados Chief Justice saying that there's a problem in the Barbados Act, it has omissions and errors. What his particular problem? He was concerned that the rules stated in Australia's evidence law that got picked up in the Barbados don't say, they say credibility evidence is inadmissible, hearsay evidence is inadmissible, but they don't say if a party objects. Now we all know from evidence law practice that generally lots of things happen that are perhaps not quite in keeping with the law, but no one cares if no one in the room objects. The parties just sit there, they shrug, they either don't know or don't care, they're fine to let it in. The judge may or may not realise there's a problem, but might say, I don't want to take time resolving this issue. And if no one objects, they won't resolve it. All right? That's the reality of a lot of practice. And of course there are reasons for that. You make tactical decisions. You think, I will let that side call that evidence even though it's not quite compliant with the Act because I want to do the same thing. So classic reason to do that. That's the practice, but the Barbados Chief Justice's complaint was the law doesn't say that. It doesn't say only if a party objects. All right? The truth though is Australian courts have specifically ruled it's implicit that a party has to object before any of these rules matter, with a caveat that the judge should themselves intervene if it's important to a fair trial to apply the rule. So it's a little bit more complex than that. So in the case of the primary and secondary evidence distinction, that classification, it's specified in the statute unless the statute allows itself for a discretion. The parties can and perhaps should make submissions. The judge perhaps can and should raise situations where the judge is unsure, and ultimately the judge will decide, put it in their reasons, apply that distinction, though it's still not clear to me, the Maldivian Evidence Act does not clearly state what follows from that distinction, but to the extent that it matters, the judge should apply it. And then, as you said, if the judge has got it wrong, that strikes me as a potential appeal ground. Any error of law by a judge is, in my understanding of appeal law, is a potential appeal ground, although at least in Australia, and I assume this is also true in the Maldives, that doesn't mean the appeal will succeed. There's a question of materiality about the error. Maybe it did make a difference at the end of the day. But yeah, like I said, the real ambiguity to me isn't the distinction between primary and secondary evidence, though that is also a difficult distinction, but what follows from it? What does a judge make of that distinction? And the Maldivian Evidence Act is, on my reading, silent or a bit obscure about what follows from that in a way that, say, the Indian Evidence Act is much clearer. So at some point, if I had to guess, if this is not changed, this is the kind of issue that would make its way up the courts and perhaps to an apex court to formally resolve. There were equivalent issues in Australia where our Act was silent, which ultimately had to be resolved by the High Court. So not this distinction, mind you, but similarly vital, fundamental structural questions. Either they get resolved by the Parliament or they get resolved by a top court, or there's a third option, everyone just fumbles their way through because the stakes aren't high enough to resolve the question. So that's how I think that would work out. I think we're done.
I'll ask a question.
Oh yeah.
Who else has a question? In the beginning of the lecture, you did mention that when new evidence acts are introduced, we have a tendency of following old rules. From your reading of the law, I just have a question about the role of judges in examining, cross-examining, re-examining. In my reading of the Maldivian Evidence Act, it doesn't say anything about a judge's role or whether they could ask questions to witnesses to clarify points of law. I think it was our practice that judges, after we examine a witness, sometimes judges would ask questions on their own. So, from your reading, does the Maldivian law currently, as it stands, allow judges to ask questions? And if they do ask questions, then how would the process follow? Because there is a flow of things like examination, cross-examination, re-examination. The question that the judge asks might, for instance, if it's a criminal case, might favor the prosecution. So in that case, who would be then asking follow-up questions? Would it be cross-examination? Would it be re-examination? What do you think of that?
Yeah, so this issue also applies in Australia. So the Australian Act, and I think the Maldives Act is not entirely different, says all parties may question a witness unless a judge, for whatever good reason, limits that power. But it also says the judge can otherwise rule in ways consistent with the Act, and I think there's similar language in the Maldives Act, to make all sorts of orders allowing different approaches or in a courtroom. So that's been, in Australia, that was introduced to allow innovation in the courtroom. So, for example, for a witness to be allowed to narrate rather than answer questions, to act out things rather than say things and so on, to use visual signs and charts to communicate, all sorts of things like that. And so there are innovations with children where you might put them in a different setting and ask them in a different way. On the other end of the spectrum, there are things like Australia has a practice with expert witnesses of putting them, instead of having 2 expert witnesses in a civil case, 1 for each side in sequence, they get brought into the courtroom together, both given chairs, both given microphones or something, and they question each other. Right? This is not the parties questioning each other, this is the experts questioning each other. They have a conversation in front of the judge, a friendly conversation to try to reach agreement and also expose differences. It's called hot tubbing. Slightly odd name. So it's all about innovation. That's a background, of course, to the question you're asking about. Where does the judge asking questions fit into this? That kind of provision allows innovations which aren't always positive. I must say I'm not positive about a judge taking anything but a minor role in the questioning of witnesses for the reasons you've suggested. In fact, for more reasons than you've suggested. A further question is, when a judge asks a question themselves and you think it's in breach of the Evidence Act, it will be a very uncomfortable thing to object to that question and get the judge to rule on the admissibility or allowance of their own question. What if the judge asks the question in a tone that is inconsistent with the ban on improper questions? I know most judges wouldn't do that, but what if you felt that it happened? You'd be in a terrible position as lawyers, and it doesn't strike me as appropriate. In Australia, there's a further complication which doesn't apply here, which is if the judge asks questions, the jurors might feel that the judge is revealing their hand. So that's another reason to doubt this. My understanding is that the Maldives, just like Australia, is an adversarial system. The major role is given to the parties. The judge is an umpire and a decision-maker role, and it should be minimised when the judge steps out of that role. That being said, everyone understands that judges occasionally do assist by asking for clarification, and especially when the judge is the decision maker, it's kind of useful for the judge to clarify rather than leave the judge in the dark because the parties didn't ask a key question. And in any case, like I said, to introduce, I think the Act preserves the general power of a court to organise the court unless the Act otherwise provides. So I don't think the answer is in the Act. The answer is in more general ideas of fair trial and proper roles. In Australia, it would be entirely possible, and has happened, for an appeal court to rule that a trial miscarried because the judge asked too many questions. So many that their role ceased to be that of judge and became that of a party. So that would be possible in Australia, but I can't speak to whether that would be a ruling that would be made in the Maldives.
One question is, if I correctly recall, Evidence Act of Australia 135 is clause 135.
Sorry, it's...
135.
Oh, sorry, the section 135, the general discretion, yes. Let's put that up on the screen. When I get to it, let's see. Here.
Thank you for that. As you said, the clause of the subsections now not in the Maldivian Evidence Act.
Correct.
My question is, what in a fair trial, what implications would that bring to the prosecution or the defense since the clause is not there? Would you recommend reform for such things as what we
So, so part of these discretions, the bit that is about prejudice, is all about fair trial concerns. The concern is the fact finder will become irrational. And so when you have a jury system like Australia, a discretion like this is essential to a fair hearing. A judge needs to be able to intervene to protect a fair trial, and this is the mechanism to do it, as is particularly the more extreme discretions for things like prosecution evidence and prosecution tendency and coincidence evidence. You couldn't have a fair trial without it if there's a jury. And in fact, there's a ruling from the South African Constitutional Court. In some settings in South Africa, they abolished the rules of evidence entirely for things like corruption cases and organised crime cases, except for this discretion. That's the only one they kept, and the Constitutional Court said it would have been unconstitutional, but they kept this discretion. That is enough to preserve a fair trial. But that's because South Africa doesn't have a jury system, it has a lay judge system. So that's the bit that's about fair trial, but I think it is of less importance in a system like the Maldives, where the source of fairness is the judge. You're putting a lot of trust in the judge is a professional, they know the evidence they're ruling on, so if there is to be fairness, it's entirely about the capacities of the judge, not about a rule like this one. To my mind, the discretion is less important to the fair trial than to case management. And I mean case management more broadly, not just ensuring the trial doesn't run too long, though there is that, but also ensuring that the trial doesn't have other adverse effects. For example, to demean people or to embroil the court in a very difficult dispute that doesn't need resolving. So, to my mind, it doesn't go to fair hearing. In the Maldives, the protection for fair hearing in the Maldives is the judge and the appeal system. In Australia, where we have a jury trial, the protection is this discretion, and I think that's the distinction. That being said, as I did mention, the Solomon Islands, which has no jury system, and has had and partly adopted Australia's evidence law, entirely adopted these discretions, including the rule about prejudice. I can't speak to how it's gone. Last time I looked at the Solomon Islands, there weren't a huge number of cases, but they did make that choice. It's not like this provision can't sit in a system like the Maldives without a jury. And sorry, I should just mention one other thing, just because it's perhaps of interest. Australia does not have a Bill of Rights. Its constitution is about federalism and about institutional issues, but there is no Bill of Rights in Australia's constitution. It deliberately decided not to follow what it regarded as an American approach, and that means it's very unusual. So there's very little capacity, not no capacity, but very little capacity for a court to rule that Australia's evidence law is in some way contrary to rights. The trust is put in the parliaments that they would pass good laws. But that makes Australia unusual, and the other jurisdictions in the Caribbean, in the Solomon Islands, in New Zealand, to an extent, they don't have a Bill of Rights, a constitutional Bill of Rights, but they have a Bill of Rights. And Maldives, there's room for courts to second-guess the legislature's decisions, and that includes decisions about what goes into evidence law. So that's an area that could happen here, which couldn't happen in Australia. So all of my predictions about how things would go actually are a little bit subject to that particular possibility. Although, of course, we all know that the constitutional challenges aren't exactly commonplace or easy to bring. But nevertheless, that could be an issue. Perhaps also, and of course, as is appropriate, all laws are read as subject to the Constitution, and that isn't just about validity, it's also about taking into account values. In discussions with the Prosecutor General every now and then, I've looked at some provisions which allow out-of-court statements into the courtroom, even though the person isn't coming to the courtroom. And the question I've asked is this compatible with the constitutional right to confrontation? And I think that in Australia that argument simply couldn't be made. We have no right to confrontation except one given to us by the legislature, but it is an argument that I think could be made in the Maldives about some of these provisions and might affect issues of interpretation.
Credibility. In Australia, can you use witnesses' criminal records to discredit them? And if you can, to what extent can you use it? And at what part of the trial do you submit or present that as evidence?
That's an excellent question and a much discussed issue in Australia. One thing I didn't mention, which I really should have, is that in Australia, as I said, we have a tendency rule, we have a coincidence rule, we have a credibility rule. And the thing about tendency and coincidence is that there's, without any further qualification, some credibility evidence is also tendency evidence. If you have a tendency to lie, that is both tendency evidence and credibility evidence. And in the Maldives, it would have to get through the tendency rule and the credibility rule. Australia deals with this in part by saying that if evidence is only relevant to credibility, it is not governed by the tendency rule or the coincidence rule, it's governed by the credibility rule. So it shifts the issue. It says that that particular category, you're either a credibility evidence or you're tendency evidence, you cannot be both. So that partly deals with the situations, but what it means is that because the credibility rule, while it appears to be a general ban on credibility, is actually quite facilitative. It's fine to raise it in cross-examination. If an accused testifies, they expose themselves to cross-examination, including, and Australia used to have a system when an accused could give a doc statement, but that no longer is the case. They expose themselves to cross-examination, and that includes, if there's no further qualification, cross-examination on their credibility, all right, including, and so of course the temptation for the prosecution would be to say, why should we trust you? You have been convicted 3 times of theft, you're a drunk driver, and you're also a murderer. And the jury would, or in Australia, the jury would learn this information. In the Maldives, I guess the judge would learn that information. So that's always been a dilemma, and it was part of a debate that went on for a century in England and Australia. Initially, the accused was simply not allowed to testify at all, and one reason was because of this risk. But ultimately, this is the historical background, when the decision was made to allow an accused to testify in their own defence, it was agreed that there would be protections to stop this situation where merely by testifying, an accused could now have their criminal record or other past bad conduct exposed purely on the theory that it would affect their credibility. And so the idea was an accused in the Australian and English system is not treated as just like any other witness. They have special protections. The specific rule is a very policy-driven and somewhat ridiculous rule. It says that you cannot question an accused about their character. You can attack their credibility on non-character grounds, things like you've said something different in the past, but you can't say you're a bad person and you're a liar and we shouldn't trust you. A character attack on the witness, unless the defence has attacked a prosecution witness's character in the same way. So if the defence, for example, in a sexual offence trial says the complainant is a bad person, has prior convictions, whatever, something like that, then they open themselves up to a similar attack if the evidence is there. It's called the tit for tat rule, that you can respond in kind. It's a bit invidious. Defendants, as part of their defence, sometimes have to argue that someone else, a witness against them, has a bad character. It seems wrong to punish a defendant for defending themselves, but you can also see the fairness. It seems wrong for the prosecution to have to listen to a defendant attacking the character of a key witness for the prosecution while they know full well the defendant is much worse. So that's the rule, and that's how it's dealt with. It's also all subject to court discretion. That deals with that is an attempt to deal with the situation where the defendant raises character for a pretty acceptable reason. So there was a case in Australia where the defendant was accused of a sexual offence against a complainant. His fingerprint was found on her window, and he said, I can explain that fingerprint. I wasn't there for a sexual matter, I was there to buy drugs from the complainant because she sells drugs. Now, initially a judge said, well, you're attacking her character. Now they can attack your character and point out your prior convictions for theft or whatever it was. But a higher court said, no, that's too much. It's a normal thing to explain a fingerprint. It's a bit unfortunate that it happened to denigrate the complainant, but it's unfair to let that land on the accused. So that's a very complex answer multiple stage answers to the question you asked. It appears in multiple, the solution appears in multiple parts of the Evidence Act. It's in many different provisions, but that's the answer. And it combines with that other rule about good character evidence. So that is how that is dealt with in Australia. The only special rule I could see about the credibility of the accused in the Maldives, or maybe I'm missing it, is the one that allows credibility evidence about the accused to bolster the credibility of the accused. I didn't see any other special protections. But that being said, the tendency rule and the coincidence rule would apply to that evidence. They're not that strong protections, but to the extent that they do protect, they would apply to the accused as well. You make the call, Nafal, but do you want to ask a further question, or we're happy to wrap up? All right. Look, everyone, thank you so much. That is everything, and thank you for putting up with such a long discussion, often travelling across the world in various ways that might seem a bit distant. As always, and I also want to say thank you for those questions. I am just continually. I teach many students in Australia, and I wish I got such good questions from my class so consistently. Every question is so interesting and leads to so much. So thank you very much. I really enjoyed this.